morning, everyone.
Good morning.
As you know, today we were assembled here for one of the most awaited events of SICASA that we do, the Moot Court, GST and IT Tribunal. So, first of all, we are very, very thankful as students that we're getting such a platform to showcase and to experience all this, because this is not done before, and this is really from SICASA. I would like to thank all the people responsible for this. Thank you so much. Now, I would like to request Chairman Sir and Kavita Ma'am to please escort the dignitaries to the dais.
Thank you. Thank you. Thank you.
Today, for the first court, the GST tribunal, it's presided by the bench member S. Venkatramani sir. A brief intro about him. Shri S. Venkatramani sir is a chartered accountant, a graduate in science. He pursued the chartered accountancy course and qualified in the year 1988. He was in independent practice for a year prior to joining Mrs. Singhvi Devi and Oni, and he retired as a partner from Mrs. Singhvi Devi and Oni after 29 years. He is practicing in the field of indirect taxes since then and is mainly involved in indirect tax planning and representation at various levels. He is a regular speaker at various forums and has presented a number of papers on indirect taxes at the state and national level. He has co-authored a few books, one a handbook on value-added tax, the second on audit under KVAD laws, and the third a discussion paper on the key transitional issues in proposed GST regime, and a few additions of the background material under the GST laws published by ICAI. Presently, he is a member of the Fiscal Policy Institute of the Government of Karnataka, involved in structuring and designing the course curriculum for the officers of the Commercial Tax Department, and a regular faculty of the Bengaluru branch of SIC of ICAI, and a member of the Finance Advisory Committee of Karnataka State Cricket Association, and a member of the Committee to Study and Report Changes to the Karnataka Tax on Profession, Trades, Callings and Employment Act, a member of the State Advisory Committee for GST Government of Karnataka, and a member of the GST Committee of All India Federation of Tax Practitioners, and an independent director in Kirloskar Fellows Industries Limited, and chairman of the Finance Committee at the University of Transdisciplinary Health Services, Sciences and Technology. We would like to extend a warm, hearty welcome to you, sir. Thank you so much. Now, I would request all the dignitaries to light the lamp to begin this day on a positive note. I would also like to extend a warm welcome to our mentors for today, Annapurnama and T. Raghavendra sir, and Rajesh Kumar Diya sir, and Devendra sir. So, thank you so much all the mentors for taking time out of your busy schedule. Firstly, T. Raghavendra sir is a chartered accountant practicing in Bengaluru. He is a graduate in commerce from Bangalore University and he qualified as chartered accountant in the year 2003 and had worked with Mrs. Pelfrey Van Mele India Private Limited as a management trainee. His area of specialization is indirect laws of India, which includes GST, customs, central excise, VAT and service tax. He is one of the founding partners of the CA firm NNR & Co, which started in the year 2005 Bengaluru. Thank you so much, sir, for taking the time out of your busy schedule and helping all of us. Annapurna Kabra is a fellow member of the Institute of Chartered Accountants of India, and she was an article trainee of Rajkumar Henschel & Co. Gulbarga, and she's completed her DICA and DIRM course as conducted by ICI. She's contributed to the articles on VAT and GST and is a regular contributor of articles to various professional journals, including the Bangalore branch of ICI Journal, Karnataka State Chartered Accountants Association's Journal and SIRC Journal, etc. She has co-authored the book on Guide to VAT Audit and Value-Added Tax in India. She has co-authored the book on background material of indirect tax of ICI. Thank you so much, ma'am. Welcome. CA Rajesh Kumar Diya is a BCom graduate, LLB, FCA, DRCA, is a practicing chartered accountant practicing in indirect taxes since 2002. Completed schooling, graduation in CA articleship at Tumakuru and later moved to Bangalore. He is practicing in the field of indirect taxes at Bangalore for more than 20 years, conceptualizing the intricacies of businesses and laws and advising clients on compliances, tax planning and representation to government and authorities. He is a partner at Venu and Vinay Chartered Accountants and a proprietor of RKTR & Co. Chartered Accountants. We extend a warm welcome to you, sir. CA Venugopal Ji is a partner in Mrs. Venu and Vinay Chartered Accountants, qualified in the year 2002 for securing All India 45th rank. He is also a certified information security auditor. He has also completed various other certification courses from ICI, namely TICA, course on business valuation, course on internal audit, and course on fraud detection and forensic accounting. He has also completed a one-year course from IIM on data analysis and business intelligence. We extend a warm welcome to you, sir. Now, I would request our chairman, sir, to address the cabinet.
Most respected Venkatramani sir, dear Rajesh sir, Annapurna Kabra, Kavita, Pramod, and all the mentors and my dear students. Happy morning to you all.
Happy morning.
I welcome you all for the very unique program, Moot Code. I think this is the first time entire South India it's happening for students level. I heard because even I didn't know that this Moot Code of kind done for members or not. When I asked Annapurna madam, she said long back when it is done for members also. But it's first time it's happening for students. You are all, I feel, I think you are lucky because to have this kind of program. Even very less conducted for members, but it has been introduced, and best of the best faculties are mentored you. You are so lucky because during our articleship period also we not had this kind of program. Really you are lucky, and it has done so seriously. Last time 2-3 times when mentors came and preparing, I really surprised. All seniors leaving their office, full day sitting in the institute, mentoring you. Really, it's a great. I hats off to all the mentors for time and effort in sharing their knowledge. They dedicated and they wanted to make it happen in how it real time it will happen. Same, a similar thing they have done. They have mentored. Hope it will be helpful. Even when you qualify, if you choose a practice, definitely it will be a great, helpful and knowledgeable. As you said, whatever assignments or you become a speaker or you are become a resource person, you should give your 100%. You should involve not only for what you deliver, what you learn from that involvement. That should be your motto wherever, not only for this program, any other program. Anyway, once again I welcome you all for this program. Once again I thank Venkatramani sir, even in his very busy schedule, and all the mentors, they are mentoring our students. Really we are lucky. Once again I thank on behalf of Bangalore branch of ICA. Thank you.
Thank you, sir. Now I request our SICASA chairperson Kavita Parmeshwar to address the gathering.
Good morning, everyone. We are running behind the schedule by almost 15 minutes, so I'll not take much of your time, and we'll strictly move on to the proceedings. But just that, chartered accountants, why this Moot court concept came in. Chartered accountants are so talented, but there are certain things that the fine-tuning of the skills to small extent is missing. And this is one of the efforts to see that we fine-tune our representative skills, and that should start from the student days rather than starting once we get into practice or something. And that's why SICASA thought of doing this, something like this. While when I approached all the mentors, whether it is IT or GST, all of them and the bench members and other people who are involved, like CA Kuber is there, Siddesh, all these people were so helpful, and that gave me the confidence, yes, we can do it. And they were so perfect in everything, were planning this entire schedule. So I am so much grateful to each one of them, the bench members and also the mentors who have given their time and taken so much effort in training all of you and also guiding you correctly the way it has to be done. So I hope all of you will take the benefit, and people who have not participated or the students who have not got the chance to participate, they will learn from this experience. We'll have the video recording, we'll put it up on the YouTube and other places. So people will at least get, and we will try to do this often so that there are more and more people trained. And wishing you all the best. Please follow all the tips and all the guidelines which have been given to you for today strictly, and you will learn. Doesn't matter if you forget something or if you don't argue. All of us learn from our mistakes and experience. So you will. This is only our first experience. So do well, give your best, all the best. Thank you all. Thank you.
Thank you, ma'am. I would request S. Venkatrami sir to give few tips to all the students.
Chairman ICI, Madam Kavita, Annapurna, Lieutenant Rajesh, Master this year, Kuber, to each one of you sitting here. I thought I will reserve my tips after the session is done, but she told me to give them. Let me give you a few suggestions. But what happens there when you stand at the bench, time will tell its own story. Three things. Remember this. One, don't go beyond fact. Facts will make or break your decision. That is rule one. Rule two, don't try to mislead or confuse. It's not going to work. That is rule two. Rule three, don't be in a hurry to exhaust yourself. You should go step by step, chronological order. So don't put the cart before the horse. So these three are done. On the personal front, don't get scared. The bench is also a human being. The bench has also gone through what you are likely to go through. They have all gone through it. So you are going through it now. Nothing new. 3. Don't ever think that every argument of yours will be successful. You are putting your best foot forward, defending your client. It does not mean you have to. It does not mean that you have to always win. It doesn't matter if you don't win. You always have a higher form. You always have a higher form. And as you go along, you will realize what you have missed. Cover it up. And as you gain experience, you will know what to cover up before you come to the court. Before you come to the court. Last tip. When you're out there on the streets working for your client, don't keep fee in mind. If you keep fee in mind, you're never going to be a good counselor. You're not going to be a good counselor. Fee is what comes after you finish your job. So, if you remember these few tips, I think you will go great lengths in practice. The rest of it, I will tell you after you finish your arguments. You will know, because I am going to lead you through what are the issues that are there in your parliament papers. Thank you very much. Thank you.
Thank you so much, sir. Before we move on to the proceedings of the court, I would just like to thank a few people who made this event happen. Firstly, I would like to thank the chairman of Bangalore branch, Srinivas sir. Thank you so much for supporting us for all of this and conducting this event for students especially. Thank you so much, sir. And SICASA chairperson Kavitama, who always wants to do something new to students and always wants to render something very informative to students. Thank you so much, ma'am. And I would like to thank all the bench members. Thank you so much, and all the mentors for taking time of that really hectic schedules and audit and all, and helping us with so much dedication and efforts. More than us, they are more involved in it. Thank you so much, everyone. And I would like to thank the SICASA member committee for organizing the event like always. And I would like to also thank the branch staff of the Bangalore branch of ICI for putting up such a nice setup and everything. Thank you so much, sir. Thank you. And lastly, I would thank all of you for having the courage to do this and to trying something new out of your articleship and all of that. Thank you so much, everyone. Without further ado, let's move on to the court proceedings.
Thank you.
While the stage has been set up, I would like to brief you about the rules of the Moot court just once again. I would like to brush them up. Rules for the Moot Tribunal competition. The Moot Tribunal is for income tax and GST, and the objective of this competition is to improve the representative skills of the students. Language of the proceedings will be in English only. Bench, the students will have to present their case to a single bench member. Students are required to present their case orally and no presentations such as PPT or computers are allowed. However, they are permitted to use the hard copy of the Bail Act, case laws, and even provide the copies of reference material to the bench. There will be only one round and each team will have 2 students. Students can argue for and against the SC or the dealer. And there will be 4 matters, each for argument under income tax and GST. And students will be provided with the decided cases for arguments, and they will have to prepare the arguments based on the precedent available. And the students will be guided and mentored by a team of expert chartered accountants. And the students have to present the case within the time allotted. The time allotted is 15 plus 5 minutes. I repeat, 15 plus 5 minutes for each team. And only one student is allowed to argue at a time. Both the team members can argue one after the other. Dress code: the participants of the teams must adhere to the following dress code during the Moot court competition. Male, white shirt, black trousers, black tie, black coat and black shoes. Female, white salwar and kurta or white shirt and black trousers along with the black coat and black shoes. And also a few other tips for the Moot court or team members. Prepare the summary of the case, listen to judges, your opponent attentively, and do not interrupt when the judge is talking among each other unless required. While submitting, you can refer to the point of the page number and relevant page and para number of your appeal document. Remain organized in the podium and follow the time schedule given by the ICI. And don't be afraid of anything when you're presenting the case. Be confident in your presentation. I wish all of you a very all the best. And we would start with proceedings. And I request all of you to stand up when the bench member enters. Bench judges. Thank you so much.
Appeal number CCC 10,001/2022 SM Tours and Travels.
Ready? Take your seats, we'll finish the cost list. We'll finish the cost list, please take a seat.
You read out all the cases.
What the case? Appeal number CCC.
One. Can I have Mr. Rajesh and Kuber as 2 amicuses versus the court? Something like that. I think Rajesh will go for the respondent, Kuber will go for the appellant. Amicus, can request you to take your positions. An amicus is a court's friend, he will assist the court and nothing more. Go to the next one.
Appeal number CCC 10,001/2022 SM Tours and Travels. CCC 10,002/2022 Commissioner of the Commercial Tax, Karnataka Bengaluru. Third one is CCC.
Yourselves ready for still number 2? Ready? Yeah.
CCC 10,003/2022 Assistant Commissioner of Central Tax.
Ready?
Yes, sir.
Serial number 1 CCC 10,001/2022 SM Tours and Travels. Martika.
This is Sakil.
We are here to represent SM Tours and Travels, the appellant, against the order GST.AP-122/2122 dated 21st March 2020. I would like to present the statement of facts of the case with your permission. The appellant, SM Tours and Travels, having the registered address mentioned in the page number 6 of the point number 1, are engaged in the business of traveling services. And the appellant received a notice for
The appellant was received a notice for return default under section 46 for not filing a return for the tax period July to September 2021 and request to furnish the further within 15 days. Sorry, sir. The SM Tours and Travels are engaged in the business of providing traveling services. The appellant was received the notice under section 46 for not filing the return period July to September 2021-22 and request to furnish the return within 15 days. But the appellant did not file the return within the due date because the accountant who was handling the GST compliances was suffering from the cancer and had died. Further, under section 62 of subsection 1 CGST Act 2017, the appellant has been issued ASMT 13 dated 11th November 2021 and the appellant has been asked to pay the tax along with the interest as mentioned in the paragraph 4 of the statement of facts, page number 6. And the bank account of the appellant has been freezed to the extent of the amount mentioned in ASMT 13. The appellant already submitted their outward taxable value for the quarter ending September 2021 and GST on the same has been paid to the extent of the amount mentioned in the page number 6 of the para number 5. GST TV for the quarter ending September 2021 has been filed. The tax along with the interest has been discharged. And the copy of the form GST/PB is already submitted before the first appeal authority. Appellant could bring to notice that they never received a copy of the order from ASMT 13 from the department. It was only after when bank then was freezing the bank account of the appellant they came to know that the department had been issued ASMT 13. And appellant already submitted all the necessary documents during the appeal stage and discharged all the liabilities as the order given under section 62 of subsection 1 after CGST Act 2007 date in form ASMT 13. This is the statement of the facts of the case.
Madam Counsel, pursuant to notice under section 46, did the appellant file his return within the stipulated due date?
No, sir.
In terms of section 62,
Yes, sir.
did he file? Did he not file?
Within the due date, he is not right.
Not within the due. Pursuant to notice issued under 46, was the return validly filed?
No.
So you have not yet filed the return.
We have been filed, sir, but not within the time limit given by the department.
So you didn't fall in line with section 46 or section 62.
Yes, sir.
Because just look at documents to see whether returns were filed, if yes, when, rates are not forthcoming.
Can I proceed? Yeah.
They have filed the return and they have a submission.
I would like to bring to your notice, in the appeal state, the appellant submits that their output taxable supply for the quarter ending September 2021 is 29,25,675, and on the GST on the same is 1,46,072. IGST rupees 1,44,134 and CGST 916.9.15 and SGST 969.15. 3B GST 3B for the quarter ending September 2021 has been filed on 3rd January 2022. Tax along the
July to September quarter,
yes sir.
you filed the return
In the
at the
month of
appeal
January.
stage. At the appeal stage,
Yes sir.
not pursuant to section 46.
Yes, sir, we was not aware of the ASMT 13. We haven't received that notice until the bank account has been freezed. We are not aware. When we reached the department with respect to that, then we got to notice that ASMT 13 has been issued. So,
I would request you to allow Mr. Saikiran to further continuation of this.
with your permission, my lord, from the above statements of fact, it is very clear the order was issued to pay tax of 93,359 along with interest, and the same has been discharged and submitted the relevant documents in the appeal state for the notice issued under section 62 subsection 1 of the CGST Act in form ASMT 13 dated 11th November 2021. Further, I would request you to refer page number 41 of order in appeal, para 6, where the officer has made an attempt to address the matter which was not mentioned in the show cause notice dated 11th November 2021. Hence, the order passed by the officer to the extent of said matter in the page 48, para 2, 3, 4 of order in original is erroneous. Further, the officer goes on to evaluate the nature of business based on the facts available with him and provide his interpretation without giving to appellant an opportunity of being heard, and thereby violating the principles of natural justice. Further, it is well-known principle that adjudication should not go beyond the show cause notice. Department to adjudicate only on the issue mentioned in the show cause notice. Department cannot go beyond what is mentioned in the show cause notice and adjudicate an issue which is not a subject matter of show cause notice. Clearly, it has given in the order GST Appeal 04, order was issued under section 107 subsection 11 of the CGST Act 2017. With your permission, I would like to read out the section.
Just look at the proceeding sheets of the FA, learned FA, and see whether an opportunity was granted or not immediately.
Yes, my lord.
Can you assist, please? Opportunity given.
Paragraph 2 of the order of the appellate authority says that an opportunity was given. It says in response to the notice issued, the ANR of the appellate appeared before the appellate authority and argued the case has been presented the grounds of appeal and requested to allow the appeal.
The opportunity of head is given in respect to ASMT 13.
But opportunity to even raise fresh issues before the learned by the FA is permissible.
So without giving without expressing our
At the time of hearing, he would have given.
no sir, told sir, directly they have issued an order. The GST Appeal 05.
I understand. But the learned FA would have given you an opportunity when you appeared before him in stating that he is going to dissolve input tax credit and charge tax at the higher rate on output tax.
So based upon the show cause notice,
No requirement for show cause notice when you are appearing in person.
so the one which we appear in appeal is with respect to A7030.
That's not better. At appeal stage, I can take up issues to enhance the order passed by the lower authority.
Sir, can I read out section 107, subsection 11?
I'm aware, but you can proceed.
Yeah. The appellate authority shall, after making such further inquiry as may be necessary, pass such order as it thinks just and proper, conforming, modifying, or annulling the decision or order appealed against, but shall not refer the case back to the adjudicating authority that passed the said decision or order. Provided that an order enhancing any fee or penalty or fine in lieu of confiscation or confiscation goods of greater value or reducing the amount of refund or input tax credit shall not be passed unless the appellant has given a reasonable opportunity of showing cause against a proposed order. Provided further, where the appellant authority is of the opinion that any tax has not been paid or short paid or erroneously refunded where input tax credit has been wrongly availed or utilized, no order requiring the appellant to pay such tax or input tax credit shall be passed unless the appellant is given notice to show cause against a proposed order, and the order is passed within the time limit specified under section 73 or section 74 of the CGST Act 2017.
So I am saying the learned FA has given you an opportunity when you
So
appeared before
opportunity
him.
is given with respect to A7030. That is, they haven't raised any order, like any point. Straight away they have raised the order with respect to the facts available with them. So as per the above mentioned provision, the officer has no jurisdiction to give direction to the adjudicating authority for raising a demand on the matter so identified in the order 48, page number 48 in the order in original, wherein the said order it is clearly seen that officer has provided direction in point number 3 and point number 4 of the order to the adjudicating authority by stating the revised demand shall be issued accordingly, and has directed the respondent to reform claim of input tax along with the applicable penalty and interest as provided under KGST or CGST Act 2017 after due verification of input tax claim in GSTR 3B filed for the above said financial years 2018 to 19, 19 to 20, 20 to 21 and 21 to 22 till 31st of December 2021. So it is clearly evident that in section 107 subsection 11, the order should be passed within the time limit specified under section 73 or section 74 of the CGST Act 2017. With your permission, I would like to read out section 73 and section 74 of the CGST Act. In grounds of appeal, para number 6, which states section 73, determination of tax not paid or short paid or erroneously refund or input tax credit wrongly availed or utilized for any reason other than fraud or any willful misstatement or suppression of facts, where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded where input tax credit has been wrongly availed or utilized for any reason other than the reason of fraud or any willful misstatement or suppression of facts to evade tax, he shall on the person chargeable with tax which has not been so paid or which has been short paid, to whom the refund has erroneously been made or who has wrongly availed or utilized input tax credit, requiring him to show cause as to why he should not pay the amount specified in the notice along with the interest payable thereon under section 50 and penalty leviable under the provision of this act or the rules made under. Further, the proper officer shall issue a notice under subsection 1 at least 3 months prior to the limit specified in subsection 10 for issuance of order. This is with respect to section 73. In the order issued by the department, page number 48, para number 4, they have issued the order under section 74. With your permission, now I would like to read the section 74. Determination of tax not paid or short paid or erroneously refunded or input tax credit wrongly evaded or utilized by person of fraud or any willful misstatement or suppression of facts where it appears to the proper officer that any tax has not been paid or short paid or erroneously refunded or where input tax rate has been wrongly evaded or utilized by the reason of fraud or any willful misstatement.
Please read para 4 at page 48.
Para 4.
Page 48.
The respondent directed to verify output tax liability.
So what has the learned FAA done?
Sir,
What has the learned FAA done? FAA is first applied authority. What has the first applied?
so they have directed the
What is the difficulty? Sir, what is the difficulty? What is the difficulty? He directed the.
yes, sir, they should give the opportunity, sir. He is directing to pass the order.
Please read.
Yes, sir.
Please read. Read
Sir,
something part of para
yeah.
4.
Sir, the respondent directed to verify output tax liability.
Directed to verify. What is your difficulty?
Sir, I'm not. Sir, further there
What
is
is your difficulty?
yeah.
He is directing the AA to verify. What is your difficulty?
I don't have
What are
any
you agreed
objection
about?
with respect to this, but further they have issues.
No, what are you agreed about? He is directing him to verify. Go before him. Go before him.
Yes, sir. But further he is stating to
Where
pass
is
an
he
order.
saying? What is
Sir, in the point number, like the, sir, I will continue the line. Can I continue?
Please.
Yeah. The respondent directed to verify output tax liability on supply of passenger of transport services, which covered under entry number 8, section 2, 7 of notification 11/2017, central tax rate dated 28/6/2017.
Mr. Counsel, what is the learned FA saying? He is directing the AA to say, please verify whether it is covered under this notification. Why have you come to the tribunal? Go there and place your objections, if any.
So,
Go there.
but he is directed to pass an order, sir.
Please read further. What is he saying?
The respondent directed to pass order as input tax rate wrongly evaded.
After verifying, he is telling you first verify, then you pass an order. What is the difficulty? Go and place your objections. Why have you come all the way to the tribunal?
So without giving any opportunity there.
Your opportunity is there, your opportunity is not here.
Sir, I have mentioned in section 107 subsection 11 where the appellate authority shall, after making such inquiry as may be necessary, pass such order as it thinks
So
just.
you are not agreed by para 4?
Sir, I am agreed, sir, but it shall not refer the case back to the.
What part of para 4 are you agreed?
Sir, they are directed. I will accept with that.
Directing to verify. Go and
But
produce
he has
your
no authority to
documents.
refer the case back to the adjudicating authority that passed the said decision or order.
So this court will deal with that. Don't worry about it. This court will deal with that.
Yes,
What
sir.
is your grievance if you go back to the AA?
Sir, there is nothing.
So you are all right to go back to the AA?
Yes, sir. If they have.
So you are not agreed by the.
Sir, if they have given the proper procedure, they didn't, as per the act, they
The court
didn't.
will deal with that. Don't worry about it. Court
Yeah.
will deal with that. Don't worry about that.
And sir, actually the order was issued for ASMD 30. So, which we have already discharged the liability. And even the department has further passed in the order the levy of tax and interest by the respondent for the month of September 2021 void ASMD 13 dated 11th November 2021 he is hereby set aside.
Can you go back to APL 5?
Yes, sir.
Please enlighten this court.
So,
What
we are
is your
discussing.
disputed tax?
Sir, order beyond jurisdiction.
Where is your disputed tax in APL 5?
Sir, disputed tax.
Amicus, can you please assist the counsel? Where is the tax? What are you agreed about? What is the value?
So further, I would like to explain further, sir. In the further point, I will explain.
Can you point out
Sir,
what is your tax amount that is in dispute?
Sir,
What rate have you paid?
sir,
What
we have
are
paid
you-
under 5%, sir, and we are liable to pay under 5%.
So can you please tell me how is that 5,62,000 computed?
Sir, because they issued, sir, actually they have not quantified the amount in the order.
Then
Because
how did
order
you
was,
quantify?
they haven't still
How
issued
did
the
you
order.
quantify?
Sir,
How did you quantify?
based upon the guidance.
So So there is no quantification.
Yeah, there is no
If there is no quantification, there should not be a demand.
Yeah.
If there is no demand, you have no business to come to the tribunal. Yes or no?
But they're pointing out.
He's telling the assisting authority to verify.
So, but you don't
Place
have the
your
authority
grounds
to-
there. Place your grounds there. So you have only one issue or any more issues?
So the order itself is not
Have
valid.
you only one issue?
No,
or
sir.
any
We
more?
have further. Like first one is order beyond the jurisdiction, and next one demand of
Please
this.
demonstrate what is beyond the jurisdiction.
So the show cause notice was issued for Assembly 13.
How does that matter? That's a procedural lapse. That's a procedural lapse. Don't come before this court for procedural lapses. Court will handle that. Don't do it. Next.
So as per section 73 and section 74, for issue of notice, you have for issue of an order. You have-
AA will follow the due procedure. You don't worry about
But
it.
he's directing the
Place
to pass an order, sir.
You
Directly.
place your objection.
Sir,
Very good.
I'm requesting the order itself is not valid.
So what is beyond the jurisdiction? Can you demonstrate to this court what is beyond the jurisdiction of the learned FAA?
Yes, sir.
Where has he gone beyond the position of law that is entitled?
Yes, sir. Which is mentioned in section 74, sir.
On one hand, you are saying amicus, can you please educate the council? On one hand, the council says there is no order. On the other hand, he said.
Sir, if you want to
I
issue-
didn't know.
For issue an order, they have to follow certain rules.
So where is the, which is the order you are agreed about? There is no order.
Sir, we are agreed only with respect to Assembly 13, sir.
Then why are you saying it is beyond the jurisdiction of the learned
Sir.
FAA?
So no, sir. I have clearly mentioned the paras which mentioned under 48, page number 48, section para 2, 3, 4. Only these are.
So you are saying that input tax credit is an issue,
Yes, sir.
which is para 2 of page 48.
Yes, sir.
Please look at para 2 of page 48. Can you please trace that dispute to your APL file? Your 93,000 and odd.
Yes, sir.
Can you please trace that to
Sir,
APL file?
93,000 is a Assembly 13 amount.
But where is that in APL file? That is your gross. It is not
Sir,
there
it
in
was already,
APL file.
the department itself is keeping asset.
So you are not agreed by it.
We are agreed to that, sir.
Where is it? Where is that in APL file? I am not able to see it. Amicus, can you please? Where is that in APL file?
So which was already submitted in the appeal stage, sir.
Where is it before the tribunal? This bench cannot consider something which is not there before it.
My lord, because the learned counsel says that ASFT 13 order, they are not challenging that order before this bench.
Because I want the appellants to trace para 2, which is what they are disputing, that input tax credit has been disallowed. Where is it reflected in APL 5? I am not able to see it. So this forum or this tribunal cannot consider something which is not before it. It's not before it.
You are challenging this paragraph. Where have you produced grounds to this paragraph? What is your dispute intent? Can you please explain to me? My lord,
Appellants will submit. Appellants will submit.
So we are liable to pay tax at 5%.
So how did you arrive at 562?
So 562, which sir, our tax
What rate is it?
18%.
Are you disputing 18 or are you disputing 13?
So
Because 5 is what you agree.
yeah, we are agreed.
So why are you disputing 18?
So, because they are ordered to pay tax at 18%.
You are not agreed on payment of 5.
Yes.
Why are you
Sir,
disputing 18?
we are up. 5% is applicable for us, sir. 18%.
5 is undisputed.
Yes, sir. But
Why are you disputing 18 here?
sir, in the order which they have mentioned, sir, 1 minute.
Mr. Counsel, I completely understand. There are two grounds that you are aggrieved about. One, denial of input tax credit to the extent of 93,000 or 92,000.
Yes, sir.
Come
91,000.
again?
Sir,
Come again? What is the number?
91,000, sir. ITC.
Please look at your appeal grounds. I think the numbers were different. What is there in para 2 vis-a-vis what is there in the facts and grounds or
Sir, input
different
tax
numbers?
credit 91,299.
What is there in para 4? Para 2, page 48.
So para 2 talks about 18%, sir, not about the input tax rate.
Para 3 rather.
Yeah, para 3 talks about the input tax rate,
What is the number?
91,299.
91. So what is it there in the grounds?
So which is 5,26,621.
So how do you link to the both? How do you link the two?
So which is the taxable value? Like on 29,25,000.
Mr. Counsel, don't get confused. There are two issues, as I understand.
So there are
One
three-
issue relating to rejection of input tax credit, which is a 91,293 or 299 or whatever the
299.
number is.
Yes.
Second one is rate of tax on the services rendered,
Yeah.
which ought to be at 5% according to you. But the learned FA has directed the AA, Housing Authority, to compute or recompute or
At 18%.
verify your books and thereafter levy tax at the applicable rate at 18%. Am I right? So what is your disputed tax traceable to APL 5?
So it's 18%, on 18% we have calculated.
All right, you calculated at 18%.
Yes, sir.
Can you go to para 14B, column 14B of APL 5?
Yes, sir.
Please read.
Pre-deposits of 10.
Huh?
14 of
Huh? You are before the tribunal.
Yeah. Details 10% of the disputed.
Amicus, can you please assist the counsel with the relevant part of the statute book?
Para 14
B,
AB.
14AB.
14 A B.
Can you please read what is that?
So details of payment.
Read the statute.
14 A B.
What does it say? Read.
Yes.
Pre-deposits 20% of disputed tax.
Where is it paid? How does this appeal? It does not go beyond the admission stage. Mr. Counsel, can you please read the footnote to that provision? Can you please read the
So
footnote?
substituted 20% of disputed tax by the
So,
central.
so what is the statute saying? The statute saying it is substituting clause B with whatever is there currently. Substitution goes back to the date of the form. So you have to pay 20%. Because the court is figuring out whether that 20% payment is effectively made or not made, and April 5 going to input tax credit, what is the payment to be done? It is not there in the appropriate column. Quickly, court is running out of time, counsel. In the meanwhile, you can figure out it.
My lord, the appellant has paid 10% of pre-deposit.
So, the appeal does not travel beyond the admission stage. Do you have anything more to say?
So
My lord,
Anything more?
my lord, we will pay the differential 10% and
Counsel will argue, amicus cannot argue.
So we are requesting you to allow for a period of time so that we pay the 10% along with us.
Amicus, can you just check with the registry, why did they not issue the defect memo? What is wrong with the registry?
I think, Lord, sir, as I understand
Has
that
the registry not done its work?
they have gone with the form, they mentioned 10% and not looking into the substitution clause.
So is the council saying that the appellant is unaware of the amended forms?
The registry is not.
Council unaware of the amended forms? Is that what the council saying?
Yes.
Huh?
It appears like that, my lords.
But that doesn't take away.
Take away,
the
yeah.
statutes. So why did the registry not do its work? One of the amicus check and quickly tell why the registry has not done its work. Why was it not brought out as a defect memo? Was the defect memo served on the appellant or not served on the appellant? And if yes, when, how?
I think on the records, they have simply admitted based on the 10% without further going into the.
Okay, you have anything else to say?
Sir, we are not going into further appeal.
Let's start the issue before
So
this trial.
if you want to go for an appeal, we need to deposit the respective 20% of
You
your
have come
tax.
before this tribunal.
Yeah.
You
Sir,
have come in an appeal before the tribunal. You have disputed 5,26,000 and 92,000. 92,000 does not find a place in APL 5. Our request statute requires you to pay 20% of the disputed tax, 10 plus 10, and come before this honorable tribunal. Even giving you the benefit of doubt that 5% is what you have remitted at the lower court level. The lower court level. And if your dispute is going to be 13% of 29 lakhs, it roughly works out to something like 3,60,000, 3,70,000 and odd, of which 75,000 or 20% you ought to have been remitted. It appears that you have remitted only 52,000, which is 10%. And input tax credit, I don't find it as part of APL 5. We have heard it. State.
As my friend said, that there are revision on cost of ITC and rate of tax mentioned in the budget. Suppose as I have said, the respondent would like to repeat the report. As per the section 117 subsection 2, it's mentioned further inquiry. So as per the respondent, being a responsible officer, representing the government, would like to protect the interest of government. So we have done further inquiry and we have asked our law authority to do verification on the same. So we would like to say that this order is not beyond the jurisdiction.
So you are saying you can conclude an order under 107 according to your whims and fancies.
No, sir. If I had asked an order in favor that they have filed guilty and closed the case, if any scrutiny of return was done for that guilty, they will close that case as it was already verified by the higher authority.
So what is the situation now?
Now I have,
Council says pursuant to 46, no return was filed. No return was filed pursuant to 46. So what is the grievance? So you have to confirm under section 62. You cannot travel beyond that. You can't issue a show cause notice. So what is the grievance that you have? What are you aggrieved about?
so we have to say that the order is not beyond the jurisdiction. The order passed by court.
Which means you are now saying when you enhance an order, you need not issue a show cause, no requirement to issue a show cause, no need to provide an opportunity to the appellant.
Opportunity was
Where is that opportunity? Can you demonstrate to this court where is that opportunity that was given by the learned FAA?
order in affidavit.
Mr. Amicus, who's running out of time quickly.
Because as is being told by them, it is not actually coming out in the order, the exact dates of the hearing.
Respondents can look at proceeding sheets and the counsels for the appellant say that they were provided an opportunity of being heard, so the proceeding sheet can be quickly looked into and can be pointed out whether any indication was given to the appellant that there is going to be a likely enhancement, and if yes, what? Was something being communicated to the appellant? The court will look at the records, lower court records will be seen at an appropriate time, can be.
Paragraph 5 of the order, yes, note of the fact of they explaining about the offer supply and details, etc. That means that discussion during the hearing is as
Paragraph
happened.
5 of
The order, page
at
number,
page,
page 34.
page 34. Page 34. Page?
34.
Oh, go ahead, please read. Please read.
In the appeal stage, the appellant submits that their outward taxable value for quarter ending September 2021 is 29,25,675 and GST on the same is rupees 1,46,074. GST preview for the quarter ending September 2021 has been filed on 1st Jan 2021. Tax along with interest has been discharged. The appellant has filed a copy of the form GST file and requested to unfreeze the amount and set aside in one order dated 11th November 2021.
All right.
On further verification of the records, it's revealed that the appellant has obtained the registration as tour operator. On observing the sample invoices filed by the appellant,
Now we will come to the nature of business separately. Have you not intimated the appellant about the possibility of an enhancement? If yes, let me know. If no, court will look into records. Don't waste your time.
yes, we have communicated, that's why this discussion has been.
All right. Have you got anything to say? Please go to APL 5. Please go to APL 5. Please go to APL 5. You go to column 6. APL 5. APL 5. Please go to serial number 6. Please go to serial number 6. What is the date that's mentioned there? Little louder, can I hear?
October 20.
What is the date on which you filed the appeal? Please go to the verification. Please go to verification. Page 5 of the appeal paper book. Page 5.
Page 5 is 5 is by 11. There are 7.
Go to page 5. What is the date? Do you have anything to say about it? Amicus, can you please look at the appellant's APL 5 and look at the dates, please? amicus state has anything to say quickly about it? Let's hear. Has the state got anything to say about it? Court will look into it later as we pass the order, not worry.
It was a clarification.
Clerical mistake, Mr. Counsel, can appear in one place. Clerical mistake cannot appear across the papers. Clerical mistake can be to say 562 is 526. Clerical mistake cannot be to say 562 is an error. I should have taken 13%. I have taken 10%. It should actually be 20%. Output tax, input tax credit has not been. It is a clerical mistake. How many clerical mistakes can we have, Mr. Counsel? We have heard. Has the state got anything to say about seal number 8 of JPL 5? Do you have any counter to the appellant's argument beyond jurisdiction? Is it denial of ITC or recovery of ITC? What is the state's argument? Is it denial of ITC? Denial of ITC and recovery of ITC stand on completely different footing. What is your grievance? What is your grievance? He is entitled to input tax credit considering his nature of business. Eligible, ineligible, claim, avail, denial, reversal stand on completely different footing. Yes, Mr. Counsel, you have anything to say whether you are denied ITC or whether it is a recovery of ITC? Are you denied ITC?
Department has
You denied ITC? Please look at paragraph of page 48. What does the learned FIA say?
directed a long claim of input tax credit.
Please read. Please read.
The appellant
Please read line 4. Hence.
Hence, the respondent directed to recover
So it is recovery or denial?
recovers.
So you claim
Yeah, we get claim.
unavailed.
No.
And enjoyed that credit.
We
Otherwise,
have
please say you are recovery. So you claimed and enjoyed. You have availed. Correct?
We have events.
Do you have any arguments against that? Because the learned FAS order speaks something about the nature of this.
Sir, I would like to refer page 46 of order in original.
Page?
46, order in original.
Yes.
Point number 6.
Yes.
The transportation of passengers by any motor vehicle designed to carry passengers where the cost of fuel is included in the consideration charged.
Mr. Counsel, what is the difficulty? The learned FAS sent you back to the A8 for verification of record. Do you have any grievance there? You want to argue further to jeopardize your case?
So we are liable for 5%. So without knowing the facts, like without understanding the nature of business of the appellant,
The test is whether you are a tour operator or a passenger transport service. That is the grievance, right?
yes, we are liable
So
for
you are 5% without ITC or
With
you are
ITC,
18% with ITC.
with ITC.
So you are with ITC.
Yes.
In the meantime, can the state please look at page 34 of the appeal paper? Of the appeal paper, amicus, can you please look at page 34? Can you take them to page 34 of the document? This is the document, amicus. This is the document. Can you assist them in tracing out this document? Page 34. Amicus, you can take this copy. Madam, can you give this document? Amicus, can you go to page 34?
Yes, my lord.
Can you assist this court as to what is that document?
The power of attorney
Under which law? Under which law?
supposed to be under the GST.
So is the state authorized suitable notification issued by Commissioner? Similarly, on the appellant side, under which law, Amicus, can you please assist the counsel?
This is the authorization of the appellant
Appellant under which law?
under the CGST Act.
Please read it. Amicus can't go wrong. Amicus is court's friend.
The authorization is a
Have you got anything? Has the appellant got, respondent got anything to talk about this? Nothing? Nothing?
My responsibility to submit that clarification.
We will give them an opportunity to file. We will give them an opportunity to file.
That our land fund is not authorized to enter behalf of the appellant.
Amicus, can go to page 33 of the paper book. Page 33 of the paper book.
Yes, madam.
Amicus, can you guide the appellants about what is the title? What is the title to that document? Title.
Before the appellant authority of
What?
commercial taxes of its file.
Amicus, can you please guide them the errors there? Can you please guide the appellant?
This is a part of the appeal paper book sheet it has come here. Of the before the FAA appeal paper book authorization.
So even FAA was wrong.
Then after the
So Amicus, you are saying state is so irresponsible that it doesn't look at any of these papers. It just comes before this honorable tribunal, and the tribunal has to look at every single paper that comes before it. Has the state got anything to say about the appellant's argument on page number 6 on statement of facts? Page number 6, statement of facts. Page number 6. Page number 6, para 6. Para 6. What is the state's position on that? What is the state's position? Amicus, can we guide the state on 169, please? On section 169. What does 169 say? $169.
Yes,
Mr.
yes, Your
Counsel.
Honor. Yes, Your Honor.
Can you quickly guide? Go to the absolute
Yes, Your
out
Honor.
of time.
Yes. 160.
Quickly run through 169. Look at your para 6 on page 6. What is your defense?
So,
So the notice issued by the department, the ASMT 30, which there is no order number. They didn't follow the.
Court will look at that. Have you got anything to say about 169, please?
So we haven't received any physical copies.
169. Be on 169. One minute. Let them finish the.
So I would like to refer page number 40 of order in appeal. Para D.
Order in appeal,
Order in original.
Yes,
D. Improper order.
yes.
During the appeal stage, we have mentioned order has not been issued as per the format specified in Form ASMD 3010 and it does not specify order number and notice reference number. The reference of the same
Those are procedural errors, the state will rectify that.
order is also not appearing in the GST portal.
Can we look at 169? It is not appearing on the GST portal, yes, state. Was it not uploaded? Was the notice not issued electronically, served electronically, or through means of any other modes permitted under law to be electronically transmitted to the appellant?
Transmitted to email, but due to non-updation of the current email, they haven't received the email.
So you don't have any grievance, so you admit that you did not have the right email ID and therefore the appellant is right in saying it was not uploaded in the portal.
Appellant hasn't updated the email in this.
So what is the difficult? So you did not even go and figure out whether the email ID was right when you went through two personal hearings, right? Pursuant to 46 and pursuant to the appeal under 107. So you did not go and look at it.
I would like to refer to section 169 subsection 3C. By sending communication to his email address provided at the time of registration or as amended from time to time.
This state we understand it would have bounced back. The email would have bounced back. So what is the corrective action that the state took? We did nothing under the provisions of 22 to 26 thereafter. We did nothing. All right, we understand. I think any counter to the state's arguments before we quickly close?
Yes, sir.
We have heard you. We have heard both your grounds.
Sir, in memorandum of, sir, they have mentioned Jude Corporation of India versus Income Tax Commissioner.
What's
Case plus.
yes?
So based upon this
Page
case,
number. Page number.
sir, page number 43,
Page number 43 of
sir, order in original,
yes,
para number 8.
yes.
The Honorable Supreme Court held in the following case that appellate authority can also deal with a matter which is not a subject matter of appeal.
Yes.
Where Honorable Supreme Court held in case of Jude Corporation of India Limited versus Commissioner of Income Tax. Sir, it is clearly held that I would like to submit the judgment copy in front of you, where in the first page of the judgment, it is clearly mentioned the appeal before appeal late commissioner, additional grounds was raised by assessee, which was not raised by the income tax officer. So, but in this case, the additional grounds was raised by appellate authority, not by the assessee. So, this case which they have mentioned in the order, which is irrelevant to the above provision. As per the
Can we borrow that ratio? Can we borrow that ratio? State will say we will borrow the ratio.
sir, no sir, 1 minute. Yeah, before producing the report, I would like to mention some points before, like power of commissioner appeals.
You have 3 minutes to conclude your argument.
Yeah. So the legislature has conferred very wide powers upon the appellate commissioner once an appeal is preferred to him by the assessee. So I would like to submit.
Kindly furnish a copy to the state, please.
So I would like to refer the limitations of the power of commissioner. So it is clearly stated, it is the only assessee who has a right conferred upon him to prefer an appeal against the order of assessment passed by the AO. If the assessee does not choose to appeal, the order of assessment becomes the final subject to any power of revision that the Commissioner might have under Section 263 of Income Tax Act. So, which state that in the case of Jude versus Income Tax Officer, the assessee has raised the additional grounds, which was accepted by the Appellate Commissioner. But in this case, without giving opportunity of being heard, the Appellate Authority, the officer has directed the respondent to pass an order, so which is completely irrelevant. So here the Appellate Authority does not have any power to raise additional grounds without providing opportunity of being heard, which is danger of principle of natural justice.
The state says that an opportunity was granted and those are recorded in the proceeding sheets, etc. While the counsel here says that the appellate was not provided adequate opportunity, there are two issues. Court will take cognizance of the records. We will carefully marshal the facts before us. We will take it. The counter to you have 3 minutes to conclude your arguments. So your argument is you will make the assessee sit in front of you in your appeal chambers. You will tell him orally that I will deny you the input tax credit, recover the input tax credit, change its nature of business, right? Change its nature of business and apply different rates of tax. And that is an opportunity of being heard.
Opportunity being heard was given and books were verified.
An opportunity of being heard under law is that an opportunity should be granted that meets the ends of justice. We have heard anything else? The counsel we have closed the argument. You have anything else to counter? Because if you argue something more, I'll have to give them a chance to counter it. Anything other than what you have said and what is not there in the grounds of appeal? Anything more?
I would like to mention the
I mean,
support-
just can we quickly check whether it is part of the relevant or not?
So this is an additional document what they are submitting, additional.
Is it additional document, additional evidence?
Evidence.
Was it not before the lower court? Was it or was it not before the lower court?
It appears that it was not before.
Can the state quickly look at it and see, amicus can quickly, was it part of the lower court records? If it is there, the record should be available. Let's not wait the court's time.
Because these financial statements are not a part of the documents appearing on the
What is the grievance so far as the financial documents are concerned? Do you have any objection?
no objections to it.
State has no objection to the financial documents.
Because obviously they should be verified before then.
So the state has no objection to it. So I can take that on record. Can I take it on record? It could go against you. It could be different. Nature of business could be different. Notes to accounts could say something else. Have you got any grievance quickly? No? Can take it on record?
So I would like to
No more.
express.
No more. No more. You have adequate opportunities. No more. No more. No more.
Next case, appeal number CCC 10,002/2022, Commissioner of the Commercial Tax, Karnataka, Bengaluru.
Amicus, can I request you to assist this as well? So the state has come up in appeal. State. They are ready?
Your Honor, the counsel is appearing before the Honorable Appellate Tribunal in the case of the Commissioner of Commercial Tax versus Messrs. AMC Private Limited on behalf of the appellate, the Commissioner of Commercial Tax under state jurisdiction. Aggrieved by the order passed by the first appellate authority, by order number GST bar 80 bar XX bar 2021, this appeal has been filed before the appellate tribunal. The crux of the appeal is that failure to update vehicle number in Part B of the e-way bill attracts penal consequences under Section 129 subsection 1 of the CGST Act or KGST Act 2017. Before proceeding to the fact of the case, I would like to highlight the key matters that will be addressed in the present appeal in the course of the arguments. Firstly, whether failure to update Part B of the e-way bill has rendered the e-way bill invalid, and consequently whether the order for providing relief of penalty by the first appellate authority is justifiable. Lastly, whether the respondent was liable to generate a new e-way bill on initiating branch transfer. I wish to seek permission of the bench to proceed with the facts of the case. A goods conveyance of the respondent in the course of its movement from Bangalore to Mysore was intercepted by the commercial tax officer, Vigilance. On verification of the tender documents, it was observed that there is a mismatch in the vehicle number in Part B of one of the e-way bills as compared to the vehicle number of the conveyance. On further inspection, it was understood that the respondent has a registered office in Bangalore and an additional place of business in Mysore. Initially, the respondent had requested XYZ Limited, the vendor of the respondent, to deliver certain goods to the respondent's Mysore unit. Accordingly, the vendor raised a bill to ship to invoice by citing the respondent's Bangalore unit as the bill to address and the Mysore unit as the ship to address. The said invoice has been enclosed as Annexure 2 for ease of reference. Further, the vendor also raised an e-way bill bearing number 1612-6366-4669 and cited the vehicle number as KA04D5053, which was factually correct. The same can be observed from the e-way bill enclosed in Annexure 3, page 22 of the submissions. Parallelly, the respondent had also effected outward supplies of certain goods to PQR Limited, a customer located in Mysore. And accordingly, the respondent raised a e-way bill bearing number 161263671755 and cited vehicle number as K8345745. The said e-way bill has been enclosed as Annexure 4 in page 20. In summation, there are two e-way bills in the case in hand. One e-way bill which has been raised by the vendor in respect of the movement of goods from the vendor's premise to the Bangalore unit's respondent's premise in Bangalore. The second e-way bill has been raised by the respondent to the customer located in Mysore. In order to achieve cost optimization by the way of accommodating both the consignments in the same vehicle which was being delivered to, which was moving to Mysore, the respondent intimated the vendor to deliver the goods to the Bangalore unit itself. Accordingly, the vendor delivered the goods to the respondent's Bangalore unit via e-way bill ending 4669 through vehicle number KA04D505. Further, the respondent shifted the goods to another goods conveyance bearing number KA345745 with the support of the same e-way bill which was issued by the vendor and a delivery challan which has been enclosed as Annexure 5. However, in the process of doing so, the respondent failed to intimate the vendor to update the vehicle number in part B of the e-way bill, number ending 4669. I would like to direct the attention of the bench to Annexure 3, wherein it can be observed that the e-way bill mentioned in the part B of e-way bill has not been updated to KA345745 and instead has been stated as KA04D5053, which is the conveyance sent by the vendor. In the light of the said discrepancy, the commercial tax officer vigilance issued the prescribed forms, including an order under section 129 subsection 1, via form GST MOV 09, demanding a payment of applicable tax and penalty. The said order has been enclosed as Annexure 14 in page 35 of the submissions. Aggrieved by the order, the respondent filed an appeal before the Joint Commissioner of Commercial Tax Appeals, wherein an order in favor of the respondent was passed, thereby providing relief of penalty to the respondent. A true copy of the order has been enclosed as Annexure 14, page 44 of the submissions.
Yes.
In the light of these facts, I wish to seek permission to proceed with the proceedings.
Go ahead.
Your Honor, I would like to first address the matter of whether failure to update vehicle number in part D of the e-way bill renders the e-way bill invalid. In the instant case, there has been a change in the conveyance of the goods in transit. Rule 138 sub-rule 5 of the rules specifically mandates the updation of vehicle number in part B of the e-way bill in cases where there is a change in conveyance of the goods in transit. It can be understood that the Rule 138 sub-rule 5 is conditional in nature, in the sense that if the taxpayer falls within the purview of the rule, then he is by default bound by the provisions of that rule. In this regard, if once the said rule is applicable, any violation in that rule by default invalidates the e-way bill. Else, the said rule could be void and would not have any relevance.
So a mistake apparent will also ab initio render the e-way bill null and void?
Yes, Your Honor. Since the law specifically states that if there is a change in conveyance, then you must update the vehicle number. Then it.
At what point in time did you expect? At the time of shifting of goods or after shifting of goods? While the goods were in transit or while the goods were stationary? What point in time?
Your Honor, the goods conveyance was intercepted while it was in transit from Bangalore to
After transshipment or before transshipment?
After transshipment, Your
I have this court a schematic representation which is part of the appeal papers. I think it is on page number 8 of the paper book. Look at the point at which it has been intercepted. It has been intercepted after whatever that serial number 1, correct?
Yes, Your Honor.
At that point in time.
Yes, Your Honor.
At that point in time, transshipment was complete.
Yes, Your Honor.
At that point in time. At that point in time, the new vehicle that carried the goods was 5745.
Yes,
Last
Your
4
Honor.
digits.
Yes, Your Honor.
What was that goods vehicle? What was it?
Your Honor, that goods conveyance was arranged by the.
What was that goods vehicle? Answer to the point. What was that goods vehicle? Was that a truck? Was that a canter? Was that a Tata 207? Tata 407? Tata Ace? What was it?
It was a
Your
truck.
notice, your orders, your MOVs, nothing talks about it.
It was a truck, Your Honor.
So that was not seen by the officer on the field. He hadn't seen it. Is that truck capable of carrying 20 tons? Because the goods that you are carrying is 10,223 or 322 plus 10,919. Am I right?
Yes, Your Honor.
So we are talking 20 tons. So why was the field formation? Were they not informed that they should look at this requirement? You have come up to the tribunal here, not knowing what vehicle was transporting 20 tons of goods. And you are saying an e-vehicle was incorrectly, conveyance number was incorrectly stated. Nothing to say?
We acknowledge that this fact has been.
So you don't know what truck was carrying those goods. You don't know whether that truck was capable of carrying 21 tons of goods. You don't know whether that truck was proceeding on the right direction or whether there was a willful or qualified intent on the part of the driver of the conveyance to take it to a route which did not appear. I don't think that appears to be the case.
Yes, Your Honor.
Proceed. What follows what you are saying? Please proceed.
Since there has been a violation of Rule 138 sub Rule 5, on the account that vehicle number has not been updated on shifting of the goods.
Is Rule 138 a valid rule?
Yes, Your Honor.
Please. Amicus, can you assist?
Sure, my lord.
Should I put sub Rule 1, Your Honor?
What is ready? You can please proceed.
Every registered person who causes movement of goods of consignment value exceeding 50,000 rupees in relation to a supply or for reasons other than supply or due to inward supply from an unregistered person shall before commencement of such movement furnish information relating to such said goods as specified in Part A of Form GST.
Has he or has he not?
He has, Your Honor.
So what is the difficulty? What is the difficulty? Part A is not updated. Transporter has to update. So what is the difficulty? What is the difficulty? No difficulty. There are two e-vehicles.
Yes, Your Honor.
Man is compliant with law.
Your Honor, since
So he fulfills Rule 138 sub Rule 1. Yes or no? Yes or no? Court is aware of that. Yes or no?
no, Your Honor.
Please read again. What is the non-compliance to Rule 138 sub Rule 1?
Your Honor, the non-compliance here will be.
In sub Rule 1.
The non-compliance is that since the goods were unloaded in Bangalore, the party which causes the
What is the
movement,
second e-vehicle? Nothing stops a conveyance carrying 2 e-vehicles. A conveyance can carry 10 e-vehicles. What is the difficulty? No difficulty. Let us not prohibit what is not expressly prohibited by law, permitted by law.
In that regard, then the first e-bill which was raised by the vendor is in compliance with sub-rule 1.
Second, the 2 e-vehicles.
The first e-bill is compliant to the extent that it was unloaded.
Up to
in time.
Bangalore.
Yes, Your Honor.
Beyond Bangalore,
It is not unloaded.
number was wrong. So what is the difficulty?
As per the law, he was
Conveyance number was wrong.
Yes.
He is giving you a reason. Saying yes, I made an error.
Yes, sir.
Your Honor, if you may point. In the diagrammatic representation, if you may permit, can I demonstrate the
Please.
facts here? Yes. So in the in the flowchart that is given on page 8, it can be seen that a first e-way bill was raised by XYZ Limited to AMC Limited for the shipment of goods to MISA unit of AMC. But on the intimation of AMC Limited Bangalore unit, the goods were dispatched to Bangalore unit unloaded there. So at that point, we may assume that the whole delivery that was supposed to be caused by XYZ Limited is terminated there. And with reference to 138 Rule 1, which says if you may comment, every registered person who causes the movement of goods of consignment value exceeding 50,000 rupees in relation to a supply for a reason other than supply.
You are missing the point. At the time of interception at Chenapatna, it is what it says. At the time of interception of the truck at Chenapatna, what was the error? There were 2 e-way bills. There were 2 e-way bills. Quantity matched.
Yes.
Quantity matched. Goods matched. HSN numbers matched. Correct? Good. Everything matched. What was the error? The error was incorrect mention of the conveyance number and part B of one part of the shipment. Because the second part moved from Bangalore to Mysore. No difficulty with 10,990. Difficulty is with respect to 10,223 or 239, 323, whatever. What is the difficulty? The difficulty is you did not check at the time of transshipment. You checked the course of movement. In the course of movement, there was only one error. What was that error? Lorry number was wrong. So what is the difficulty?
Your Honor, when we say that the movement of goods by XYZ was terminated at Bangalore unit, it mandates AMC Limited to raise a new e-way bill. So he would assume that
My vehicle broke down in Bangalore. It broke down.
But the responsibility here is passed on to AMC Limited. He was supposed to raise a new e-way bill for the new leg of the transaction that is being caused.
The registered person says that it is an error. So what? So what? It is an error. So what is the difficulty?
Your Honor, the registered
That's
person.
why. You don't want to go beyond 138 1. Court is holding out at 2. You don't want it up. Proceed, proceed. Proceed.
The council would like to place reliance on the judgment of the Madhya Pradesh High Court in the case of Gatti Kintetsu Express Private Limited versus the commissioner, the commercial tax officer and others, wherein it was held that failure to upload part B of the e-way bill is not excusable and thus attracts penal consequences. If I may direct the attention of the bench to page 66 of the submissions.
Page 66. Page 66. Yes. Yes.
The Madhya Pradesh High Court has held that since the distance was more than 1200 or 1300 kilometers, it was mandatory for the petitioner to file part B of the e-way bill, giving all the details including vehicle number before the goods were unloaded in the vehicle. Thus, he admittedly violated the provisions of the Goods and Act of 2017, and learned authority rightly imposed the penalty and directed the petitioner to do the same. Thus, it is established that the...
So are you placing reliance, are you drawing analogy, are you taking the ratio, or are you looking at the observation?
we're drawing an analogy from the
So what is the similarity? If you are drawing an analogy, how similar is this case to that?
Your Honor, in both the cases, there has been a failure to update Part B of the vehicle number in Part B of the vehicle. What we want to highlight is that if you have failed to update Part B of the vehicle, then it cannot be excused and it will attract penal consequences.
Is that offense total or is that offense partial? You are drawing, be careful, analogy. What happened in that case, what is one single consignment which was transshipped? In this case, there are two consignments which are being moved.
Yes, sir.
Correct? One part of it, there is no difficulty. The difficulty is only in the other part. The other part, right?
Yes, sir.
So please look at your penalty papers on what value you are levying. Please look at it and let me know before the court. Go ahead, please go ahead.
Since the respondent has carried an invalid e-bill because of violation of Rule 138 Subgroup 5, he has contravened Section 68 subsection.
Where does the Rule 138 say it is invalid? Where does the word invalid come from?
Your Honor,
We can't import words into the legislation which the legislature doesn't intend to be.
yes, sir.
Where is that word invalid?
Your Honor, I'd like to make two submissions, sir. 138 Subrule 5 specifically mandates updation of...
138 sub rule 5. Let's put 138 sub rule 5. Yes. Yes.
In the case where there is a shift in the conveyance of the goods, it specifically mandates updation of vehicle.
Listen. What are the rules? Listen.
Where goods are transferred from one conveyance to another, the consignor or the recipient who has provided information in Part A of Form GST EWT01 or the transporter shall before such transfer or further movement of goods update the details of conveyance in the e-way bill on the common portal in Form GST EWT01.
So where did you intercept this? Look at the proviso. Don't stop with the rule.
Provided that where goods are transported for a distance of less than 10 kilometers within the state or union territory, from the place of business of the transporter, finally to the place of business of the consignee, the details of conveyance may not be updated in
Where are you reading 10 kilometers?
With your permission, my lord.
Where are you reading 10?
Provided that where the goods are transported for a distance of up to 50 kilometers.
Where does your notice say that you intercepted beyond 50 kilometers? The notice doesn't say so. Does your notice say so? Doesn't say so.
Your Honor, since the goods are being transported from Bangalore to Mysore,
Where did you intercept? Was it beyond 50? Before 50? Continue. Anyway, it's before 50 kilometers. Continue.
Your Honor, would you like me to continue with the
Please continue. Please continue. I mean, basic English. Please continue.
The respondent has also contravened explanation 2 to subrule 3
Explanation 2 to subrule 3 of which rule?
of 138.
Explanation 2 to subrule 3 138. 2 to subrule 3. Yes, please go ahead. Yes.
Explanation 2 states that the e-way bill shall not be valid for movement of goods by road unless the information in Part B of GST EW01 has been furnished, except in the cases of movement covered under the third proviso, to subrule 3 and the proviso to subrule 5.
Correct. So subrule 5, proviso to subrule 5 we read. What is proviso to third proviso to subrule 3? Please read third proviso to subrule 3. Which is also 50 kilometers, right?
Yes, sir.
Which is also 50 kilometers.
Yes, sir.
So this explanation does not say it is not invalid. Does not say it is invalid, sorry. It says it shall not be valid. Not being valid and invalid stand on a completely different footing under law. Correct? Not valid means what? Counsel Rajesh does not have a valid ticket. It does not mean he is holding an invalid ticket. Not holding a valid ticket does not mean it is invalid. Invalid is completely different. Right? Proceed.
Section 68, subsection 1, read with Rule 138, Subrule 1, states that the person in charge of a conveyance carrying any consignment of goods of value exceeding such amount is required to carry the prescribed documents. The prescribed documents have been enlisted in Rule 138, Subrule 1, which states that the person in charge of the conveyance must carry an invoice or bill of supply or delivery challan as well as a copy of the bill. In the instant case, the intent of the law here was to ensure that all the relevant details pertaining to the movement of the goods between two given locations has been captured and furnished to the government. In cases where, comparing case where the respondent has not carried a valid e-label or where he has not carried an e-label at all, in both the instances there exists a discrepancy in communication of the documents to the details to the government. This is not.
There is a discrepancy. There is a discrepancy. You admit there is a discrepancy,
Yes, sir.
right? So the state's case is that there is a discrepancy.
Yes, sir.
Yes or no?
Yes, sir.
Yes. Yes.
Yes, sir.
Can this court record it? The state's case is there is a discrepancy. Can it be recorded?
No, Your Honor, it is an error.
Can this court record that it is an error?
Yes, sir.
So it will record that it is an error.
Yes, sir.
So we have moved away from invalidity to an error. Yes or no?
Yes, Your Honor.
So error will be recorded. Okay, proceed.
The respondent has contravened Rule 138 subrule. Since the respondent has contravened Section 68, subsection 1, read with Rule 138 subrule 1, the penal consequences listed in Section 129, subsection 1. It attracts penalty. As per Section 129, subsection 1, in the event of contravention of the provisions of the GST law, any person who transports or stores any goods in transit in contravention to the provisions of the GST law, the goods and conveyance of the said person are liable to detention and will be released only on the payment of the applicable tax and penalty. Since in the instant case it is a violation of Section 68, as established earlier, Section 68, subsection 1, read with Rule 1.
So on what value you will levy penalty? On both value of both the consignments or one consignment?
One consignment.
We're clear? You don't want to check on the value of one consignment or both the consignments?
It's on the value of one consignment.
10,323, 10,323 kg consignment.
That consignment pertains to the consignment which is being delivered.
So 10,919.
Yes, sir.
On that value you will levy penalty twice, which is some 2,02,000 and odd.
Yes, sir.
Huh?
We have applicable tax amounts to around 4 lakhs and the penalty equivalent to 100% amounts to 4 lakhs.
On full value, are you telling me that you are levying penalty on the value of both the consignments or one consignment?
One consignment, you know.
Only?
Yes, sir.
Go ahead. Go ahead.
In conclusion, the failure to update Part B of the EV bill has resulted in the respondent not carrying a valid EV bill, and this is in violation of Section 68, subsection 1, Rule 138A, sub-rule 1, and attracts penal consequences under Section 129, subsection 1. Basis this, the order passed by the First Appellate Authority to provide relief of penalty is invalid. Your Honor, now my co-counsel would take up the matter.
In continuation to the argument put forth by my fellow counsel, I would like to address the ground whether the respondent was liable to raise a new e-way bill or not for initiating branch transfer. So, Rule 138 sub-rule 1 of the rules emphasizes e-way bill must be generated by any registered person causing the movement of goods of prescribed value. Such movement of goods can be in the nature of supply or otherwise. So in the instant case, when the goods were delivered to the Bangalore unit by the vendor, it is assumed that when the goods are unloaded from the truck 1 and at the Bangalore unit, it assumed the transportation that was being the responsibility of the vendor is terminated at that point. And the further movement of the goods, the transportation of further movement is assumed by the respondent. Hence, he is required to raise a valid e-way bill for the next movement, like till the Mysore unit.
Can it not be said that the goods are in the course of movement because the original invoice is up to Mysore?
Yes, but
Can it not be said? The course, it's in the course. Under the Supreme Court.
But the responsibility is assumed by the respondent for the goods. He has taken the delivery in the Bangalore
He
unit.
doesn't deny that. He is not denied. He has come forward to say it is my goods. He is not denying it. He is pleading before this honorable court saying that yes, my lord, I made one mistake. There was one lorry number which was wrong. He is not going beyond that.
Your Honor, the respondent himself requested the vendor to unload the goods at the Bangalore unit.
How else will he take it because he has only one conveyance?
If he had not done that, the vendor would
He
have
wants it
continued
to
to.
do. Because you are saying in your grounds of opinion that it is cost optimization. You are saying it. State is saying that.
Your Honor,
State is saying it's a cost optimization measure. You are not even disputing that in your appeal papers. You are not even saying cost optimization measure is not a reason. You are not saying so. Correct? You are not disputed that. I will not allow you to take fresh ground now.
Yeah.
That's another matter. We will deal with that. Yes, go ahead.
But the respondent has raised a delivery challan for the movement from the Bangalore unit to the
He
Mysore
has.
unit.
He has.
But with the strength of delivery challan and the e-way bill which was raised by the vendor in first place,
Correct.
he is moving the goods. So
Yes,
the
he
strength
has.
of delivery challan is considered here.
Yes.
But in the e-way bill, part A of the e-way bill, if you as annexure 3,
Yes.
in the e-way bill details, the original invoice reference is given, whereas the delivery challan reference is not mentioned.
Where does the law say or give delivery challan reference here in the e-way bill? Law does not say so.
Part A of the
If
e-way bill.
invoice number is given, it is enough. Invoice will carry the delivery challan number. What is the difficulty? What is the difficulty?
Your Honor, the same e-way bill cannot be supported with a delivery challan as well as an invoice.
What is the difficulty? Quantities matching, nature of goods are matching. Man has come forward. He is telling you yes, it is here.
Since he raises a delivery challan for the movement, we assume
He
that
is not this.
we presume that the responsibility of the said goods is taken up by the AMC.
Where is that in the order? Where is that in the order? I will not let you take that ground now. It is not part of the order. It is not part of the notice. Show cause does not say so. It doesn't say so. The show cause said there is an intent which is willful or malified. It doesn't say so.
But the show cause notice gives a reference to the delivery challan that was.
That's all it says. It says part B is not filled up. He admits part B is not filled up. He says, my lord, it is not willful or malified intent to evade or avoid. That is his ground. That is his plea. In the
Cross objection. That is the plea of the appellant.
Your Honor, if you may permit to annexure 11 where they have submitted a MOV 09.
Where does it say? Where does this notice say that there is a willful or mala fide intent to evade tax that is legally due to the government and the goods that are carried by way of conveyance number 5745 vis-a-vis what moved from the original place of supply is completely different. It doesn't say so. This notice doesn't say so. Amicus, can you please quickly look at that and let me know whether there is any such ground? I haven't seen any such ground there. It only details there is an error in part B. It doesn't matter. It doesn't matter. The only support you can draw, which is actually against you, is go back to page 37, para 6 of the notice that you are order that you are talking of. Go to page 37, para 6. What does page 37, para 6 say? Please look at seal number 6, para 6. You know what it says? Please read.
Further, though transporting special equation prone commodity, the dealer.
Who says so? Who says so? Who says it is an evasion-prone commodity? What is the basis for making statements? The state cannot make statements out of nowhere to say iron steel is an evasion-prone commodity. How can you, officer, say? You can take the support of your officer if you want to and talk to him and say on what basis he made this statement here. How can he say that this is an evasion-prone commodity? Simply because somebody is selling gold, can you say it's an evasion-prone commodity, therefore I will search you? Law does not allow you to do that. Law is to say that you are a person who is evading. Fair enough. Law cannot say iron and steel is an evasion-prone commodity. No, not possible. Do you have anything to say about this? You don't want to say anything? Proceed.
So I would like to conclude it. I would like to conclude in this regard that the revenue primarily recognizes its function to ensure compliance under the GST Act along with the duty to identify and penalize tax evasions. We acknowledge that there has been no instance of tax evasion, but we also acknowledge that there is a contravention to the sections or the Act provisions provided under the law. So, as a revenue holds good the duty to ensure that such contraventions are penalized. And in general parlance, if we try, penalty can be imposed by law on committing of an offence or failing to do something that was the duty of the party to do so. In the instant case, the provision of the law mandates carrying a valid e-way bill in respect of movement of goods. Failure to comply so makes the respondent liable to penalty. So hence the council requests.
So you levy 100% penalty. Huh? You levy 100% penalty. Simply because one column in part B of the e-way bill was not filled up or incorrectly filled up, you levy 100% penalty.
Your Honor, had it been the case that there was no specific provision in the law, then we would agree that.
Don't take that provision. Amicus, can you please guide the council to 126 subsection 2? Who says there is no provision under law? Please read 126 subsection 2. Subsection 2. Amicus, quickly, we are running out of time.
The penalty imposed under this act shall depend on the facts and circumstances of each case and shall be commensurate with the degree and severity of the offence.
So, did the officer on the field or the field formation give a go-by to this provision? You have levied 100% penalty. You have given a go-by to this provision.
there can be no provision in the statute book which cannot be given due effect to. It has to be given due effect. It has to be impartially considered. Go ahead.
Your Honor, the commercial tax officer was of the opinion that since penalty under section 129 is applicable in the instant case, subsection 6 to section 126 states that the provision of this section will not be applicable where penalty is specified under this act either as a fixed sum or expressed as a fixed percentage. So in the instant case where he was of the opinion that penalty under section 129 is applicable, the section 126 was not applicable.
126(2) is also not applicable.
Your Honor, the subsection 6 clearly states that the provisions of this section will not apply. So that includes the preceding.
Please read.
The provisions of this section shall not apply in such cases where the penalty specified under this act is either a fixed sum or expressed as a fixed percentage.
So 126 subsection 6 is applicable to which of those subsections? Can you please help the court in understand?
In the instant case, it is section 129, Your Honor.
No. Because please help the court understand. 126 subsection 6 has got nothing to do with 129. 126 subsection 6 has got nothing to do with 129. You are saying the provisions of this section. Which section? 126. The provisions of 126 shall not apply in cases where the penalty specified under this act is either a fixed sum or a fixed percentage. Subsection 2. Section 2 is overriding. It says act. It says act. Please read.
The penalty imposed under this
Under
act.
this act, it takes within its sweep and ambit all the provisions of the statute. Go ahead. Good. You have 3 minutes to wind up. We will have to give the applicants an opportunity. Sorry, the respondents an opportunity.
So again reiterating, acknowledging the fact that there is no evasion of tax, but there is a non-compliance to the act or the rules. So hence the respondent is liable for penalty under section 129.
Equal to tax. Correct? Penalty equal to
As
tax.
prescribed under section 129.
Which is equal to tax. Yes?
Yes.
Your Honor, if your Lordship is well versed with the facts of the case, we would like to proceed the grounds of objection. Much obliged. The grounds of cross objection against the appeal filed by the applicant are as follows. The first being that in the given case there is no requirement for a fresh issuance of an e-way bill. The second being that the act of not updating the e-way bill for the transfer of goods is merely a branch transfer with the same GSTIN, and hence it is considered a minor breach under section 126.
So you will do what you want to do under law, and you will come back to this court and say it is minor breach of law, my lord. The state says your intent is nullified. You don't want to upload it. You want to recycle the e-way bill.
But here we are
You want to recycle the e-way bill.
Your Lord, it's merely a branch transfer and it is not even
Who
qualified.
says for branch transfer you don't need an e-way bill? Therefore, a lenient and sympathetic view should be taken. Law does not say so. Law looks at every offence in the manner in which it should be looked into.
Your Honor, we are carrying an e-way bill, but erroneously we have not updated the card key.
So, you can slaughter somebody and say in the pit of rage.
But Your Honor, there was no revenue loss for the government.
Who says so? Who says so there is no revenue loss?
Your Honor, this is a branch transfer and it does not qualify as a supply payment. It between branches with having the same GST ID.
So where is the question of no loss of revenue? Tomorrow if you don't account this, you will say terminated in Bangalore and it is lying in stock. In Mysore it is sold. That is their grievance. That is why they have come up in appeal. That is why they are justifying penalty which is equal to tax. They are saying don't show the appellant any lenience, the registered person any lenience. They are saying in fact it should be more.
Your Honor, we've come forward to pay the penalty and we've also filed returns for the same amount.
No, you may have filed, but you are now asking for refund.
Because this is merely a branch transfer.
Who says for branch transfer there is no levy? If it is not accompanied by, in the course of movement by proper documents, their grouse is, the state's grouse is there is no proper document which is backed up for the goods to move from point A to point B. That is their grievance. Their grievance is 100% penalty is justifiable.
So, Your Honor, they stated, the appellant had stated Rule 138 of the GST Act 2017, stating that we were not carrying the necessary documents. We were carrying the invoice and the delivery challan and the so it was in compliance.
What was the conveyance which you used to move 20 tons of steel?
It was the consignment.
Why did you not say that? Why did you not say that? You forget what the state did not do its job. Does not mean that you don't do your job. State did not do. We will act the state separately. Does not mean you don't do your job.
It was not intentional that we did not update the party. It was an error on part of the respondent. And,
so your plea is that
it
is
is
a
an
minor
error.
breach. It is an infraction of law which does not justify penalty equal to 100%. Anything more? Nothing else? Nothing else?
General penalty under section 125 can be levied rather than specific penalty under section 125.
Please read one. Please read one. 125.
Any person who contravenes any of the provisions of this act or any rules made thereunder for which no penalty is separately provided for him.
Now you fix yourself in 125. Fix yourself. How? How do you call this? Breach. They are saying you are a fit case for 129. State says you are a fit case for 129. State is gone to the extent of telling the provisions of 126 also cannot be applied to you. State is telling you are a fit case for 129 equal to tax. Really? It will be alright. Next time will be alright.
Your Honor, we like to place reliance on the judgment raised in the VSL Alloys versus State of Utah.
So you want to place very same judgment here. No, what is your reason?
The VSL Alloys versus State of UT, there was seizure of goods for not updating Part B of the...
Yours is not a case of seizure.
It is a case of seizure.
No, it's not a case of seizure.
It's a detention.
Where is seizure in your case? There is no seizure. He let you pass. He is only said pay 4 lakhs and move. He is not seized anything. So how does the ratio of that decision or the observation of that word or the analogy drawn based on the factual position in that assist you in your argument?
With your permission, I would like to add, here the goods are not seized because the respondent has come forward to pay tax.
Why did you pay? You allowed the goods to be seized. Why did you?
There is an emergency which from the customer which
Get a second consignment which could have moved. Second one was moving, right? They didn't stop you from moving back. They didn't stop you. Field formations didn't stop you moving second consignment. It was only the first one which was in difficulty. Back again. How do you fit yourself into 125? This did 125. Because can you please assist them with the statute? Please assist them with the statute.
Section 125.
Assist them with the statute, please. Assist them with the statute. Yes.
Section 125 general penalty. Any person who contravenes any of the provisions of this act or any rules made thereunder for which no penalty is separately provided for him provided for in this act shall be liable to pay a penalty which may be extended to 25,000 rupees.
State has now carved out a case. State has carved out a case saying you violated the provisions of 68, 129, read with rule 138, sub-rule 1 to sub-rule 5, read together with the explanations and provisos thereof. So how can you say that there is no provision? You are saying you are fit case for 120.
I will already interlinked with your permission. I would like to seek for further arguments.
Sorry?
I would like to continue with further arguments. My lord, here act of not updating part B of the bill can be considered as a minor breach under section 126. Would like to quote section 126 subsection 1 of the KGS Act 2017. Any error or omission in documentation without.
Don't go to the case now. Please go to 126. Tell me under which subsection of 126 do you fit yourself into? You are calling yourself a minor breach.
Yes, ma'am.
Please read 126. Please read 126. Read.
No officer, section 126, general disciplines related to penalty. No officer under this act shall impose any penalty for minor breaches of tax regulations or procedural requirements. And in particular,
1 minute. So you are talking no officer shall impose a penalty for minor breach. Come to explanation A. Explanation A.
if a breach shall be considered
Please.
a breach shall be considered as a minor breach, the amount of tax involved is less than 5,000 rupees.
Yours is 2 lakhs.
No,
4 lakhs. I don't know what. 2 or 4. 2. Tax is 2 lakhs, right?
Yes, sir.
So you are not 5,000 here.
My lord, as mentioned in grounds, appeal grounds of cross objection number 4, as per rule 11C of the CGST rules 2014.
Rule 11C of
CGST rules 2014. Intrastate,
14.
so 2017. Intrastate transfer of goods or services between the persons having the same registration shall not be eligible to tax. Further, as per section 126 1A of the CGST rules, CGST Act 2017, the tax involved here, since there is no tax at all, the tax involved is less than 5,000 rupees.
Don't put the cart before the horse. No. What is the state's grievance? The state's grievance is your goods have terminated. That means the supply, the inward supply is terminated at Bangalore. The subsequent movement from Bangalore to Mysore is a fresh supply, and therefore it is a subject matter of levy. If it were to be a branch transfer, then the provisions of law are completely different. You are not fitting yourself into that case. You can't bring in a fresh argument here to say, no, it is a stock transfer. Not possible. Do not take your friend from. Continue.
And I would like to read explanation D to section 126 of the section. Any omission or mistake made in documentation shall be considered to be easily rectifiable if the same is in error or apparent on the face of the record.
So you are not a minor breach. So you don't fit into 126 at all. So class B will not apply. They are not a minor breach. They are more than 5,000. So this 126 will not apply to you at all. That's how the court understands this provision. You want to educate the court in a different manner? Because can you please quickly?
And also I would like to say explanation B is relevant to us to section 126 subsection.
So will fit to the main part of the provision of the 126(1). No officer under this act shall impose a penalty for any minor breach of tax regulation. Minor breach means 5,000. The moment you are minor breach, you are out of this provision.
Minor also it says procedural requirements. We are trying to convey that not updating part B of the which is a procedural requirement and it can fit to section 126.
So can you please educate this court what is the word that lies in between these two?
Or my lord.
So how does that help you? How does that help you? Amicus can
Please.
Good.
No officer under this Act shall impose any penalty for minor breaches of tax regulations or procedural requirements, and in particular, any omission or mistake in documentation which is easily rectifiable and made without fraudulent intent or gross negligence.
So is this a rectifiable error?
Yes, my lord.
Moot no longer rectifiable. State is telling moots have gone. It is left. Now how will you rectify it? It's gone. State's case is willfully ordered.
Yes, my lord, we agree that we agree with the contingencies
So
of
the latter part of it won't
it is not a rectifiable error.
Court is the latter part of that will not be court is helping you out in the next part. Or latter part of it will not help you. Won't that provision help you?
For the purpose of this subsection, any breach shall be considered as a minor breach if the amount of tax involved is less than 5,000.
Latter part.
Any omission or mistake in documentation shall be considered to be easily rectifiable if the same is in error apparent on the face of the record.
Why did you give an undertaking to say at the time of interception, saying that it was an error, it was a minor breach, and raise a fresh e-weapon? Why didn't you do that? Why didn't you do that? You had the opportunity. They intercepted you. They stopped your truck en route to Mysore. Why did you not do it? That opportunity is gone. You cannot come to the court and say that is the opportunity which I am mistaken. Then therefore this court ought to take this ground now, plea now. Not possible. Correct? That opportunity you should have taken then. Go ahead.
My lord, here we place reliance on the following judgment. Integrated Constructive Solutions versus VA, ST and Proper Officer, GST Appellate Authority, Himachal Pradesh. In this case, it was held that competent authority has passed an order in a mechanical manner and had ignored the corrected and updated EVA bill as produced by the
It
respondent.
will not apply to you. You have not corrected, you have not applied it. That is the state's case.
My lord, here
State is saying there is no e-way bill and the e-way bill you have furnished is also wrong. So how are you saying that this integrated constructive solutions case is similar to your case? Not possible. You can't borrow. Next. Amicus, you can please brief them why.
Here we have to convey that in the instant case, the respondent has erroneously but not intentionally updated the part B of the
Which part of the appeal petition?
page number 25 of
Page number
grounds of
25.
process.
Page number 25. Where?
Last paragraph.
Ah.
In the instant case, the respondent has erroneously but unintentionally has not updated the part B of
This is
the
over. This won't apply because that decision. What happened in integrated case? In integrated case, he rectified it. You should have fresh e-paper. You didn't do it. If you had done it, probably, this would have been a similar case, although not the same.
Yes, my lord, but we would like to convey that here the respondent is carrying
Court has understood this. We will consider that. Next.
We would like to emphasize on this matter, my lord. Due to such error, there is no revenue loss to the government, and there is intention also not to avoid any taxes. This can be concluded based on the liability regularly discharged by the liability by filing regular returns as applicable.
We have heard your plea. We have heard.
applicability of the general penalty under section 125 or 126 can be levied rather than specific penalty under section 129.
Can you tell me under which subsection of 126? Which subsection? You cannot say you have to apply 126 to my case. Which subsection of 126?
126 subsection 2, my lord.
126 subsection 2. Why would you say so? The field formation say they have considered the facts and circumstances of your case. They are saying they have considered. They are saying having considered, you are a fit case for a penalty equal to tax under 129 read with 68. That is what they are saying.
My lord, I want to read out the clause of section 126.
Please.
As per section 120 subsection 2 of the KJ Act 2017, the penalty imposed under this act shall depends on the facts and circumstances.
Can you trace this plea, your reply before the field formations when they issued your MOB, whatever form number? Can you please trace whether you have taken this ground there? Then how can you compare with the fresh ground?
We have taken
126.2.
Yes, ma'am.
Be specific. Be specific.
126, 1 also, 122 also I have taken.
Be specific. Under 126.2, I am told the field formation there that you have to follow the principles laid down in 126 subsection 2. Have you told them? I don't say. I don't see it in the grounds. I don't see it in the grounds. I don't see it in the reply either.
But this is a new ground of objection we are raising before the action.
That court will decide whether I have to allow that or not. We will decide. Court will decide.
With the permission, can I continue? The penalty imposed under this act shall depend on the facts and circumstances of each case and shall commensurate with the degree and severity of the breach.
We have heard you.
My lord, we also place reliance on the following judgment given by the High Court, Gujarat High Court in case Synergy Procedural Private Limited.
Which page number?
Page number 26, last year.
Yeah.
The Honorable High Court held the following. We are of the view that at the time of detention and seizure of goods or conveyance, the first things the authority need to look closely into the nature of the
Be
conference.
careful, bro. The court there was deciding on a case of detention and seizure. You are a case of detention. You are not a case of seizure. You are not a case of seizure. Be careful.
The first thing, the authorities need to look closely into the nature of the contravention of the provisions of the Act of the rules. The second step is the process on the authorities to examine whether that contravention lead to evasion of taxes.
State agrees there is no evasion. State has categorically agreed that there is no evasion. State is on the principle that 68 read with 129 and 138, 1 to 5 is what will happen. State doesn't say you are an evader. No. I have a different question for state which we will handle. Next.
Here in the case, the act of not updating EVA bill, the court held that this may be quite trivial or may not be of such a magnitude which would by itself would be sufficient to take you that the contravention was the necessary intent to avoid the payment of taxes. My lord, we also place reliance on the judgment given in Sriram States versus the deputy tax officer by the Honorable Gujarat High Court.
What does it say?
I said interpretation of taxing statutes should be done in a way to facilitate business and interstate trading, and not in a perverse manner which would result in impediment of the same by harassing business persons.
What did they do? They did not seize your goods. What did the state do? They said nothing. They said part B is not filled up. Please pay 2 lakhs, whatever, 4 lakhs. Oh, please pay 4 lakhs. Keep going, don't pay. Don't block the highway. That's what they said. Beyond that, they said nothing. What is the difficulty? Why are you bringing this case now? What is the perversity? There is no perversity here.
Imposition of penalty, my lord.
There is no perversity. If you are talking perversity, then you will have to go by the intent of the field formation to say he was so perverse. It is not the case. He said 69, 129. They have not followed. pay 100%, go. No perversity, no perversity. Anything more?
Yes, ma'am.
Anything more?
My lord, here we have the view that it is a procedure, it is just a procedural.
We have heard you. The procedural lapse, no willful or malignant intent. Therefore, penalty cannot be applied in a mechanical manner. Therefore, you apply 25,000 for all the crimes that I committed. Let me go. We have heard. Next. Because please look at subject papers at page number 28. Cross objections. Cross objections.
We finally conclude that based on the most submission, we reiterates that updating not part of the vehicle is a minor breach. The same should not be held against the respondent because there is no intention to avoid any taxes and also no revenue loss to the government. Therefore, we request your good self to set aside the appeal raised by the appellant and the entire amount.
There is no good self in that record. No good self. The bench you are addressing the tribunal is not good self. Amicus, can you just take page number 28? Can we look at the date down below? The 2020, 2022, 2002, what is it? So we don't have the habit of vetting the appeal papers with amicus before we file it before the court. We don't have. We will educate. Any rejoinders to the registered person's arguments?
Yes, Your Honor.
Yes.
Addressing the learned harms of contention, they have highlighted the fact as per Rule 138, they are supposed to carry delivery challan or invoice or bill of supply with e-bill for movement of goods and the fellow learned harms.
He is admitting.
Yes.
He is pleading before this court to say, my lord, it is a minor error, please let me off to, don't leave 100%. That is his plea. He is not saying anything else.
Your Honor, with respect to circular number 64, bar 38, bar 2018, which has been enclosed as annexure 18, the government has clarified that in case where one or two digits of the vehicle number, it has request the bench to refer to page 17.
This circular need not apply to all and sundry. This circular has given instances where it can be considered as a minor breach. Instance. He pleads that mine is not there in this. It is away from this, but mine, one lorry number I have not mentioned. That is all is his plea. This circular lists out instances. That's all. All right, I am not in this instance. 5, 6, 7, 8 example, mine is 9th. That is his plea. Madam Counsel. Madam Counsel, can you please tell this court which is that part of the first appeal order that you are aggrieved on? Can you lead me precisely to that paragraph? Which is that part? First applied authority said grant refund. Which paragraph are you aggrieved on? Which is that finding? Which is that observation?
Your Honor, we are aggrieved by the order passed by the.
I know you are aggrieved, that's why you have come here. Which part of the order? I don't find any difficulty with the first applied authority's order. I don't know. This court doesn't find any difficulty. Which part you are aggrieved?
Your Honor, the first appellate authority dropped the penalty on the grounds that
He
there
dropped.
was
He
no
dropped.
intent.
But what is the finding you are aggrieved against? both amicus, please guide them to say, I want to find out which is that paragraph, which is that sentence which the state is agreed about. Paragraph 56, page 56. On page 56. Which paragraph?
Your Honor, in page 55,
Page 55. Okay.
under issue number 1.
Under issue number 1. There are two issue number 1s.
The second-
Madam Counsel. Yeah.
Second issue number 1.
Yes.
It has been stated that the appellant by oversight did not get the vehicle number updated in part B of the e-way bearing number 1612 6366 4669 upon shifting the goods to vehicle number KA345745 for the branch transfer between
Where is this ground in your appeal paper? Where is this ground? This ground is not there.
Your Honor, we have contended that
You have contended generally. You have not contended specifically. Where is the ground? So, the state is not offended when the learned first appellate authority says in the latter part of the very same paragraph on at page 56, when he says historically it is noticed that the appellant has filed returns regularly in time. How does that help? So you have no grievance, you have no grouse. You have no grouse.
we have
Where is that ground? Where is that ground? Where is the ground? In the appeal papers. So you don't have further grievance. When the learned FAA says, upon examination of the track records, it is ascertained that the appellant has not committed such mistakes earlier. So you don't have any grievance. How can an appellate authority pass an order based on track record of an X? The transaction which is the subject matter. Where is that ground? Leniency shown by the learned FAA. You have no grievance. State has no grievance. No ground in the appeal.
we have included
Let
the
the party
lenient-
says your leniency has to be taken.
No,
He says so. Please read para 56, last but one line. Page 56, last but one line. Amicus.
A lenient view may be taken.
So you have no grievance. Where is the ground? Where is the ground?
Your Honor, we have concluded by saying we, revenue, the LA cannot.
That is the grounds of appeal. There is no attack on the findings of the learned FAA. Correct? You are not attacking the findings, so you are accepting the findings of the learned FAA by inference. Correct? Can we record that you are accepting?
No, Your Honor. We've been aggrieved by this order, so inferring that we do not concede with the findings of the hearing.
Thank you for review. email.
Appeal number CCC 10,003/2022, Assistant Commissioner of Central Bank.
So this is a departmental appeal.
We are representing the GST department.
Please sit down. Go ahead.
We are representing the GST department as the Assistant Commissioner Lokesh, my co-applicant Monesh Kumar.
Mr. Mendes, can you please assist the court in giving the relevant notification that they have been appropriately appointed under law? I need the proper notification with names, designations from the commissioner. Appropriately with relevant sections and rules. With relevant sections and rules.
Your Honor, as per section 112 subsection 3, the Commissioner may on his own motion or upon request from the Commissioner of State Tax or Commissioner of Union Territory Tax call for and examine the record of any order passed by the appellate authority or the regional authority under this Act or the State Goods and Service Tax Act or the Union Territory Goods and Service Tax Act for the purpose of satisfying himself as to the legality of the propriety of the said order, and may by order direct any officer subordinate to him to apply to the appellate tribunal within 6 months from the date on which the said order has been passed for determination of such points arising out of the said order, as may be prescribed by the Commissioner in his
I
order.
understand that. Can please assist them in giving me the notification which authorizes them to appear before this bench under relevant section. Relevant section, if it is not, please don't bring it before the court. It has to be properly authorized.
So it was.
I think is it properly authorized? Properly authorized. Can you assist the court in giving me the page number?
Page number 11.
Page number
11.
Page number 11 is not an authorization. Page number 11 is not an authorization. Because
It's not appropriate and properly authorized.
Not?
The authorization which is annexed with the appeal papers appears to be incorrect.
What point in time they will be filing a proper? What point in time? How long do they need? How long do they need? I guess we are wasting court's time.
They need a short span of time to furnish.
We'll post it tomorrow. We'll post it for tomorrow. File it in the office. File it in the registry. Tomorrow,
Yes,
tomorrow. Is commissioner in town?
yes, sir.
If you find tomorrow, can we record it?
Yes, sir. Tomorrow will be
You don't want more time.
Tomorrow will be totally.
Otherwise, we will take you as not represented. Is it okay? If you don't file it by tomorrow.
Yes, sir.
Because your arguments will thereafter not be taken on record. Proceed.
We are here to appeal against the order passed by Additional Commissioner of Central Tax. Here the facts. Ms. MLRR, the respondent, as registered under the provisions of GST Act 2017 in both Telangana and Karnataka states. The respondent has claimed that they had erroneously paid an amount of 33,86,523 towards IGST at Hyderabad branch. The same was filed in the returns filed in Form GSTR 1 and 3D for the month of May 2019.
In which state?
Telangana.
So Telangana, they declared the appropriate turnovers and paid the tax. Correct?
Yes, sir. This was identified when the respondent is reconciling the
Which respondent? Hyderabad respondent.
Yes.
Okay.
While reconciling the books of accounts while filing the GSTR 9 and 9C, and the same was amended in GSTR 9 and GSTR 9C, where the filing was delayed due to COVID situation. The respondent has also claimed that the purchase orders against which output was declared in Hyderabad are actually relating to the service provided from Bangalore, and the same was paid by utilizing the available ITC in electronic credit ledger.
In which state?
Hyderabad.
So in Hyderabad, what he did, he declared an incorrect turnover, utilized the input tax credit.
No, Your Honor. In Hyderabad, they have declared the output tax and they have paid the
Physically, they have paid
in cash, and they after reconciling they have paid in the Bangalore branch, which is which
So
they have
he
paid.
realized that this turnover does not pertain to Hyderabad, but it pertains to Bangalore.
Bangalore,
Right?
they realized, and then they have paid the output tax in the Karnataka using the input tax credit.
So he paid taxes in 2 states.
Yes.
The respondent has submitted an application in Form GST RFD 01 by ARN AA36032103015 dated 23/3/2021 for rupees 33,86,523 electronically through common portal on account of excess payment of tax. The claim was acknowledged by ZW360.
On which page of the paper book are you reading from?
Page 3. Page 3.
Huh?
Page 3.
Page 3, para?
Para 3.
Go to para 2.
Yes.
Please read what you have written there.
This was identified when the respondent is reconciled.
Next, line 3. Line 3. Can you please
Where the filing was.
The respondent.
The respondent has also claimed that the purchase orders against which output was declared in Hyderabad.
Which purchase order? Which law says purchase order is a legal document? Which law says?
That is what the respondent has been claiming. So as whatever the respondent has claimed against the earlier authority, we are briefing the same facts.
So he's not talking invoice, he's talking purchase order.
Yeah, they are showing the purchase order as a proof, telling that this order was issued by the Bangalore branch, but erroneously they have declared the turnover and they have raised the invoice and declared the turnover in Hyderabad branch. Later, which they have identified and they have.
So the registered person is not talking invoice.
No, purchase order they have.
Okay, proceed.
The claim was acknowledged by ZW360421008.
So please be on para 2. Please be on para 2. Please read that. And please go back 1 minute back what you said. And please read what you have written here.
The respondent has also claimed that the purchase orders against which output was declared in Hyderabad are actually relating to the services provided from Bangalore, and the same was paid by utilizing the available ITC in electronic.
1 minute back you said you have effected 2 payments. Now you are saying I have utilized ITC.
Yes, sir, they have paid. They have discharged their output tax liability in Hyderabad by paying through cash.
But it's not set off, it's payment.
Yes. In Hyderabad, they have paid through
Amicus.
cash.
In indicate them about setting off vis-a-vis payment. Go ahead. Please go ahead. I understood. Go ahead.
The respondent has submitted an application in form GST RFD01
Yes.
dated 23/3/2021 for rupees 33,86,523 electronically through common portal on account of excess payment of tax. The claim was acknowledged by Z336042100842116 stated
Go ahead.
for claiming of refund of tax paid in Hyderabad. We issue a show cause notice by reference number Z03604210285950 dated 25/4/2021 as to why the entire refund should be rejected, why should not be rejected. The respondent has replied white number ZD360521066.
All right, we have read through. Please tell me what is the crux of this? What is the crux of that para 4? What is it that you are saying? Very good. Please go ahead.
So, Mrs. MLR, they have appeared again using the authorized representative, Shri Vishwanath CA, and they have claimed that they have erroneously included the values in GSTR 1 of Hyderabad branch. They have submitted GSTR 9 and 9C, stating that they have amended the turnover and their reconciliation was delayed. They further stated that they have noticed the payment of IGST in Hyderabad during the reconciliation. The POs are relating to consultancy services rendered from Bangalore, and since IDC was available, they have paid the same in Bangalore in July 2020. And there is no need to pay from cash ledger, and since it was paid from IDC, no need to pay interest also. As they have as there was input available for them in Bangalore branch, they have utilized the same input and they have discharged the tax liability of output tax in Bangalore branch. So the authority has observed that Mrs. MLRR has paid IGST in Hyderabad, and details of invoices are duly reflected in GSTR 1 of Hyderabad in May 2019. Once GSTR 1 was filed, the same will be reflected in GSTR 2A of the party recipient through auto-population of the portal. This enables a client to claim the ITC available in GSTR 2A through GSTR 3B. If services are not provided by Hyderabad branch and showed in GSTR 1, they should have issued the credit notes as required under section.
Who says so?
Authority. So the assistant commissioner has while rejecting the refund application filed by the respondent, the assistant commissioner has claimed that.
Come in the departmental appeal. Can you please read section 34 and tell me which part of that section you will fit into to come before this tribunal? Because please help them with 34. Which part of 34?
34 section 1.
Which part of 34 subsection 1 are you agreed upon?
So it was in the first point where.
What are the circumstances under which credit note can be issued?
So the credit note can be issued in case if there is any difference in the taxable value or the tax issue which they have already issued in the tax invoice, which was found to exceed the taxable value. So in the present case, the taxable value which they have issued,
He cannot issue credit note. He cannot issue.
Here when there is no service, but they have issued the taxable tax invoice.
Credit note. So why are we arguing saying credit note should have been issued? We cannot issue credit note.
So but the corrective action they have to issue the credit note.
We will see what corrective action is later. You agree with me first, and I will record it saying 30 provisions of 34 relating to credit note will not apply. Yes or no? Yes or no? The four conditions or four circumstances under which credit note can be issued. You don't fit into all the four conditions. Therefore, credit note cannot be issued. Therefore, you agree with me, and I will put it on record that the provisions of 34 do not apply. We will see what applies. We will see later. Can I record it?
No, the section
Because can I record it? Can I record this? Because appeal goes no further after I record. Appeal stops. Appeal stops at this point.
Yes, sir.
So we stop.
There are further more problems.
So you give up this ground. Will you withdraw this ground? Will you withdraw it? Will you withdraw this ground?
Yes, Your Honor.
Huh?
But actually, as per the section, I mean, as per the
Because
section,
please explain them the difficulties in withdrawal.
If you see that this is not applicable, then quickly only what
Please.
you have considered in your appeal.
Your court friend, you can't take so much time quickly, huh?
so section 34 will tell that if the tax invoice is found to exceed the taxable value, where the exceed in the sense that even when there is no, here in the case, the value of the invoice should be.
That one word. Huh?
Yes.
All right, go ahead.
If services are not provided by Hyderabad branch and showed in the GSR one-off branch, they should have issued a credit note as required under section 34 of the CGSTR to their client, so that IGST which they have already paid and reflecting in the GSR 2A of the client will be rectified and will be reversed. Unless specifically provided as provided under section 34, if credit notes are not raised, and included in the GSR 1 of Hyderabad, the same cannot be treated as corrective measure. The availability of ITC to their client and will be undue benefit as long as the invoice of Telangana included in GSR 1 of Telangana, and in the absence of any corrective measure, the actions required to be taken by entirely independent of each branch different in the state under GST. The payments made at Karnataka at a later date cannot be treated as a corrective measure as long as the required corrective measure is not taken place in the Telangana.
Paid the tax, right?
Yes, sir.
Paid the tax.
Yes, sir.
Originally also.
Yes, sir.
Originally
Yes,
in
sir.
Hyderabad.
Yes, sir.
When he reflected the corresponding turnover in GSTR 1 and in 3B,
Yes, sir.
taxes were remitted by virtue of the credit available, right?
In
By
Hyderabad,
setting off
in the Bangalore.
Hyderabad.
No, in the Bangalore. In the Hyderabad, they have paid the tax in cash.
Telangana, I mean Karnataka,
Using an input as
later date.
Bangalore payment, Hyderabad setting off. No,
No.
Yes.
So they have actually paid the tax in cash in Hyderabad branch.
Declared in Hyderabad are actually relating to services provided, and the same was paid by utilizing ITC available in electronic.
It's a mistake in the tax.
Mr. Amicus, are you coming to this court and telling me that there is a mistake in the grounds
No, the
of
way they have
without even
presented-
filing?
They've misworded the language where subsequently
The court has to go into the language employed to find out where it is wrong.
They apologize. They should have actually what they
It is not apologizing, amicus need not apologize.
yeah, they should have written here at the subsequently paid in Bangalore to utilizing credit. That is what they want to tell us facts.
All right, go ahead.
Please.
As that was, as I have not raised any GST credit notes, and later which they have declared in the Karnataka cannot be treated as a corrective measure as long as the required measure is not taken place in the return of Telangana. Accordingly, the Assistant Commissioner has rejected the claim of refund which was in form GST RES 06 by ARN AA 360.
Please proceed.
Further, Mrs. MLR has filed an appeal with the Additional Commissioner bearing number 106/2021 RRGST ADC dated 22nd September 2021 against the form GST RFT 06 dated 28th May 2021 passed by the Assistant Commissioner of Central Tax Kachipoli GST Division. Mrs. MLR has filed an appeal bearing on the grounds that the conditions specified in section 34 of the CGST Act for the issue of credit notes are not satisfied and claimed that they have taken the corrective action by amending the inadvertent misreporting in its monthly return in the months of August 2020, strictly following the procedure laid down in the circular number 26/2017 GST dated 26 December 2017 and the provisions of section 37 and 34 of the CGST Act.
We'll come back to the circular later. Go ahead.
They have also stated that the decision of Honorable Gujarat High Court judgments in the case ONGC versus Union of India, even in case where any amount is paid by way of self-assessment, in the event any amount has been paid by mistake or through ignorance, it is always open to the assessee to bring them to the notice of the authority concerned and claim refund such amount wrongly paid. The authority concerned is also bound to refund such amount, as retention of such amount would hit by Article 265 of the Constitution of India, which mandates that no tax shall be levied or collected except by authority of law.
He did not collect, you declared. Nobody collected.
Yes.
He is right in asking for refund, right?
He has requested the authority for requesting the refund which he has paid erroneously.
Okay, so he is right. Appellant is right.
Yes, sir, appellant is right.
No, sorry, respondent is right.
The respondent is right in claiming the refund of tax.
This decision supports him.
Yes.
It supports him. It's against you.
Yes.
It's against you.
Yeah, the additional commission has passed order against the GST RFT 06.
This decision supports them.
Yes.
Still in the facts.
Huh?
Still in the
It's
facts.
still in the fact.
Oh, this is the facts. Okay, all right. Thank you. Go ahead.
So by reviewing the documents or details which they have submitted, additional commissioner has set aside the implemented order passed by the lower authority and directed to issue the refund. Additional commissioner has allowed the refund and directed to issue the refund. So on the grounds that they have not taken any corrective measure in reversing the GSTR1, which they have declared in GSTR1 in Hyderabad branch. We wanted to go for we have appealed against the order issued by the additional commissioner of issuing the refund.
Which additional commissioner? Additional commissioner of
Additional
which
commissioner
state?
of Central Tax appeals from Hyderabad.
Okay.
He's from Gachibowli division.
Okay. Okay. Fine. What happened?
So we are appealing against the order which additional commissioner has passed on the grounds.
Who has authorized you to come in appeal? Who has authorized you to come in appeal?
That is, Commissioner of Central Tax has authorized
Commissioner of which central tax? Which state?
Hyderabad.
Show me that order.
That is the order which we have asked for, requested a time of 1 day. Tomorrow will be submitted.
No, that is I got the power of attorney which you asked me for time. You didn't ask for time for furnishing. The commissioner's order is not furnished now. There is no question of hearing the appeal. Appeal stops now. Because there is no cause of action for you to come here. Don't come here. Don't waste the court's time. Because
My lord, they have only this order which appears to be incorrect. They will rectify that error. I mean, it appears that they have enclosed.
which is that page? Because the
11, page 11, that's the only authorization.
Page 11 cannot be entertained.
Sorry.
Review part by Commissioner Karnataka cannot be the cause of action for filing appeal before suspension. Not possible.
So we
I
apply.
have to perforce reject this appeal before admission. Appeal not maintainable.
It appears that they have
Rejected as not
enclosed the wrong
maintainable
order.
under law.
It appears that they have enclosed the wrong order. They will furnish the copy of the order
So
by the
amicus,
Commissioner of
the
Telecom.
appellants don't have the habit of checking through the documentation before they file it. What is the registry doing, amicus? Is the registry up to the mark or not up to the mark? Do they need some strictures?
Maybe given guidelines as to what are to be checked.
Guidelines are there.
It is given also there we given guidelines.
Proceed.
See on the grounds that and the respondent has not submitted any proof other than purchase order which they have, by which they are claiming that service has been provided only from the Bangalore and not from the Hyderabad. So on the grounds of this, and they have not provided any proof that on what basis they have declared the turnover in Hyderabad branch, as there has to be an invoice referring to the order which they would have.
They are saying they have inadvertently declared.
On what
The
basis?
accountant, while opening the GST number, has put the Hyderabad GST number instead of Karnataka GST number. That's all he has done. He's not done anything else. He's saying the exact 33 lakhs or whatever is this number, he's opened the Hyderabad GSTR 1, key is there. Instead of GSTR, of the GST of Karnataka. What is the difficulty? What is the difficulty?
But when
He
they
subsequently rectified.
so when there is no proof that the rectification which they have
He
made
will
is
give
correct.
proof from Bangalore saying he has subsequently remitted tax physically. Give you proof.
But what is the proof that they have not submitted any proof?
You write to the Commissioner of Karnataka and find out. Why are you complicating matters?
No, what is the proof that they have not?
Right. Why should he give
No,
you
the
proof? You
relating
give
to
notice, he
Hyderabad.
will give you proof. You give notice, he will give you proof. He has already given proof. He said it is an error. Nothing has changed. There is only one supply. And that one supply is supply of service. There can't be supply of two services of the same invoice. How can it be?
But they have declared it. No? When they have declared it,
He is saying yes, he has declared. He is not retracting from that. He is saying yes, I have declared. My lord, the accountant, instead of opening Karnataka GST, he has opened Andhra GST because we have branches across India. And this has gone in there inadvertently. We have voluntarily rectified, is what he is saying under 996. So voluntarily rectified. He has not waited for you to give show cause.
but what is the proof that they are telling that it was inadvertent?
We will ask them. Continue.
And the additional commission has also allowed the appeal for the application of refund of tax on the ground that tax which was erroneously paid in Telangana is subsequently paid in Karnataka.
So if the additional commissioner Gachibowli is not correct, he is correct.
They have paid, but on the ground that they have paid in Karnataka, they cannot.
He is paid there. There is one supply. He made an error.
What is the proof?
That is why Gachibowli commissioner has allowed the appeal.
Yes. But the additional commissioner who has passed the order has not verified on what basis they have not made any. I mean, what is the proof that there is no supply has been made from Telangana, because they have already when they have already issued a tax invoice from Telangana and they have declared the same thing in GST returns of Telangana. But why? I mean, on what basis they are telling that?
He is not issued tax invoice from Telangana. He is issued tax invoice from Bangalore. He says tax invoice is Bangalore. PO is there from Bangalore. I have branches across India. By only mistake that I have done is uploaded in Andhra portal. I have not uploaded in Karnataka portal. That is all he has done. That is his
Change of website. Actually, invoice also is from Telangana.
invoice is also from Telangana.
They have issued an invoice.
Invoice is Bangalore is the factual position. What is the difficulty?
When they have issued an invoice, they issued from Bangalore. No, they have issued from Hyderabad also.
Let us see. Go ahead. Let us see.
And the respondent has erroneously declared the sales in May 2019.
Sales?
I mean output.
Output?
They have erroneously
Outward supply.
Outward supply. Okay. Outward supply in May 2019. Once it was filed in GS7, the same will be available for the recipient, which will give an undue advantage to the recipient of claiming extra input. So, and they have not made any corrective action by issuing the credit note as specified under section 34, subsection 1 of the CGS Act 27. Based on these grounds,
so you are saying the order passed by the learned first appellate authority ought to be rejected, refund ought not to be given.
Yes, sir.
Simply because you made one mistake. Am I right?
Yes, sir.
Am I right?
Yes, sir. Because they have not made the corrective action.
Anything more? Anything more? Amicus certified 2 documents, inform the registry accordingly, the head file proper authorization.
Yes, sir.
And it has been recorded that they will do it tomorrow. No further time will be granted because you are sought only for 1 year.
Okay.
Please.
Before I proceed with the cross objections, I would like to point out their claim that we have not furnished invoices. We have actually submitted invoice copies and purchase orders at the adjudicating authority level, and it is also attached to your reference in pages 25 to 28.
Pages 25 of appeal papers or your cross objections? Cross objections. 1 second. Page 20. Yes, go ahead. Go ahead.
So if you will be pleased to have a look at the purchase order, you will see that both the purchase order.
Give me 1
and-
moment. 1 moment, please. 1 moment. Yeah, I am on purchase order at page 25.
The purchase order is also being raised. The address, if you will be,
Yes.
is at the very top. It says Bangalore,
Yes.
and the invoices on page 27 and 28 have also been raised.
1 minute. 1 minute. 1 minute. You're a little slow. We need to look at the papers. Page 27. Yes.
Yes, Your Honor. So the address that is there at the very end of the page is clearly mentioned that the GST number starts with 29, which indicates the fact that both invoices were raised by the Karnataka establishment. So the fact that the sales were reported in a different establishment from where it was rendered, and the fact that we have proof for that is clearly only an obvious, glaring and a self-evident mistake, and we submit that there is no need for further argument or evidence. The second ground that was raised by them was that the learned additional commissioner did not have jurisdiction because he rejected the order he allowed the refund on the grounds that it was subsequently paid in Karnataka, which is factually incorrect because the order passed by the appellate authority is on the basis that they were not required to issue credit notes and not on the basis that it was subsequently reported in Karnataka.
So how does that make a difference? The FA's order. Are you aggrieved by his findings or are you aggrieved by his order?
I am aggrieved by their appeal, sir.
That is not the point. You have to come up before me and say whether you are aggrieved by the findings or aggrieved by the order.
I am not aggrieved by either.
I just thought you said based on PO, based on credit note, and not on.
So I was countering their appeal that we have not submitted purchase orders or invoices.
Alright. So what is your grievance?
My grievance is when they say that the learned officer has no jurisdiction to issue a refund simply on the grounds that it was subsequently reported in Karnataka is incorrect because those were not the findings on which the order was issued. The findings were that the credit note cannot be issued, which takes me to our third ground of cross objection. They say that we have not initiated any corrective measure in respect of ensuring that an undue benefit does not accrue to the recipient. We have amended the invoices. So in GSTR 2A in the B.
Can I pause you and take you one step behind?
Yes, sir.
Under which provision of law are you claiming refund?
We're claiming under section 55, sir.
Huh? 54 which subsection?
54, subsection 8.
This is. Madam Counsel, please read.
Subsection 8, clause C, which says refund of tax paid on a supply and for which invoice has not been issued. So we have not issued an invoice in respect of this supply.
So why did you pay your tax? This is that money you paid.
So we paid it
You thought you had too much money and therefore you paid.
We paid it inadvertently in Hyderabad.
Which means on basis which document you effected payment of that tax? Basis which document? Because it is in rupees and paisa, if you are paid on 10 lakhs, I can understand. Because it is rupees and paisa, it is based on some document. Which document was the base document pursuant to which you paid your tax?
So it was paid inadvertently. What was supposed to be paid in Karnataka was paid in Hyderabad.
That's it. So your grievance is only that.
Yes, sir.
So how will you fit yourself into 54? Subsection 8. How will you fit yourself into 54A? Huh? So under which provision we are coming in appeal? Amika, please tell them.
Subsection 1 of section 54 does not specify instances in which refunds may be applied for. So any tax that we should not have paid but have yet paid, we are applying for a refund.
All right, proceed.
So section 34, if with your permission, may I introduce section 34?
I am aware of 34. Continue with the
So
argument.
section 34 clearly stipulates that credit notes can only be issued when a supply has actually been made and when a tax invoice has been paid. So in the instant case, there was no supply and there was no tax invoice, so we cannot be mandated to issue credit notes. And with respect to the undue benefit accruing to the recipient, we have amended the invoices to ensure that such benefit does not accrue to the recipient.
Can you amend the invoice? What is this argument you are now coming up and saying I have amended the invoice? How can you amend invoice after it's issued?
So we can amend invoices in GSTR 1, we remove, withdraw.
Stay in the portal.
Yes, sir.
Stay in the portal.
We have brought the taxable value and the tax down to 0. So it will be populated in GSTR 2A and the recipient cannot claim into tax credit. So whatever corrective action is necessary from our end, we have initiated it. Those cannot be grounds for the tribunal to reject it.
Rent is now coming up and saying it was an inadvertent error. I cannot be hanged for an error which was inadvertent in as simple as populating a GSTR 1. They say you have no documentary evidence to prove that a supply took place in Hyderabad. You don't have any documentary evidence. On what basis are you coming up in appeal? Is there grievance? Is there argument? Do you have any counter? Do you have any rejoinder?
So though they have inadvertently declared
Yes.
the
They admit it is inadvertent. They admit.
though they have inadvertently, there has to be basis on which they have paid the GST, on which they have
That
paid.
invoice was the document. That invoice was the document basis which he paid.
But when it comes to section 54 subsection 3, sir, like where on
She's not on 3, she's on 54(1). Madam Counsel, am I right?
Yes, Your Honor.
Huh? He's not on 3. She is coming up on 1. Madam Counsel is coming up on 1. Madam Counsel is not coming up on 3 subsection. Quickly, court is running out of time. We have to close in the next 5 minutes. Yes. Yes, Mr. Counsel.
Sir, the appellant has no further grounds to.
So appellant does not want to even negate the arguments of the registered person as regards the purchase orders, as regards the invoice, as regards the. Nothing more, we can take it on record, no further argument. We close it. We close it.
Your Honor, we accept the refund which they are claiming under section 54(1), but since they have not made any.
So you give up your ground?
No, the section under which they are claiming is correct, but the reason like they have not, since they have not
The section
taken.
under which they are claiming refund is correct. If that is an admission of fact, then they are entitled to refund. Appeal closes.
But they have not made any corrective action. As of
thought, Madam Counsel said corrective action has been taken, court has been corrected, and therefore they have been converted to zero. Because am I right?
Yes.
That was the statement
Yes,
made by Madam Counsel.
Yes.
when there is a tax invoice, they have to issue a credit note.
It's an error. Madam Counsel has come up with an argument to say, yes, my lord, it is an error. Amicus, you cannot argue on behalf of the appellant. You cannot argue.
No, I'm just trying to get in.
Amicus is a court's friend, not the appellant's friend.
That is the only ground we have, Your Honor, telling that they have not made any corrective measure for by issuing of credit note.
All right, court has heard. Anything else? Any rejoinder, Madam Counsel? Close. This court places on record the efforts of both the amicus, Rajesh and
The vote is done. Kavita, give me some.
Sure, sir.
To completely sort out the proceedings now. The two amicuses were here. Although they are court friends, they were teaching them the provisions of law. So we go through the entire gamut of preparation. Now, if we look at the gamut of preparation that we have, if we look at the entire gamut of preparation that we are talking of, if we look at Moot, now, some basics that we learn before we go to the tribunal, but how we file these appeal papers. Appeal papers are not a piece of trash. Appeal papers are to be bound, serially numbered, with adequate attention. You saw in one of the appeals that the appeal is filed even before the order is served. Now, you can come here to the court and say it is an error. I will not even admit it. If I have to dismiss your case, I can find the flimsiest of reasons to dismiss your case. On the contrary, I can proceed under Rule 116, saying the counsel has already prepared the appeals before the tribunal because the order before it was signed was known to the counsel. So you have to be extremely careful when you fit in the dates. Now when we come before that tribunal, there is no more sales, no more purchase. Good number of appeals here are using the word sales, using the word purchase, using the word turnover, using the word claim, pay. We have to be extremely careful when we use the words under law. We have to be extremely careful. No more sales, no more purchase. They are only output or input, finished, period. Now while I don't want to take a position on whether an appeal succeeds or appeal fails,
I have to place some regard that as students, you have put in an extraordinary amount of effort to come up with this. I think you deserve a round of applause. I don't think 30 years back when I was a student, I would have come up to this stage. I don't think I would have. 30 years later, I can stand here and talk many things, but 30 years before, I don't think I would have done. But attention to detail when you file appeal papers. On the simplest of grounds you can succeed, on the strongest of grounds you can fail. On the strongest of grounds you can fail. That is why when you prepare and come, you should think that the other man is better than you. The court in its wisdom, it has seen hundreds of cases. For you it is only one case, for the court it is 100 cases. So it knows. It knows by the time you stand in front of him, the court knows whether the man is alright or man is not alright or man needs a reprimand. Court knows it. Therefore you have to be extremely cautious. You have to be considerate. How do you prepare these facts and grounds? That's why I said, don't deviate from the facts. If you deviate from the fact, appeal closes. Finished. You are not going to succeed. And when you are on grounds, you need to attack what is your grievance. Why are you aggrieved? Why have you come in appeal before the tribunal? Most of these appeal papers that are before me did not tell me what is your grievance against the First Appellate Authority's order. What is the grievance? Why are you coming here? You have to tell. Page 4, para 12, line 3, quote unquote. This is what the learned FA says. My lord, this is wrong. He cannot give a finding saying I take a lenient view and allow the appeal. Nobody can be lenient. You have to follow the law. You have to follow the law. Therefore, every single sentence of the learned FAA must be seen with a magnifying glass and you have to attack that. If you don't attack it, you will have no recourse to further action. The tribunal is the last fact-finding authority. After this, there is no fact, there is only law. There is only law. So if you miss that fact now, you can't add that fact later. You cannot add that fact later. Therefore, the simple facts, like that in that 129, section 129 case, the field formation should be taught to see which is the truck which carries 20 tons of steel which is possible to be carried. You haven't seen that. You had to see it. Like in case 3, Commissioner Karnataka directs Commissioner Andhra. You go and file a, who is Commissioner Karnataka to tell Commissioner Andhra to file appeal? You have nobody to tell. Commissioner Andhra will do his job. Commissioner Karnataka what to do his job. You ought to do his job. He will do his job. Don't worry about what he will do. Now, these are raw facts. Raw facts which you have to be extremely careful of when you prefer an appeal. Now you come to the first case that was there. First case. I think this was the case relating to levy of penalty, if I am right.
Beyond the scope of the A70 13 and
the section 62, read with section 46. Now the scope of 46 and scope of 62 is what you need to attack. That's where you need to attack. No show cause notice was given, no opportunity. 62 does not tell me I should issue a show cause notice. Who says under 62 under 62 I will pass a best judgment assessment. Period. Over. Over. That's it. Now, look at the situation there. The First Appellate Authority under 107 determines a position or determines the tax, saying that your rate of tax is 18%, but you have paid 5%. That's your grievance, right? Paid 18%, but you pay 5%. Look at the appeal papers. What is your grievance? Your grievance is 13%. Correct? Your grievance is not 18. Your grievance is 13. Your grievances is the very classification. You never attack the classification. I didn't find a single ground on assemble. Tour operator versus passenger services. I didn't find a single ground. No ground. Tomorrow what will happen? Let us assume that you don't have a grievance on that and you get classified as passenger transportation services instead of a tour operator or vice versa. If the rate of tax for that HSN changes, you are finished. You can't go back again. You cannot. Today, fortunately for you, all are 18 or all are 5 or all are whatever rate. Therefore, you are lucky. Now the attack must be that. 2. Input tax credit that we are talking of. There is no reconciliation. 4662 says one number. First appellate authority says another number. You have come in appeal on a third number. Who is to reconcile this? Court doesn't have time. Court doesn't have time. Court will tell you, you go reconcile all this and come. That's all. Date will go for 3 months. Date will go for 3 months. Now when we come in appeal, we will have to be over cautious with all of these facts. The second appeal which came under 129, transportation. You can't highlight court papers. You cannot do. You cannot put index and you cannot. You can give annexure numbers. But when you highlight paragraphs, you have to say whether emphasis is applied or emphasis is not supplied. Don't tell the court that this is in bold letters, please read it. You say emphasis supplied. In the original order it's not like this, but I have supplied this emphasis here. Right? 3. Don't rely on case laws. I always tell young children, students, a decision only cements or uncements the factual position. Be strong on facts. Be extremely strong on facts. A court decision can only support thus far, no further. It will not take you further. It will stop you there. Beyond that, you cannot travel. So don't rely on judicial pronouncements. When you apply circulars, be extremely careful. Like when you came under circular for 126. All right, he has given 5 examples there, or 6. This man is 7th example. This man is 7th, example number 7, it is not there in 6. So I will tell you, my lord, that circular quotes only 5 instances. I am the 6th instance. Therefore, that circular is not binding on the lower authorities. In any event, it is not binding on the tribunal. So I will tell you it is not. So reliance on the circular doesn't help. Doesn't help because those are instances that are given. You have to fit yourself into that instance. If yes, you go into that bracket. If no, don't quote that unnecessarily. Don't quote that unnecessarily. 3. Provisions of law are required to be read and construed strictly. You cannot import something which is not there. You cannot import. If you import, you are misleading the court. You can be reprimanded. Some of the best counsels in Bangalore have got strictures. Rajesh will know it. Not because they misstated facts. It is simply usage of words by virtue of which strictures were passed. So your entire reputation of 35, 30, 40, 50 years is at stake when you stand before a court and make your arguments. Trust me, no court is going to guide you the way I guided you. Remember this saying, when a judge opens his mind in the courtroom, he loses his discretion in the chamber. Which means, if I am asking you questions here, you are thinking that this is the basis in which orders will come. And I am bound to do that. But court will not talk like the way I talk. It will simply listen, that's all. Here and there, in passing they will ask you some questions. Otherwise court will not talk and guide. Court will not take you through. You want to read, you read. You don't want to read, it will tell you, all right, we know the provision, proceed. That's all. So he won't give you time. He has 100 cases. Today at 1 hour for one case. Some of the best counsels don't get 15 minutes. If I stand before the tribunal, I have to plead for time. So you have that initial 5, 6, 7, 8 minutes. With that, if the court believes that you have a case, they will tell you, proceed. Otherwise you know your fate. You know your fate. You don't get time like how Kavita madam was good enough to give you 1 hour, 30 minutes for appellant and 30 minutes for respondent. You won't get. So best counsels don't get. When I stand before the tribunal, I get 2, 3. Judges will tell me, Venkat, finish it in 5 minutes. Huh? How do you finish a 50 crore case in 5 minutes? That's the time you have. And in that time, how quickly you can think on your feet, how much of preparation that should go into it. A 100 crore case like Oracle which you fight, you get 5, 10, 15, 20 minutes. Imagine if you have to fight, client will be waiting there. He will be looking at your face. He will tell you what you are not talking. What do you talk? So in that 5, 10, 15 minutes, you set the facts, you set the position of law, you argue, you conclude. This is the time you have. This is the time you have. Think through. I'm very happy to see so many young girls come or young ladies come here. I think this is a fantastic profession, litigation. Trust me. It makes you think on your feet. It improves your presence of mind. It makes you highly skilled. Yes, there will be good and bad days. There will be good days, there will be bad days. But we have very few women who come to the courthouse. Very extremely few women. Presume all of you who came here together with your friends, I will have the fortune of seeing you all in some court somewhere someday, so that I am extremely happy to see you all. Good effort all in all. Thank you all. Any questions, please give them 5, 10 minutes, please.
Anybody have any questions? Now I request our SICASA chairman and our chairman sir and secretary sir and Ida madam to come on stage.
Nice to see you. Such a long Thank you so much. It's a pleasure. Thank you. Gita madam, thank you. Come.
Now I request our mentors, Rajesh Kumar sir, to kindly come on stage. And Amita ma'am and Venu sir to kindly come on stage. It's a small token of thanks from all of us.
I must tell you the effort that Rajesh, Annapurna, Venu have put in. Could not have Kavita has taken, I know the kind of pains that she has undergone after she talked to me a month back. So I think Kavita deserves a hand as well.
Thank you, ma'am. Thank you very
Wish
much.
all the best. He has come here despite his personal inconvenience. He has a lot of things to handle at home. I think he deserves it.
lot of help and support from Kuber and Siddesh. Thank you so much.
I request Venkatramani sir to announce the winners.
No, I think you are Kavita. Yes. Kavita call.
So we have two prizes, winner and runner-up. So any guesses for the runner-up? Ranjini and Ratan. I'm not disclosing the marks what you secured, but then you've done well. Congratulations.
Come. All the best. Thank you.
And the next one, the final one. Any guesses here? At least this must be clear. Nishchita and Neha. Congratulations.
All the best. Chairman sir. All the best. You are Nishchita. All the best. Thank you. All the best.
Thank you.
To take so much effort and participate in this, it takes a lot. So I would request,
Stand up, please take a picture. Won't get this opportunity. Stand up.
I would request all the participants also, as when I call to come on the dais. Maurish and Lokesh.
Both of you made a good effort, huh? Good effort. Good effort. All the best.
Amika and Sakir.
Cycling showed a lot of confidence.
It was not just letting down, giving up so easily.
You were just pushing the bench.
Yes. One more
Yeah.
point.
Good. Very good.
Somansya and Pankaj.
Good effort based on the.
Shreya and Bhaskar.
Both Shreya and Bhaskar also, huh?
But it took me 30 years, no? And I still know nothing. All the best. Group photo आएगा. And I think the participants are the ones who have to stand and take one group photo. We can always go down. आगता?
ಇದು ಅಡ್ಡ ಇದೆ ಅನ್ಸುತ್ತೆ ಸರಿ ಬರಬೇಕು
I think one row you can take.
All participants can come in front of.
Come in the front. All participants can come in the front. Madam, come here. Come here. What's the problem? Please come here. Why are you going back? Come over. Come in the front. You won't get this opportunity. Come, please stand.
Bunny, Monesh.
Everyone of you has witnessed the wonderful moot court competition that has conducted in the field of goods and service tax. Now it's time for income tax. So for this, I request Kavita, SICASA Chairman Kavita ma'am to escort the bench member C.A. Suman. Suman Ladkar is a chartered accountant and lawyer with over 14 years of post-qualification experience. Suman Ladkar primarily focuses on advising clients in income tax litigation and represents clients regularly at various forums, including and up to the appellate tribunal. C.A. Suman Ladkar focuses on complex matters such as those involving search and seizure and corporate taxation, and cases handled by Suman have been reported in tax application. She is presently working as a consultant for Mrs. H.C. Kincha and Co. We welcome you, ma'am. Along with the bench member, we have our wonderful mentors, C.A. Ravikar, C.A. Siddesh Nagaragari, C.A. Deepak Chopra. C.A. Ravikar heads the litigation wing of direct taxation at TSMD. He has over 6 years of rich experience in the field of corporate taxation, advisory and litigation. He has represented clients before various tax authorities and has co-authored articles on issues with respect to taxation. Post-graduation from Christ University, he started his articleship with PMR Advisors and later joined TSMD Bangalore. He is actually associated with KSCAA and he is part of Direct Tax Committee for 3 consecutive years. We welcome you. C.A. Deepak Chopra, he is a fellow member of Institute of Chartered Accountants of India and has graduated in Commerce from Bangalore University. He qualified as Chartered Accountant in the year 2011. He has a strong passion of direct taxes and has been regularly taking classes for students of Company Secretary and Chartered Accountants course. He is a regular faculty member of Bangalore branch of ICAI for direct tax classes for students of CFI. He has also been a resource person on direct tax matters at various forums including at Bangalore, Tumkur, Devangiri, Hyderabad, Bangalore and Rock. He has been resource person for sessions hosted by committee for members and graduates. He has also been faculty for officers of Income Tax Department at the Direct Tax Regional Training Institute, Bangalore. He is also a Direct Tax Committee of KSCAA, Karnataka State Chartered Accountants Association. He is currently partner in Deepak Neeraj and Associates, where he heads the Direct Tax Division. We welcome you. I request Sridhar to welcome. and the third mentor, C.A. Nagaraj. He is a practicing chartered accountant in Bangalore since 2008. He is practicing in the field of direct taxes and he is mainly into tax litigation practice and has represented at various levels. His focus area includes transfer pricing and international taxation matters. He is partnered with Messrs. Ramesh Ashwin and Karnath in Bangalore and was partnered with NCS and Co. Bangalore and Karkala. He worked at consulting firm BMR and Associates LLP, litigation firm KK Chaitanya Law Chambers, audit firm K. Godrej and Company, and Gemini Professional Services Private Limited. We welcome them. Now we shall proceed for court proceedings. I know most of you have already gone through the rules, but here is a quick small glimpse of the rules of Moot Court competition. The Moot Court Tribunal is for income tax and GST. The objective of this competition is to improve the representation skills of the students and the focus will be on how well students present their cases. Language of the proceedings will be in English only. The students will have to present their case to a single member bench. Students are required to present their case orally and no presentation such as PPT or computers are allowed. However, they are permitted to use hard copy of PARAC, case laws and even provide the copies of reference material to the bench. There will be only one round. Each team will have 2 students. Students can argue for and against the FSC or the dealer. There will be 4 matters, each for argument under income tax. Students will be provided with the decided cases for argument. They will have to prepare their own argument based on the precedent argument. The students will have to present the case within the time allotted. The time allotted is 15 minutes plus 5 minutes for each team. Only one student is allowed to argue at a time. Both the team members can argue one after the other person, or one student from the team can present the whole case. The students are requested to come attend here, and for male it is white shirt, black trousers, black tie, black coat and black shoes, and for female white salwar and kurta or white shirt and black trousers along with a black coat and a black shoes. Please silence.
ITA number 1001, Bangalore 2022, Element Mines, please stand up. ITA number 1002, Bangalore 2022, Case 2, XYZ Jewelers Private Limited. ITA number 1003, Bangalore 2022, Case number 3, Srimati R.R. ITA number 1004, Bangalore 2022, case number 4, HDC Private Limited. ITA SC number 1001, Bangalore 2022, case number 1, 11 months.
My lord, we will be representing 11 miles.
Sorry to interrupt. We are in ground on admissibility of the appeal because the appeal is not certified. The officer not certified and there is no appeal chala finding me on the evidence. Chala it's not a
Then the defense memo is issued to the appellate from the registry. Registrar. Whether you got any defense memo?
no.
Whether appeal challan is filed with the appeal memo? Please provide the copy to the reporter. There is a procedure to file the appeal with the Inauguration. What should accompany the appeal memo is prescribed in the income tax tribunal rules. You have to see the rules and then prepare accordingly and submit. Unless the papers are proper, this case cannot be heard. This is in the normal course of the proceedings. Assuming that you have filed the appeal challan, we will proceed, and during the course of day you have to file the challan to the registry so that we will see to it, and if all the defects are pure, we will consider the case as heard. Otherwise the case will not be heard.
If your lordship can permit, if you can have password meeting challan.
Fine. You will get it right?
Right.
And is there any other defect that you are pointing it out?
Form 36 is not certified.
Whether you got a copy of the certificate, you please provide, I will pass it over. You can cure the defect and then article. Pass it. Extras.
Yes, please.
ITA number 1002, Bangalore, 2022, case to XYZ Jewelers Private Limited.
Is there any defect? No? You can proceed.
Good afternoon, Your Honor. I am Bhavna, myself Ashita, and we are in the capacity of representatives to XYZ Jewelers Private Limited. It's a private limited company. So to brief you on the facts of the case, this appeal for assessment year 2019 is filed by the appellant, a private limited company, being agreed by the intimation dated 29th July 2020, passed under section 143 subsection 1 of the Income Tax Act 1962. For the year, the appellant had filed the return of income under section 139 subsection 1 on 31st of October 2019, declaring a total taxable income of rupees 29 crore 41 lakh 91,900. The appellant's books for the year under consideration were also duly audited under section 44AB of the Act. In the tax audit report in Form 3CD, which has been attached to you for your reference, page 103, under clause 20B, the appellant's tax auditor had reported the fact that there has been no delays in remittances of employees' contribution to Provident Fund and employees' state insurance. However, the appellant was further served with a notice under section 143(1)A of dated 14th February 2020, proposing to disallow a sum of rupees 3,23,827 on the basis of reporting in the Form 3C, due to which there arise an additional tax liability of rupees 1,38,169. Your Honor, for this notice served, the appellant also filed a response well within the due date on 19th of February 2020, and the response filed was filed online under the Proceedings tab. The response has been attached for your reference in page 121. So the appellant disagreed with the proposed disallowance and filed a response that all the payments have been made before the due date mentioned under 139 subsection 1, and it has also been mentioned by the tax auditor that no disallowance is called for in light of High Court jurisdictional judgments in the case of CIT versus Sabri Enterprises. So therefore, on account of character constraints, Your Honor, we could not file a more descriptive reply on the e-proceedings portal. Further to this above appellant's reply, there was no other response served by the Income Tax Department. Thereafter, the appellant was served with an impugned intimation under section 143 subsection 1. And a sum of rupees 3,23,827 being the remittance to employees' contribution to Provident Fund and ASI was disallowed, and the taxes were computed accordingly. So agreed by the disallowance of rupees 3,23,827 and the levy of interest thereon, the appellant is preferred this appeal.
I would like to take you through the grounds of the appeal. The first ground of appeal which we would like to argue on is that the learned assessing officer has erred in the passing the intimation in the manner it was passed. The intimation in itself is prima facie bad in law and is liable to be quashed. Your Honor, in the Finance Act 2016, the amendments were brought about in the Finance Act 2016 as to the assessing officer should send a notice to the appellant before making any adjustments. And the amended law also mandated that the assessing officer provide a reason, opportunity for the person to being heard. This is mentioned in the second proviso of section 143 subsection 1, that response received from the assessee, if any, shall be considered before making any adjustment if it is made within the due date. So even though our appellant has submitted the response within the due date, the response is not being considered, and even the impugned intimation fails to throw light as to why the response is not being considered or why it is erroneous or anything as such. Therefore, this is against the true spirit of law, and it violates the principle of natural justice in our opinion. And one of the fundamental principles of natural justice is the rule of audi alteram partem, which means that the other side be heard. So, Your Honor, the Apex Court in the matter of Assistant Commissioner, Commercial Tax Department Works Contract versus Shukla Brothers, they clearly described the doctrine of audi alteram partem, which said that a person to whom an order is required to be passed or whose rights are likely to be affected needs to be given an opportunity of being heard. So our ground is that they are not given this opportunity for us of being heard. Therefore, the intimation in itself, the manner in which it is passed is erroneous, and therefore it's liable to be quashed.
Counsel, they have issued proposed notice under section 141 before passing the intimation. So the moment they pass proposed judicial, don't you think they have given a proper opportunity and you have complied with that, you have responded to that? And moreover, you should understand that these are all, this particular order is not the regular assessment. This is not under 143(3), wherein the assessing officer calls for the recording order. This is 143(1) intimation. They just give you one notice, you respond to that, and they pass the intimation. So, this is the legal framework which is there under the Act. There is no one-to-one communication under intimation under section 143(1). So, this is the basic fundamental on which this particular 143(1) intimation works. So, 143(3) is different. I accept that whatever plea that you are taking, that is 100% applicable in the case of regular assessment, but not in the case of intimation. Intimation, the moment they issue a proposed adjustment notice and you respond to that, they should consider or they might reject. That is on their thing. So they have considered your reply. After considering your reply, they have passed the intimation, whether right or wrong, you are before us. So that way, that we will decide. But this particular ground, somehow, I feel this is not the thing. Next, we can proceed with the next.
Next ground we would like to argue is that the learned assessing officer has erred in the fact that he has not appreciated that the tax auditor of the company had categorically reported no disallowance is called for under section 36 subsection 1(5)(a) of the Act. So, I would like to bring you notice page 87. In that, the text of the permissible adjustments under section clause A of section 143(1) has been mentioned. It provides a list of permissible adjustments in processing of the income tax returns. Any adjustment which is made outside this permissible list of adjustments is ultra vires and is bad in law. Therefore, in this, if you can see that the arithmetical error, incorrect claim, and disallowance of loss and all the other permissible list of adjustments have been given. The adjustment made by the learned assessing officer does not fit into any other subclauses of section 143 subsection 1(a). So thus the disallowance which has been made by the learned assessing officer in the impugned intimation is on the basis that the disallowance reported by the tax auditor in the tax audit report has not been considered by us while filing the income tax return. So, however, it is pertinent to note that in the tax auditor in clause 20b, I would like to bring to your attention page 105 to 106. In the 3CD clause 20b, the tax auditor does not report any disallowance. The tax auditor simply reports the due dates and the actual date of payment. So, in fact, the tax auditor has categorically reported a non-disallowance in the observation segment. In page 102, in the 3CA observation segment, the tax auditor has mentioned that no disallowance is called for in light of the jurisdictional high court judgment. Therefore, the disallowance made in the intimation is beyond the scope of adjustments listed in section 143 subsection 1A. Then the disallowance being against the provisions of the law is liable to be debated in our opinion. To further argue on the merits of the case, I request my fellow representative.
One thing, counsel. See, if you see page number 105, the due date is mentioned as 31st of October 2019. However, as per law, the due date should be as per the respective acts, not this 31st October 2019.
Yes, Your Honor. On the basis of the High Court judgment CIT versus Sabari Enterprises, where the due date was taken as 31st 10 due date for furnishing of income tax return under 139 subsection 1. Because this 43B mentioned that the PF and employee's contribution should be done before 139 subsection 1 due date. It should have been passed. So therefore, we have taken that reference, and only the explanation to the memorandum for Finance Act, which was brought about, the amendments which were brought about, was done in financial year 2021. So therefore, this is not liable binding this assessment year.
Good afternoon, Your Honor. As my colleague has already briefed you on the technical aspects of the case, I would like to take you through the merits of the case. The SSC, as we know, had filed a return of income under section 139 subsection 1 duly within the due date, but there was no disallowance that was reported in the return of income as well. But in this case, the assessing officer has erred in disallowing such sum, being the remittance of employee's contribution, saying that there is a delay as per the relevant statutes. So under section 36 subsection 1 clause 5A, the assessing officer has disallowed the same. So Your Honor, in this case it is pertinent to note that though there was a delay in the remittance of the employee's contribution as per the relevant statutes, it very well needs to be noted that when compared to the PF-ESI laws, there is a delay. But when there are other sections 36 1 and 43B that comes into picture, it does mention that under section 43B, which says the specified payments which are supposed to be made within the 139(1) due date, that has been very well made. The summary of the payments have been given to you for reference. I would like to draw your attention to page 129 to 130. This specifies the paid date and the due dates as well. So if you can observe in the some months, even the due dates as per the relevant statutes has been considered, but the same has been disallowed by the assessing officer in those months as well. The 15th of the next preceding month will be the due date. So even after complying in certain months within those relevant statutes as well, the assessing officer has disallowed that amount as well.
Further, Your Honor, in a binding precedent of Principal Commissioner of Income Tax, Jaipur versus Rajasthan State Beverages Corporation Limited, the court had allowed the claim of the SSE in the same similar facts having similar nature, where the SSE had made a delay in payments as per the relevant statutes, but the same was made well within the due dates of section 139(1). The court has mentioned that the deduction can be claimed by the SSE.
Are you going to rely on some jurisdictional high court decisions?
Principal of Commissioner of Income Tax, Jaipur. That is the versus Rajasthan. That is the case. In the light of binding precedents and case laws, the mentioned disallowance has to be deleted. Further, when the provisions
Is there
of
any Supreme Court decision on this issue?
no, there is actually a recent judgment, but that is not applicable in our case because the assessment year is 1920 and there is it had come in the year 22.
Copy is available with you?
No, ma'am, but we're not relying on that specific case. Further, when the provisions of section 36 and 43 were brought to the notice of CID, the recent amendments brought by the Finance Act 2021 was under discussion. The learned CID had erred in taking the recent amendments to section 36(1) and 43B as retrospective in nature. But 43B of the Act specifies the list of deductions that are admissible under the Act only upon their actual payment. Employer's contribution is covered under section 43B, but the treatment with respect to employee's contribution is silent. But there are many courts that have applied the section 43 in employee's contribution as well and allowed the deduction to employer even when there is a delay as per the relevant statutes, but made well within the date of furnishing of income tax return. So the SSE is well aware of the newly inserted explanations. There were explanations inserted to section 36 and 43B as well.
So you are relying on any case law which says it is retrospective in nature?
Yes, ma'am. Yes, ma'am. Further, I will go through it. So as per the explanation, what the explanation says is that in section 36, it says that for the purposes of the word due date, the provisions of section 43 will not come into picture, as the word explanation says. In 43B, the explanation says that the employee's contribution, specifically, employee's contribution does not come in the picture of 43B, is the newly inserted amendment. So we have considered that amendment as well. The above explanations, however, does not apply to the present case of the appellant, as it is effective only from assessment year 21-22. I would like to draw your attention to page 192 to the extracts of the finance bill, which clearly mentions the same. If you can see the highlighted point, Your Honor.
Yes.
This amendment will take effect from 1st April 2021 and will accordingly apply in relation to the assessment year 21-22 and subsequent assessment years. So, in support of the argument that the newly inserted amendment is inapplicable to the facts of the appellant's case, the present case has to be considered. I would like to draw your attention to page 195 and 196. This is the case law which we are relying on, which is Messrs. Crescent Roadways Private Limited, Secunderabad versus CID, Hyderabad. It says that the facts of the case are very similar to the case in the appellate case. So if you see in page 196, it says that it is ruled, however, keeping in mind through the last 4 lines. Page 196. In the bottom right corner.
Yes.
However, keeping in mind the fact that the same has been clarified to be applicable only with prospective effect from 1/4/2021, we hold that the imputed disallowance is not sustainable in view of all these latest developments. So, in the light of above grounds, the explanation that is newly inserted is inapplicable in our client's case. The present case has to be considered on the unamended law, which is the law prior to these amendments. And the finance bill, as it clearly mentions that such amendments from the date will be applicable from 1st of April 2021. And therefore, the assessment year in question is 2019 and 20. So we request that since it is prospective in nature, the disallowance made in the case is to be deleted. And to conclude our case, Your Honor, I would like to request you to consider all the technical grounds that my colleague has been argued and quash the impute intimation. And if not, on the merits of the case that is clearly mentioned in the finance bill and the 36, the section 36 and 43B, we request a disallowance made to be deleted.
Your Honor, first of all, it is a defective return because the due date is 31st October 2019. As per the relevant statutes, it is 15th of the policy. Main point is that one, my lord. And the next one, directly coming to the conclusion, my lord, they said that they do not rely on the Supreme Court decisions. That is actually baseless. It is the apex of the decision making. We have to rely on the Supreme Court. And the Supreme Court, if you come to my lord, page number 34.
This is the Supreme
In the Supreme Court.
These are not numbered?
This number, page number 30.
Page number?
30. Supreme Court. The last.
Yes.
The 34th page number, point 55. It covers all the aspects of lending, XYZ jewelers. It says that the court does not find any reason to interfere with the impugn judgment. The appeals are accordingly dismissed.
This will not give you any help. You have to show me where exactly the Supreme Court is mentioning that section 43BB does not cover employees' contribution to PF. So this is there in this judgment. You just show me where it is.
Sorry to interrupt you.
You will be given your chance to counter the argument.
Not the counter argument. The copy of the DR is not. We have not
You
received.
have not. You should give a copy to.
Appeal they are relying on, so it's not given. Yeah, the appeal they are relying on.
Nothing. This is all the same thing that what they have. You have done. This is actually duplication of documents. Nothing new. There are some case laws which they are not referring at this. They are now relying on this Supreme Court decision, right? Please see to it that whatever document that you are submitting before the bench, a copy of which is given to the AR.
We is containing the point number 54.
Yes.
In the opinion of this court, the reasoning in the impute judgment that the non-constant clause would not in any manner regulate or override the employer's obligation to deposit the amounts retained by it or deducted by it from the employee's income unless the condition that it is deposited on or before the due date is correct and justified. The non-constant clause has to be understood in the context of the entire provision of section 43B, which is to ensure timely payment before the returns are filed, or certain liabilities which are to be borne by the assessee in the form of tax, interest payment and other statutory liability. In the case of these liabilities, what constitutes the due date is defined by the statute. Nevertheless, the assessors are given some leeway in that as long as deposits were made beyond the due date. But before the date of filing the return, the deduction is allowed. That, however, cannot apply in the case of amounts which are held in trust, as is the case of employees' contribution, which are deducted from their income. They are not part of the assessee's employees' income, nor they are heads of deduction for in the form of statutory payout. Their other income monies only deemed to be income with the object of ensuring that they are paid within the due date specified in the particular law.
So you rely on the Supreme Court decision. And what is your final conclusion?
The final conclusion is that they are directly heading into the section 139, subsection 1 of the Income Tax Act 1961, where the due date is, that is as per the tax rate if they are applicable, of the 44AB of the Income Tax Act 1961, the due date will be 31st October.
But as per 36(1) subsection 5A of Income Tax Act 1961, it clearly specifies as per the respective statute. Now, what are the respective statutes? They are EPF and ESL. And ESL is 15th of the following month. That have to be followed. They are not due to this.
The crux of the Supreme Court decision.
And the crux of the Supreme Court decision is that actually covers all the case. XYZ.
See, you rely on the Supreme Court decision. Yes, yeah. You want to counter the argument or you want to bring out some distinguishable points so that this particular Supreme Court decision is not applicable. See, this Supreme Court decision is a very latest decision. This has come on 12th October. So, probably yes. The matter would have been completely different if this Supreme Court decision would not have come. So now, this Supreme Court decision is the law of the land. So it is like we are, this has the binding dictum on us. So we will have to consider this into consideration in case if you want to distinguish particular issue on facts. This law is settled that 43P does not cover employees' contribution to PF. So it is to be done well within the limit mentioned in the respective points. On other points, if you want to distinguish, you can ask.
Yes. Under section 143(1) clause A, it is mentioned that, like I showed you, the list of adjustments mentioned. Anything which is outside that is not is ultra virus. But in here, it is mentioned in the list of adjustments that in the 3CD, if the disallowance is mentioned, and then the appellant is not considered the same in the income tax label, then it falls under the permissible adjustments. But here in the appeal in question, in the 3CD, the due dates mentioned, and there is no disallowance by the tax auditor, which is mentioned in the 3CD. So they cannot, they are like the non-assessing officers erred in that fact that they cannot pass an order which is outside the permissible adjustment limit in section 143 subsection 1.
And also, the tax audit report that I am referring to, they did mention that it was defective. A defective tax audit report cannot be a basis for disallowance in the code. So basically, it's, when they mention it is defective, it cannot be a base on which the specific disallowance is disallowed. So, and we have already prior mentioned that as per the Supreme Court judgment as well, which came out recently, but at the time of determining due dates, we had relied on binding precedents, which I did mention, that the due date will be as per the section 139(1). But even after, if we set that part aside and take the relevant statute date, there have been in months in where the payments have been made prior to the due dates of the relevant statutes as well, but that also has been disallowed by the assessing officer. So we request that,
Can you please demonstrate that any one entity where you have made the contribution remittance well within the due date of the respective act and they have disallowed?
Can you move to page number 192?
Sorry. It's 129.
If you see in the month of October in Provident Fund, Provident Fund statement, the summary which is there in page 129(1). In the month of October, the due date as specified is 15th of November 2018 and the paid date is 14th November 2018. In this case, it has been remitted prior to the due date of the relevant statute, but it's still disallowed.
We rely on the fact that the disallowance is not mentioned in the 3CD and they cannot rely on the 3CD and propose this disallowance.
And one more thing, Council. See, if you see this annexure, the due date is mentioned as per the respective act. If you see the 3CD, the due dates are as per 139(1) due date. So there is a mismatch. So this annexure is nothing but 20B 3CD. 3CD.
They just mentioned the statutes.
See, that means the due date that is to be reported is as per the respective acts, not under the 139(1).
But the TCD has mentioned it, so.
Heard.
With your permission, can I speak?
Yes.
No. In most of the cases, the council said that you are, as the department said, the income tax department did not encourage the efforts made by the tax auditor, since all the payments which are made by the assessee is is not as per the relevant statute. Is not as per the due date of the relevant statute.
See, one thing. Now, the Supreme Court decision is on it. Now they have demonstrated that they have made a payment which is well within the due date of the respective. So, that particular amount cannot be disallowed. So, to that extent, there is a finding that I am going to give relief to the appellant. But, as such, with respect to other disallowances, we have to rely on the Supreme Court decision and state that section 43B, employees' contribution is not covered. So, I will be upholding the disallowances to the extent of delay of the remittances under the respective. You have demonstrated that one payment of 20,000 and odd is well within the due date. That cannot be disallowed under 3615. So, with due respect to Supreme Court decision, I will be following the decision of Supreme Court, but with one caveat that they have demonstrated that whatever payment that is made well within the due date, it should be considered and relief is to be granted to that extent. So this is the verdict. For this particular matter will be sent back to the AO with a clear direction that if they have made the payment well within the due date of the regular, of the respective statute, that cannot be disallowed under any circumstances. This will be the proper effect of Supreme Court decision, and we are following the Supreme Court decision. So in your case, the matter is partly correct. It is heard and I am pronouncing the order. So this is the...
The assessing that you said, the partial, that is, it is not to be considered as for assessing officer because it is defective. It's a defective.
But based on that only you have processed and you have given you that contention will not help you in any way. What is coming to your rescue is Supreme Court decision. It is only because of Supreme Court decision you won this case. Otherwise, the matter was already settled. It is a covered matter. So you will definitely, that's a partly covered matter wherein we will be following the Supreme Court decision and stating that the disallowances made under section 3615A with respect to employees' contribution, wherever they have made the payment well within the due date of the respective act, they cannot disallowed. Even Supreme Court says. So it is the proper effect that is to be considered, and AO will consider this and pass the order.
Thank you.
number 1003, Bangalore 2022. Case number 3, Srimati Hara.
Good afternoon, my lord. I, Shilpashri SN and my co-colleague Sain are here representing appellant Rajyalakshmi Redraj against CITA order dated 23rd May 2019. The issue of the case is partial exemption provided under section 54F. The appellant filed a return of income for the assessment year 16-17, declaring a total income of rupees 3,02,110. I would like to draw your attention to page number 23.
23 of the paper book?
Paper book, yeah. So during the year, the appellant sold 3 lakhs equity shares of company Aditya Auto Products Private Limited for a total consideration of rupees 2 crore 40 lakhs and declared long-term capital gains of 2 crore 5 lakhs 39,185. Out of the above consideration, the appellant had claimed exemption under section 54 EC and 54F of the IT Act amounting to rupees 50 lakhs and rupees 1 crore 55 lakhs 39,185 respectively. So, appellant furnished the proof of investment in IC bonds and also the utilization towards the construction of residential property. As the construction could not be completed before the due date for furnishing the return, the appellant deposited the unutilized consideration of rupees 1 crore 75 lakhs into CGAS. The same has been confirmed in AO order page number 29.
Yes.
Yeah. And the appellant also provided a statement of account from the builder confirming the consideration paid for construction amounting to 1 crore 80 lakhs 34,321, page number 62 and 63. Builder statement.
62 and 63. This is filed before whom? See, if you see the index of the paper, there is a certification. This is to certify that the aforementioned document information available properly before the authorities as mentioned in column number 3 given. Where is this column number 3? These documents are to be published before the lower authority. That's what you are telling. So, which are the authorities? The column itself is not there. So, whether it is filed before the lower authorities, this certification goes on. Is it filed before EMO or CAB?
You see, my lordship, the first statement from the Prestige Group has been filed before the lower authority. We have to admit that there is an additional evidence which we have produced before the bench of the bench.
So this is additional evidence that you are furnishing before the bench.
Not my lord. If you see the index number, index in additional document, there is a page number 52.
52 to 63.
Yes, ma'am. There is a second statement from the builder.
Counsel, you must be aware that before the tribunal, you cannot furnish additional evidence unless it is called for. Or if at all, if the circumstances permits, you have to move a petition for admission of additional evidence, and it should be placed on the record of the tribunal, and then based on that only, whether it is absolutely, tribunal will decide whether it is to be admitted or not. And moreover, this is part of paperwork, and you are on top of that you are certifying that this is filed before lower authorities. You should have certified that this particular, in fact it should not be part of paperwork. It should be separately, you should have filed, moved a petition, and you should have produced. We would have definitely accepted, or we would have considered. But this is completely against the proceedings. You can proceed without relying on this particular document. We will not be considering this as a valid proof of evidence. And you can proceed.
Okay.
The appellant informed the AO that the property is due for registration and an amount of 10 to 12 lakhs was payable for registration. With this, the entire consideration of rupees 2 crore 40 lakhs was invested with the provisions of section 54 EC and section 54 F. As regards the claim under section 54 EC, there is no dispute. With regard to section 54 F, learned assessing officer raised concerns on availability of the claim on grounds that construction was not completed within the stipulated time and that entire consideration has not been utilized as claimed in the ROI. The appellant initially entered into agreement to sale.
There is one thing please tell me, that the AO, what the AO disallowed? He has disallowed only a proportionate reduction under section 50. He has not denied the complete reduction. Right? He has given you relief. So, your argument should be on the limited point of the disallowance. Rest all is considered by the assessing officer. 54 EC is not at all disputed or doubted. With respect to 54F, with respect to this proportionate disallowance of 54F, you have to make it a point and provide the documents and base your arguments so that we can consider the issue. Yes.
During the proceeding, it has been mentioned.
So, initially entered into agreement to sale with Prestige Augusta Golf Village. However, the same was terminated and transferred to Prestige Woodside. This resulted in delay in construction of property. I would like to draw your attention to page number 57.
Now this 57 is again additional evidence. Fine, you can proceed.
With respect to change in project, this is the proof with respect to change in the project. The initial project started was not completed and property was transferred to a new owner. AO also simultaneously issued notice to the builder regarding the amount invested. Builder confirmed the same, but one tranche of payment made was not included in the statement. And the learned assessing officer disregarded the contentions of the appellant and accepted the statement issued by the builder.
Whether the builder has given a statement stating that there is a mistake and
yes,
that you have produced as additional evidence.
My lord, the index has been, there is a clerical error in the additional documents. The second, there are two statements, my lord. First statement produced before the lower authority. If you could if you could go to the page number 52. Yes, my lord. That document, there is a link to the newspaper. $56, my lord. Number 18. This statement, along with up to the page number 60, my lord. This has been produced before the lower authority.
There is no stamp. That it is filed with the lawyer. Fine, we can proceed. Let us see.
On page number
53, 56 to 60, what you want to do?
So therefore, AOD computed the exemption under section 54F and at 1 crore 43 lakhs 80,000 to 89 as against 1 crore 55 lakhs 39,185 claimed by the SSC. Accordingly, the excess exemption claimed of rupees 11,58,000 was added back to the total income.
So this is filed before the lower authorities, this particular letter.
Yes.
And
They will undertake to file an affidavit.
It is there in the, as all the statements of facts, if you could draw your attention to the CIT order, where also it has.
It is mentioned?
Yes, ma'am. Yes, yes, ma'am.
Okay. Just show it to me.
Sure.
I'm not having the orders.
Page number 44.
Order is also part of the paper. Yes.
If you come to the page number 47, ma'am.
47.
Yes, sir.
Yes.
If you see the para number 4, the appellant also filed a statement of fact which is extracted. You see the highlighted part. The appellant also provided a statement of accounts from the builder confirming the consideration paid construction amounting to 1 crore 80 lakh 34,321 and a bank statement showing the additional amount paid from the SB account amounting to 4 lakh 70. So it was misplaced in additional documents. Though extent to that document is already produced before the lower authority.
Page number 50.
Yes.
Yeah, CIT audit. Agreed by the audit of the assessment and restricting to claim of deduction under section 54F, the appellant preferred appeal to the first affiliate authority. The CIT confirmed the view taken by the assessing officer. Ma'am, they have mentioned the
Which page number you are referring?
50. In page number 50, I have highlighted these grounds for which it was decided.
The sale consideration has not been fully utilized till date.
That I have highlighted the part in the order and
Yes.
I am reading
From where you are reading, you have to read.
Okay, I'm reading from the synopsis.
Synopsis is anyway filed. That I will see to it. No need to read from the synopsis. You have to place your argument. No need to read from the synopsis. It is anyway filed before the bench. So it is very much available with me. So it can be considered. Only thing is you have to place your arguments why 54F should be allowed in full. They have given you partial relief. Just demonstrating. See, you have now shown me that there is a amount which is not considered as omission on account of this particular thing that we will consider. Apart from that, what else you want to state and release?
Yes, madam. Coming to that, it's evident from the suggested fact that the total net consideration of 2 crore 40 lakh, which has gained from the sale of equity shares on the November 2015. The 50 lakh is already invested in the.
That is not doubted.
Yes.
I am completely in agreement. And in fact, you are not before me on that particular point. You just
I'm coming
restrict your arguments only with respect to 54F.
Okay.
Yes.
The remaining consideration of 1 crore 90 lakh was lawfully utilized towards the investment in residential property.
Just a minute. See, the total 54F, how much you claim in the return of income?
1 crore 55.
1 crore?
55 lakhs 39,185.
Okay. And how much AOL?
Sorry, madam.
How much AOL?
They were allowed 1 crore 43 lakhs 80,289.
Okay. The balance?
The balance of 11 lakh 58,000.
11,58,000. Now, if you can show me that you have spent 11,58,000 within the span of 3 years, this can be considered. This is the limited issue. You just demonstrate me that you have invested 11,58,000 within the span of that 3 years. whether registration took place, not took place, construction completed, not, and not on that. There are n number of case laws in support of you. So, anyway, we are very clear on that point. Just demonstrate us that the balance of 11,58,000 rupees is invested. Then we if we 3 years.
My lord, the 11,58,000 amount does did the SSC had invested, the appellant had invested, but it's not within the due date due to the performance impossibility by the builder. Because during at the time of filing the ITR, the appellant was acting in the guidance of builder. It had kept aside the 11 lakh of amount for the purpose of property registration of property. But there was a delay in construction which could not be done the same. So that's the reason it could not be invested within the 3 years.
Ultimately registration.
Yes, ma'am.
When it is after 3 years.
After 3 years.
And you have invested, you have considered and you have paid the registration.
Yes, ma'am.
But that is not within the time frame of 3 years.
Time frame.
That is the thing, right?
Yes, ma'am.
And out of this 11,58,000, how much is extra investment that is now to be considered from auction?
How much extra?
Consider the investment that we have to consider.
Entire amount has been utilized for the road.
No, that is after 3 years.
After
3 years. See, the law is very clear. See, for claiming reduction the section 24 was purchased, it is 1 year period, 2 years. So construction, it is 3 years from the date of transfer. See, they were department definitely take a stand that the construction is not complete. So that's why you are not eligible for the entire reduction. That is not your case. They have allowed the benefit, but only they have restricted to the extent of 11,58,000. They have not given you relief, stating that you have not invested this in 3 years. Whether any money is kept in CGS?
No matter.
Money is not kept in CGS.
No matter.
And within the 3 years, see, law is very clear. If you have invested well within the time, you will definitely get the benefit.
But my lord, the appellant had in the beginning had intention of investing in the
Intention is different. Law is very clear. Intention is different. Nobody is doubting your intention. Intention is very much clear. Everybody is having greater intentions. Not law and all income tax act never works on intention. You have to see the act. You have to see the procedure. You have to see the provision. The intention is nobody is doubting your intentions. That is for sure. If you can demonstrate me that you have invested extra sum well within the due date of prescribed under 54, I will definitely give you it. If that is the case, fine. If not, then not. Is there any case law that you want? This is all factual. No case law. I am not doubting any case laws. I am aware of all the case laws. Only thing is now you have to demonstrate, because this is income tax appellate tribunal. This is ultimate fact finding body. This is equivalent to Supreme Court with respect to facts are concerned. Nobody will sit and check the facts in High Court and Supreme. You can't even go on the facts basis. So now you have to clearly demonstrate that you have invested within the 3 years. We will grant you the. Nobody can stop you from granting reduction under section 54. To that extent, I am very liberal to you. Please demonstrate it. If not, then nobody can.
I was giving some of the case laws to court that to substantiate the.
Tell me, show me which case laws.
If you go to case law 1, I mentioned in the post case law 1. Last page, last.
Yes.
High Court of Madras. The separate.
Can you please tell me the case, the page number? Sardar Nagar, High Court of Madras?
Yes.
Yes.
Yes, my lord. if you see the highlighted one, the exemption of in any case of investment in residential house assessment year 2001, in order to get benefit under section 54F, assessee need not complete construction of house or occupy the same.
Yes, I am also not. Need not to complete. I am not telling you. There are n number of
Here,
cases.
the case here is like the appellant was not able to invest in because of the performance impossibility by the builder. If the builder was able to finish the construction in the new time, the amount would have been gone to the registration of property. It would have been utilized within 3 years. Due to the delay in the construction by the builder, the appellant could not be able to use the remaining amount. Had it been the case the builder had finished the construction, the appellant had definitely made use of 11 lakh towards the registration of property.
This delay from the builder's agent will not help you to getting reduction under section 54. See, registration is different, completion is different. Unless you expend some money, invest money.
Money has been subsequently invested.
Subsequently invested, but I can't stretch the 3 years timeline.
That's the case I have.
Where show me where it is written that, see, you show me one case law, wherein it is written that due to this, they have not appealed, due to circumstances beyond the control of the SSC, or because of the builder's side, there is a delay, and the expenditure incurred after 3 years is to be allowed. You just get me one case law. Yes, sure.
They haven't got the case law like which allowed beyond the 3 year limit. But there are certain cases where the court has been upheld with the intention of the appellant was in a nature to invest from the beginning itself to invest in a residential property. The exemption has been allowed.
Show me where it is. Which case law you want?
Come to the case law before the Karnataka High Court, page number 69.
Ramachandra.
Yes, ma'am. If you see the highlighted part, if the intention is not to retain cash, but to invest in construction or any purchase of property, and if such investment is made within the period stipulated therein.
Period stipulated therein means 3 years. Continue.
Is not at all attracted. And therefore the contention that the assessee has not deposited the amount in a bank account as stipulated and thereof he is not entitled to the benefit even though he has invested the money in construction is also not correct.
See, here they say that CGAS comes into.
Yes.
Here in your case you have not invested in CGAS. That is not your case.
The only amount which is set aside.
How much ever you have invested in the property, that will be allowed. And the time frame, what is the time frame? 3 years. We are not doubting any transaction. We are not telling you that we will completely take off the entire deduction. AO is fair enough to give you deduction with respect to partial deduction is given. The only thing is now, even the case law that you are referring to, that is Karnataka High Court, which clearly states that period stipulated.
My lord, that's what. In the beginning itself, the amount has been, when the bidder had called upon, the amount has been
then you should have kept in CGAS. And that too, in CGAS also, there is a provision which says that if you don't expend the money out of CGAS, immediately after that it will get taxed. It's just parking the money in particular account.
Yes, madam. I want to bring one more point. At the time of filing idea, the appellant was in the view of that respective 10 or 11 lakh will be registered, used towards the registration of property.
Yes.
That's the reason 1 crore 80 lakh was invested in CGAS. So as the time passed, like as I told, the builder could not be able to finish the construction. That is the reason the appellant was not able to deposit in the CGAS. The CGAS deadline was already passed, my lord.
That is okay. See, we are not on CGAS. Just demonstrate me that money is invested in 3 years time frame. Or get me one case law wherein the time limit of 3 years is extended. Whenever they register, at that time whatever is spent, that is allowed. If you can get me the case law, we will consider.
My lord.
Then department.
So, good afternoon, my brother. As the applicant is in the For the
No need to repeat anything, no need to repeat. Just whatever comes to, whatever you want to make a point, just be clear, that's it. Be precise, no need to go through read, nothing is there.
So, before you honor, they have told that they have not invested any amount in the CGA, but they have invested 1 crore 75 lakhs out of the total contribution of. They have not deposited the whole amount of 1 crore 90 lakhs, but they have deposited 1 crore 75 lakhs. They are claiming here that they are not enough.
Whether that 1 crore 75 is invested in the property or kept in CGS.
First it is kept in the CGS, subsequently.
They told that never kept in the.
No, my lord, only the extent of.
You told me.
See, I have been asking you that whether any money is kept in CGS or not.
Yes, my lord, you asked me to focus only on the remaining part of 11 to 12 lakh.
No, 11 to 12 lakh is fine.
Yeah, entire amount up to 1 crore 80 lakh has been deposited in the CGS.
Out of which you have
has been,
spent,
proof
which
also-
have been, portion of which is spent, and AO has considered that
Yes, ma'am.
portion, and he has the loan reduction.
Yes, madam.
Yes. Then,
And the case law they relied upon, it basically speaks about performance impossibility of construction and not performance impossibility of investment. So the obligation is investing money. Delay in the construction should not be held as substance over form. But in this case, the balance amount was not utilized and then no proofs were also submitted regarding the same. And section 54 clearly mentions that if the amount deposited is not utilized for specified purpose within the stipulated period of time, that is within the 3 years of the construction, after the date of the transfer of asset, then utilized amount shall be proportionately taxable. So in the view of clear and unambiguous provisions of the law, the applicant would be entitled to the exemption of 54F only of so much net consideration which is invested by them. And we have a case law also regarding that case law. This was the judgment of High Court of Bombay, Humayun Suleiman Moot versus Chief Commissioner. Case law compilation, page number. High Court of Bombay, judgment of High Court of Bombay for the case Humayun Suleiman Moot versus Chief Commissioner of Indian Income Tax, Mumbai. This is similar to the case where it specifically mentions that the amount which is not being utilized for the construction before the filing of the return must be deposited in the capital gains account scheme, and which has not been utilized for the purpose within the time limit, then they are restricted to the consumption.
yeah, one thing is that you were referring to some CAT, please find that there is some portion which is not considered by the AO that you have invested from, you can demonstrate from your bank accounts. Whether that particular part is considered in the reduction?
No, my lord.
No?
No, my lord.
To that extent you will get it. Otherwise, 3 years, nobody can.
But the always intention of the
Intention is, I am not doubting the intention. Even I am having a very good intention of allowing full grant relief to
True, my
you.
lord.
But the thing is, ultimately, I am stuck with the provisions. I am bound by the provision. What provision says? Have you gone through the 54F
Yes,
and 54? 54 54F what it says?
54F.
Can you extend the period of 3 years?
No, my lord.
See, there is a case where the property is not registered. So, there is a complete denial of 54 years. All these cases, what you are referring and these people we are referring, that is all probably with respect to the entire denial of 54A. AO is fair enough to grant you relief, but whatever portion that is not considered by the AO, yes, you will definitely going to get, but you have to show that this is expended well within the time frame of 3 years.
As I put up my argument here that AO appellant had already 11 lakh had been the builders.
We will consider, no, we will consider, and it is already considered.
It's a mere procedural lapse, my lord.
Procedural, it is not procedural lapse. It is not procedural lapse. With this procedural lapse, if I allow your claim, that means I am going to extend the time limit which is given under the Act. And if that is the case, then you should get me some case law or some evidence or some proof under the provisions of the Income Tax Act or case law to show that you can keep the benefit of the expenditure, whichever, whatever, which is beyond the time frame of 3 years. If you can get it, we will. See, as of now, to my knowledge, there is no such case law. And you have provided one case law of Karnataka High Court, which is binding decision on the bench, which clearly stated stipulated time frame. So, within 3 years, if you can demonstrate that you have expended little more, which is not considered by the court, that will be considered and suitable relief will be granted. So, that would be the verdict of this particular case. If this verdict is already I have considered, in fact, I have argued in the yes. Heard. Heard and pronounced.
Thank you, madam.
Shilpa Shri and Sahini. Time frame becomes very crucial because if somebody is taking time of some other contestant, then the other contestant won't be getting time to raise his argument. So please, the moment the time is over, please at least mention and
the first team, they have taken 20 minutes each.
Okay.
Okay, the second team is, they have taken 22 minutes.
This is with respect to case number 2.
Yeah, case number 2.
20, both.
Yeah.
15 minutes we can sound an alarm.
Haan.
Manage it.
20% minutes each is taken. The second, the third team is 22 minutes, 20.
Okay.
And the other team is 8 minutes.
8 minutes.
They couldn't argue because they were already
Please, session and then allow because see, in the first case it is 40 minutes, in the second stage it's exactly 30 minutes. So please see to it.
PA number 1004, Bangalore 2022, case number 4, ECB Private Limited.
My name is Prashant Paul, and this is co-counsel Sahana Lokesh. We're representing the SSE ABC Private Limited, and this is in respect of ITA 123 Bangalore 2020, where the relevant assessment year is 2011-12. And we are here in our appeal to the Income Tax Appellate Tribunal because the SSE is aggrieved by the CIT order dated 4th February 2020. With your permission, we'd like to summarize the facts of the case.
Your Honor, pursuant to the information. With your permission, may I please proceed with summarizing the facts?
Yes.
Pursuant to the information received from ED, the IT department initiated reassessment proceedings against the appellant. A director of the company lent 3.77 crores to the appellant company. Part of it, that is 0.77 crore, was returned back to the director, but the remaining 3 crore was considered as an advance towards sale of a property worth 9 crore rupees. As the director could not pay remaining consideration, the advance was forfeited and the agreement to sell was rescinded. As the forfeited amount was on account of sale of capital asset, the appellant credited the said amount to capital reserve account. The appellant requested for a reason for reopening of the assessment under section 147 of the Income Tax Act 1961. The assessing officer concluded the assessment wherein 3 crore rupees being forfeited amount had been added to the income of the appellant on the following grounds. That the issue on hand is forfeiture of loan and not forfeiture of advance for the purchase of property. That in return of income filed, the director has claimed the amount forfeited as a revenue loss. That it was mentioned in the agreement to sell dated 29/8/2008 that the loan of rupees 3.77 crore was taken by the appellant to pursue a project. That the forfeiture of loan would fall within the purview of section 28 subsection 4 of the Act. So section 4 clause 4 of the Income Tax Act 1961 reads as the value of any benefit or perquisite, whether convertible into money or not, arising from a business or exercise of a profession.
Further, Your Honor, we'd like to invite your attention to the grounds of appeal on page 5 of the appeal set and lay specific emphasis on the following grounds, which is ground 3 first of all. As mentioned by my co-counsel, I'd like to, for the benefit of Your Honor, I'd like to read out the third ground.
You are not pressing technical ground?
Not under 148. We are not pressing on 148. We believe that there is reasonable.
Then you have to endorse it. You have to endorse that you are not going to press this technical.
Yes, we do endorse that. We are not.
Just get the endorsement that they are not pressing this ground. They have to write that you are not pressing this ground and you have to sign it.
not pressing the ground advance. Sure.
Yes.
Right, Your Honor. So, ground 3 very specifically mentions that the authorities have heard in law and on the facts have not appreciated that the forfeited amount on the basis of the agreement to sell was on account of advance towards the sale of property and would constitute a capital receipt in the hands of the SSE. And essentially, Your Honor, I'd also like to mention that this particular agreement to sell that was signed between the director and the SSE was clear. There were explicit clauses that were agreed mutually, of course, between the director and the company on forfeiture of advance, given non-payment of the remaining balance by 31st of December 2009. Since by that date the director did not make the balance payment, which is to the tune of 6 crores, the amount of 3 crore was forfeited. As my co-counsel earlier mentioned, the total loan that was due by the company to the director initially was 3.77 crore, but on forfeiture only 3 crore was retained.
When that balance amount was repaid?
At the time that forfeiture, before the forfeiture, when
Is it before the entering into agreement or post agreement?
Post-end agreement, post-agreement.
Post-agreement.
Yes, we returned 77 lakhs post entering into an agreement, but only 3 crore was forfeited, and essentially forfeiture by nature cannot also be unilateral. It has to be by mutual consideration and acceptance. And once on 31st December 2009, the balance payment was yes.
Repayment of this 77 lakhs is post agreement.
That's correct.
Yes. And when is that
The last date.
agreement entered into?
The agreement is dated 28th of February 2008. 28th of August 2008. I beg your pardon. 28th of August 2008.
Yes.
Right, Your Honor, in pursuance of the same, since the lower authorities have erred in classifying this particular advance in the nature of a property as a conversion of a loan, and further have stated, as mentioned in ground 4, where I'd like to invite your attention, that this particular transfer of a capital asset, and I'd like to lay emphasis on the transfer of a capital asset which falls within the purview of first section 2 subsection 14 of the Income Tax Act, which defines a capital asset which this falls under. Now these particular 4 units that were being agreed to sell to the director fall within the definition of capital asset under 240, and further that agreement to sell, once the sale would be completed, would fall within the definition of 247 under transfer of the Income Tax Act 1961. But the assessing officer has gone on to mention that such an advance of about 3 crore rupees will fall within the purview of section 28, subsection 4 of the Income Tax Act of 1961, and for the benefit of Your Honor, I'd like to read 28.4. Sorry? Right, so section 28, subsection 4 of the Income Tax reads that the value of any benefit or perquisite, whether convertible into money or not, arising from business or the exercise of a profession, Your Honor. And by laying emphasis on the bare clause of the Income Tax Act, may I now invite your attention to the facts of the case. Now, our business, the assessee's business, is in the business of refined salt. The assessee's principal activities do not in any manner construe either real estate activities or taking or making loans. And so it is very clearly established, even as per the memorandum of association of the assessee, that the business is of refined salt and not either of making or taking loans or dealing in real estate activities. Further, Your Honor, I'd like to invite your attention to... Yes, it is. The extract of MOA is part of paper book, yes. I'll invite your attention to that in the following argument. First, I'd like to invite your attention to page 13 of the paper book. Your Honor, we'd like to place reliance on a landmark case by the highest court of the country, Mahindra and Mahindra by the Supreme Court of India 2018, and we'd like to place specific emphasis from line 5 of that particular submission, which mentions, in order to invoke the provision of section 28 subsection 4 of the Income Tax Act, the benefit which is received has to be in some other form rather than in the shape of money. In the present case, it is a matter of record that the amount of 57,74,064 is having received as cash receipt due to the waiver of loan. Your Honor, it's important to take note of the facts here because it is absolutely similar to what happened in Mahindra versus Mahindra in Supreme Court 2018, where this particular loan was converted into an advance simply because the 6 crore payment was not being done, the 3 crore was forfeited by the company. And since the forfeiture was done in the nature of a capital receipt, it should fall within, as we are mentioning, the ambit of section 51 of the Income Tax Act of 1961, and there is absolutely no question that this would be classified under 28(4), which aims to tax the profits and gains of the business or a profession rather than a capital receipt. Further, Your Honor, I'd like to invite your attention to page 15 of the appeal set. And this reaffirms my earlier argument about the memorandum and articles of association, where I invite your attention to line 3, which is, it is relevant to note that from the main objects of the parent company do not contain pursuing of real estate business. As such, the company is not engaged in the purchase and sale of properties, and therefore the advance received and forfeited cannot be construed or considered as a business transaction. Further, Your Honor, I'd like to invite your attention to the ensuing paragraph, second line, which mentions that it can be verified from the balance sheet that the property against which the advance towards sale consideration is with respect to the commercial space with the specific measurements for the year ended 2009 and 10, where the said property is not held as stock in trade, but rather as a fixed asset, which clearly establishes the transaction that the intended sale was of a property and not trade. Further, Your Honor, I'd like to again bring your attention to page 15 of the paper book.
Yes.
On para 11.8 and more specifically, Your Honor, I'd like to bring your attention to the previous page, page 14, the last para, 11.7, which is the primary case that the department has relied on in its appeal from the CIT and the analysis of the assessing officer, which is of MS Ramaniam Homes Private Limited 2016 384 ITR 530. This is the particular case that they have relied on, which mentions that it is immaterial whether the benefit is derived from the business of sale or purchase of real estate, given the fact that it may not be the principal activity of the business. If I may bring your attention to the ensuing paragraph, 11.8 in the next page. Next page, Your Honor. Yes.
Yes.
Now, it's pertinent to also note that the above ruling that we just mentioned, Ramaniam Homes, that the department has relied on, is not relevant in this case, in the present case of the SSC, as it has been overruled by the Supreme Court in the case of Mahindra versus Mahindra, the judgment of which was earlier read on by ourselves. It is relevant to note that the Supreme Court has not disturbed the ruling of the Bombay High Court of the same Mahindra and Mahindra, which was in the lower court, which ascertains the same principle and upholds it against Ramaniam Homes. Further, we'd also like to mention, and in under 11.10, that there are particular other cases and given references that are standing in the favor of the SSC, as given by particular high courts, as mentioned in that particular paragraph, Your Honor.
What is CAT, please find?
That it is based on 28.4.
Can you please take me to the CAT please order? What is the content of CAT please? You would have relied on Mahindra and Mahindra because the CAT please also not.
Yes, that was the Bombay High Court, but the
subsequently
sub-CIT appeals relied on Ramaniam Homes, which is when we appealed to the IDAT, and now we are relying on the Supreme Court Mahindra and Mahindra, which eventually overruled Ramaniam Homes' decision. May I invite your attention to page 17 of the paper book, Your Honor. That is the ruling of the.
Yes. Para?
Para 12 itself, Your Honor. Right, so
5.6, 5.7, CAT appeals order.
that is the ruling of the.
See, I told you to show me the findings of CAT appeals. In the CAT appeals order, this is, you have to see the appeal memo.
Correct.
And in that, from page number 8 onwards, CAT appeals order starts. And what are the findings of CAT appeals? That you have to read it out.
Yes. Right, Your Honor, may I?
Yes.
The appeal was filed on 7th of September 2017.
Not the entire
That's the
order.
appellate order.
I want the findings of the CAT appeals order on this particular issue, not the entire order.
This will be para 3.1 if I'm not wrong. Page 8 of the paper book.
See, these are the grounds that is reproduced. And there is a finding. Before that, there is 148 findings. And after that it comes that you have to show it to me where exactly the CAT appeals. Right. Part of the, it is part of the order. What are the findings of CAT appeals order? Why CAT appeals has not considered your claim, your plea?
Please allow us a minute.
No problem. Take your time. Para 5 deals with your issue. Para 5.1. Page 13.
Right. May I read it? So in ground numbers 2 to 5, the appellant has contested the addition of an amount of rupees 3 crores, taking the same as benefit of perquisite received by the appellant company and taxing the same under the provisions of 28(4) of the Income Tax Act. After rejecting the contention of the appellant that impugned amount represented forfeiture of earnest money received in connection with the transaction of removal property, and therefore capital gains will only be exigible on the final transfer of property under section 51. The cost of acquisition will be computed after taking into account the earnest money so forfeited. In this regard, the following submissions have been made by the appellant.
You can skip that submission.
Yes. Further, on para 5.2 on page 14, Your Honor. Should I read out the rest of the order? Further, as regards the contention, the advance from the director was a capital advance and not in connection with the business transaction. The following submissions were made by the appellant through their letter dated 16th August 2019. Should I go through the submissions, Your Honor?
Yes, yes.
So
Because it talks about the grounds on which
Right.
the AO has served.
Yes. So the assessing officer concluded the assessment wherein 3 crore being forfeited amount is being added to the income of the appellant on the following grounds. Ground 1, the issue on hand in forfeited of loan and not is the forfeiture of loan and not forfeiture of advance for the purchase of property. That in return of income filed such a 3 crore, such particular director, whose name is registered has named the amount forfeited as a revenue loss, and that it was mentioned in the agreement to sell dated 29th August 2008, as we mentioned earlier, that the loan of 3.77 crores was taken by the appellant to pursue a project. And finally, on the next page, that the forfeiture of loan would fall within the purview of 28(4) of the Act. And we already mentioned the extract of the MOA and the article.
Now 5.3. The submissions
The appellant having carefully considered, sum and substance of the same is that the loan received from the particular director has been considered in the books of accounts as advance for purchase of property. Since the advance was forfeited, the same is treated as a capital receipt and credited to the capital reserve account. The advance from the director being in the nature of earnest money for purchase of property, the provision of section 51 will apply to such an advance. Since the company is not engaged in the business of buying and selling properties, the benefit received on the account of forfeiture cannot be termed as a benefit within the meaning of section 24, subsection 4, section 28, subsection 4 of the Act. And then para 5.2. Your permission has been given.
like to relay on invalidity. Yes. And your intention is that section 51 is applicable and not 28.
Yes, there are a couple of other emphasis that we are laying out. Travancore rubber, also a Supreme Court case.
Supreme Court decision, when you are relying on the later decision, one is different.
Sure.
Yes.
Thank you.
Your Honor, we are representing department. As the ground stated by the appellant, we would like to Yes, Your Honor. As the grounds and the facts already stated by the appellant, I would like to state our contention to the grounds stated by the appellant. Your Honor, I would like to bring it to your notice that the company had taken loan of amounting 3.7 crores, and subsequently that has been moved to advance. So the nature of transaction or the occurrence of the events moving from loan to advance, we are a little suspicious about it that it is a collectible device. So I would like to continue my argument with the fact that it is a collectible device. So subject to the matter of agreement, Your Honor, I would like to bring it to your attention, page 18 of appeal memo. Para 5.9 in the end. The property, subject property of the land where the advance was given to the transfer of immovable property. The said property was leased out to another company, Cobra Indian Trade, in February 2010. Your Honor, the agreement between the director and the company where the director fails to repay advance or pay the entire balance 6 crore advance to the assessing company within 31st 12/2009. Within 31st 12/2009, the company would forfeit the same. But it has been leased out to the another company called Cobra Indian Trade in February 2010. But amount was forfeited in financial year 10 and 11, not in financial year 9 and 10. And it was
See, the agreement is entered on 28/8/2008, right?
Yes.
And the loan, initial loan was given on initial loan.
2006.
Financial year 2 years. Date is available? Date is available? We don't have it. For what this particular loan is given?
The loan was given for the purpose of a project. Where
Project?
Yes. Purpose of a project. That is what has been mentioned in the order as well. Also, to prove again that it is a collectible device, there has been no debit entry of interest in the books of assessee company, not even a notional interest debited to their books. So, since the assessee is not in a real estate business, it has leased out property which is 4 flats to the another company which is deriving rent out of it. So this would again constitute that it is a colorable device, and then the transfer of loan to advance, again it constitutes, since it is the director of the company, we are again suspicious about the reclassification of the same.
There is an agreement, right? Valid agreement?
They have a sale agreement.
Agreement is there, agreement to enter.
Yeah. Sale agreement?
Sale agreement is part of paper.
Yes, it is part of paper.
We suggest because the entire sale agreement is not there. It is part of the CIP order.
Whether you have given the copy of the sale agreement?
We have an extract of the agreement to sell, Your Honor. We don't have the entire copy. It was submitted as part of the annexure, but considering confidentiality of client confidentiality, that was not mentioned as part of the report. The entire agreement to sell is not there. The extract of agreement to sell is there, which mentions the forfeiture clause, the non-performance clause. That is part of it.
See, whenever you are submitting some documents to before the court, it should not be the extract. See, this particular sale agreement is very crucial document,
Right.
which decides your case. And moreover, this department is doubting the very validity of that agreement. See, usually what happens, in case if they have not doubted the agreement and then if they have proceeded with some other contention, this matter would have been different. But now they are doubting the very validity of the sale agreement, and that sale agreement is very crucial, and you have to demonstrate that that particular agreement is not a colorable device, but it's a genuine document which has been entered into and the correspondence has been taken
So
the parties.
Your Honor, the agreement has already been perused by the department, and on perusal.
On perusal only, they have come to the conclusion that there is a colorable device. They are telling this is all
Based on surmises and conjecture, but not based on any fact.
that will be that I will ask them how on what basis they have come to, but you have to produce the document.
Your Honor, it is part of the paper book. If you can just give us a minute, we'll give you the exact reference.
You will just keep that particular document ready when your turn comes at that time. I will.
Yes, sure. Thank you.
May I proceed, Your Honor? Also, in continuation to that, I would bring your attention to page number 18 of appeal memo. May I read out what is stated in the page 18 of appeal memo? Also, the advance money has been foregone by the director, which is stated in page 18 of appeal memo. I will state what is mentioned in the order, that director states, it was in goodwill and trust reposed in me by late Mr. ABC as a matter of commitment and honoring my vote. I agree to forego a sum of rupees 3 crores as an advance for purchase of property as per agreement to sell.
Just a minute. Wait, we are reading para 5.8.
5.8, Your Honor.
Just to know that there is
Yes. Italics.
Yes. I was referring that, Your Honor. Subsequently, after that, may I request you to go to page 13 of appeal memo. Just below the para 5.1, the one in italics, it states that subsequently, failure on the part of Mr. Director to pay the balance in consideration of 3 crores was forfeited by appellant out of advance, and balance 77 lakhs was repaid to Director. Your Honor, this again clearly proves that it is a colorable device, where Director states that it is already forgone by him, and then again the company states that due to inability of Director to repay the loan, they have forfeited the same. We pay the balance money of 6 crore, the company has forfeited the same. This again proves for a fact that it is a colorable device, and also, Your Honor, since the assessee company and then the director are involved in day-to-day management, director would obviously assess the financial position of a company before giving the loan, and company for a fact that it should also assess the financial position of a director. Also, for a fact that company cannot claim the lack of awareness of financial position of a director, that stating he was not able to repay or he was not able to pay the balance 6 crore advance. Rather, I would say it is just a colorable device to evade tax of 3 crores. Also, the director has taken and set off the loss of 3 crores against this income from other sources, where the 3 crores was not offered to tax here, and the other end, the benefit of the same was taken in direct proceedings. Your Honor, Your Honor, I would also like to bring to your attention one of the case we have relied on, McDowell and Co. Limited versus CIT, 154 ITR 148. As per page 10 of the case law compilation which we have submitted. Page 10. Yes. Paragraph 23, it states that tax planning may be legitimate provided it is within the framework of law. Colorable devices cannot be part of tax planning, and it is wrong to encourage or entertain in the belief that it is honorable to avoid the payment of tax by resorting to dubious methods. It is the obligation of every citizen to pay taxes honestly without resorting to subterfuge. Your Honor, as mentioned by all the facts where it proves that it is a colorable device, since the tribunal is the final fact-finding authority, I would place this fact in front of you for the judgment, Your Honor. Also, Your Honor, another fact which we want to represent in front of you is concept of human probability. We relied on again another case, CIT versus Durga Prasad Moot, 82 ITR 540. Durga Prasad Moot is in this only was quoted. Yeah. Not in our submission, the applicant submission, there is Durga Prasad Moot. Page 82. Page 82 submission. Page 82. Yes. Your Honor, last paragraph which states, science has not yet invented any instrument to test the reliability of the evidence placed before a court or tribunal. Therefore, the courts and tribunals have to judge the evidence before them by applying the test of human probabilities. Human minds may differ as their reliability of a piece of evidence, but in that sphere, the decision of fact-finding authority is made conclusive by law. Again, I am placing the judgment in front of you, Your Honor. Also, in the case, by the reason we relied on Durga Prasad Moot, the assessee had taken shelter under trust deed to evade tax of 2 lakhs. So, in our case, it is the sale deed where our assessee is evading tax of 3 crores. They are taking the shelter of sale agreement, which is again the colorable device, and we would like to apply the test of human probability and place it in front of you, Your Honor. Also, they have relied on the existing sale agreement, and there was no intention of selling or purchasing property from director and company as well. So there was no intention of foregoing the loan as well, advance. He has foregone the loan and then they are forfeited in their books, which again I will have to prove that it is a colorable device, and leave it in front of me, Your Honor. And my co-representative will take the technical facts.
Your Honors, as the facts of the case was represented by the AR, and as the sale deed was proven with substantial evidence that it is a colorable device, I would like to take your attention towards the sections which is relevant to the facts of the case. In this grounds of appeal, my Lord, the appellant states that the appellant is not engaged in any business, more specifically real estate business. So no question of invoking section 28 for the tax or of the amount forfeited. In this, I would like to contradict the grounds that is taken by the AR and state that in financial year, as stated, 7-8, the director had advanced the loan of 3.77 crore to the assessee company to pursue a project which is in the nature of the business, which is in the ordinary course of business. Just merely reclassifying loan to advance does not change the fact that they are evading tax. So in this, I would like to tell that section 28(4) of Income Tax Act, can I quote what it says, my Lord? The value of any benefit or perquisite, whether convertible into money or not, arising from business or the exercise of a profession. In this, the law does not specifically state that the benefit should be
exclusively non-monetary in nature. We would like to state that it is not the actual receipt of the money, but rather the benefit which has a monetary value to the assessee. In this case, not paying loan by the assessee has a monetary benefit to the assessee in the financial year 7-8, and hence the unpaid loan of 3 crore prior to it getting classified as advance should be taxed in the right hand in the right year of 2017. In this case, we would like to place reliance on the judgment passed by Madras High Court in case of CIT versus Messrs. Ramaniyam Homes Private Limited. The facts of the case I would like to sum it up in this statement and findings of the case. One is that the waiver of principal of loan amount is constituted as an income and it is taxable under section 28(4). And additionally, it states that the benefit need not be actual cash receipt. It can be in the nature of opposite or a benefit bearing some monetary value which may or may not be converted into money. In our case, my lord, the benefit is in the nature of not in nature of cash, but it has a monetary value. So section 28 should be applicable for the amount of 3 crore, and we would like request you to kindly dismiss the ground taken by the AR. And we would also like to state that, my lord, a single transaction can constitute as a business. In this, we would like to place reliance to the case law of Venkataswamy Naidu versus CIT. This is part of our case company. Request you to kindly go to page 90. Paragraph 3. It is allied to the transactions that constitute trade or business, but may...
Page 90.
Yes, sir.
Paragraph?
Yes.
Yes.
It is the 5th line. It is allied to the transaction that constitute trade or business, but may not be trade or business itself. It is characterized by some essential features.
Page number 19, Venkataswamy.
Yes,
third paragraph.
Third paragraph.
Second paragraph.
Yeah,
You are reaching the conclusion that the transaction is an
no, my lord, the next paragraph.
Okay.
So in that paragraph, the 5th line.
5th from top?
Yes. It's after the full stop, where it says it is allied.
The paragraph starts.
Can I approach the bench, my lord?
No. Even if the conclusion of the tribunal about the character of the transaction is treated as that paragraph you are referring to.
So the question about the character of
Yes,
transaction.
this is what? Okay.
So in this, the 5th line.
It clearly suggests.
So it is allied to the transactions that constitute trade or business, but may not be trade or business itself. It is characterized by some essential features that mark up trade and or business, but not all of them. So even an isolated and single transaction can satisfy the description of an adventure in nature of trade. But at least some of the essential features of trade must be present in the isolated or single transaction. So in this it states, my lord, that a single transaction can take a form of business if certain characteristics of a trade is present. In this case, I would like to reiterate that the loan initially was given for the purpose of pursuing a project, which is in the nature of business, which constitutes trade. And hence, the single transaction can constitute as a business, and it is liable to be taxed under section 28. In addition to this, Your Honor, the assessee has taken the ground that amount received from the director is shown under Schedule B, unsecured loan, in financial statements of the applicant and not under trade creditors or trade sundry creditors. We would like to state that, Your Honor, our findings of the case was very clear that the 3 crore amount is taxable under section 28 and we are not considering it under trade creditors or under sundry creditors which would attract with section 41 subsection 1 of the Income Tax Act. So this must be dismissed. Now, Your Honor, I would like to tell that section 56 subsection 2(9) will be applicable in case of forfeiture. In this regard, we would like to tell that in this regard we would like to place relevance of section 51. So in this, my lord, can I quote what the section says prior to the amendment?
The thing is now, the whole issue is about the validity of that agreement. If the agreement is valid, then they have section 51. If the validity is the agreement itself is colorable device, then all these arguments are in place. So now we have to check the validity of the agreement to conclude these proceedings. The main crux is to see the validity of the agreement. So I have understood the points what you have communicated. Now let the AR explain how that particular agreement that they are relying upon is valid. So based on that, in case if we feel so, then I will come back to you and give you an opportunity to counter the argument of the
Much obliged.
Yes. Your argument should be limited only to the extent of validity of that agreement. See, Mahindra Mahindra is there. Supreme Court is there, which is in your favor as of now, subject to the validity of the agreement.
Yes, Your Honor. And there are multiple grounds actually. We will start with that, the validity of the agreement. Before that, may I just take a minute to address the grounds that were addressed by the DR? In just a minute.
How long?
Just a minute. I will wrap it up in a minute. and then get to the agreement.
Yes.
So first of all, I'd like to place on record.
To conclude, I would be requiring 2 to 3 minutes, not more than
Yes, Your
that.
Honor.
I will not
Yes.
say anything.
Yes, Your Honor. Your Honor, we'd like to first place on record that the DR has acknowledged that it is a monetary benefit that the SSC has received. And we'd like to go back to Mahindra vs. Mahindra and Supreme Court Order 2018, which specifically excludes the ambit of monetary transactions under 2028-4. Second, we'd also like to mention that this particular, the DR also mentioned that single transaction can be classified as business. Your Honor, that would doubt the sole integrity of Section 5 of the Income Tax Act, simply because if every transaction can be named as business, then what would be the requirement of classifying transactions or income under different heads? Then every other transaction that the company gets into would be assessed as profits and gains of business, and there would be no requirement at all to be assessed as capital gain on house property. And so we would say that it is completely infructuous and law, and that should be taken off the record. And finally, the DR is also confused whether this assessment has to be made on the 28.4 or 56.29. And with bringing some clarity on this particular transaction, 56.29 is a proviso to 51.
It is not applicable for this year. It was not even
Yes,
there in the statute for
24.15.
this year. That is not the issue. Don't get into all that.
Just want to clarify.
Limit your argument with respect to validity of the
Right, Your Honor. So I'd like to bring your attention to page 17 of the appeal set.
Yes.
So, Your Honor, we first of all believe that any allegations of this being a colorable device is completely unfounded and not based on fact or any finding as such. And for the benefit of the court, can I read out the submission? Can I read out the extract of the agreement itself?
Yes.
So it mentions that the agreement was executed on 29/8/2008. Mentions that the agreement was extended on account of failure of the appellant to pursue with the project. Relevant extracts as mentioned, where the purchaser is an investor who has invested funds for the projects taken up by the vendor company to the tune of 3,72 lakhs. The vendor expressed its inability to pursue the project, and the vendor is facing financial stringency and could not reimburse or refund the funds invested by the purchaser. And in lieu thereof, the vendor has offered to convey the scheduled property owned by the vendor in favor of the purchaser, and the purchaser has agreed to purchase the same on certain terms and conditions mutually agreed between the parties. The purchaser agrees to pay the sale consideration in the following manner: the first 3,72 lakh being the amount invested or advanced by the purchaser in the projects undertaken by the vendor, appropriated towards advanced sale consideration for the purchase of the scheduled property. The remaining amount, 5,27 lakhs, being the balance sale consideration to be paid by the vendor on the date of execution and the registration of sale deed. And also, in this case, we would also like to mention that the DR mentioned that the sale deed was a colorable device, as was mentioned by them.
Sale deed
Was
means
not.
it is agreement. See what they are, don't get into all that.
All right.
It is understood that it is there.
All right,
talking
Your
about
Honor.
sale
All right,
agreement.
Your Honor. All right.
Let's not get into it.
Right.
Yes.
So finally, the vendor shall establish a good and marketable right, title interest in the central property, and the purchaser shall complete his part of the contract under this agreement on or before 31st December 2009, which is the payment of the remaining 5 crore 27 lakhs, and the vendor shall execute relevant deed of conveyance in favor of the purchaser or his nominees as the case may be. So, Your Honor, we believe that there were particular provisions to make sure that that particular debt that was owed to the purchaser was converted into an advance only because of the sale of the property that the company was doing to the director. Had the sale not been in place, that conversion would have not happened at all. And simply because of non-performance of the explicitly agreed terms within the agreement to sell, the director's advance of 3 crore was forfeited.
So this forfeiture clause is there in the agreement?
Yes, it was
Can you
forfeited.
please show it to me where it is?
With specific reference clause 12, we don't have the copy of the agreement to sell, Your Honor. That's something that was not provided to us, the entire copy of the agreement to sell.
No, that is okay, but the relevant portion of the forfeiture clause must be there somewhere. no?
Clause 12, Your Honor, it is part of the order itself.
It is part of the order. CIT appeals order, assessment order, or any document or correspondence wherein they have discussed that this particular forfeiture is as per the terms of the sale agreement, wherein it is mentioned that in case if there is impossibility of performance or if the particular contract not fructify, then what happens to the...
So I'd like to bring your attention, Your Honor, the fact that there are certain blanks that have been highlighted here. It is in the interest of time for confidentiality. We have not been given the exact names and the exact financial statements.
No, I am not asking about the name. I am just asking you to show me the relevant clause wherein it is mentioned that forfeiture is as per the agreement. See, the question would have been completely different if they wouldn't have questioned the validity
Madam,
of
that
the...
is, Your Honor, that is evidenced by the fact that there were no legal proceedings launched by the director against the company, because it was explicitly agreed within the agreement to sell that there is a forfeiture clause.
Then it should be shown to the court. See, the thing is, we are ultimate fact-finding body.
Right.
See, unless the particular fact is given to me, how will we appreciate your fact?
It is passed in the CIT order that clause 12 is the forfeiture. There are two clauses specifically, if I may bring them to your attention, Your
Show me
Honor.
from where CIT appeals order, whether is there any
I'm not sure it's part of this, Your Honor.
CIT appeals order.
The same para that we read out to you, Your Honor.
You told you have some extracts of sale agreement in the paper.
No, so this is the exact extract of the ATS, ma'am. This is the extract of the ATS that lays down the final date for the payment of the advance for the payment of the remaining amount of 5 crore 27 lakhs, failing which the amount will be forfeited. That is the extract.
Failing of which will amount to forfeiture of 3 crores. See, the total loan given was 3.77 crores. Out of which 3 crores was
Forfeited.
forfeited.
By mutual agreement.
Mutual agreement.
Yes.
77 is repaid.
Yes.
Repaid.
Yes.
That too after the sale.
Yes, Your Honor, it's well established that there is a conventional agreement. There are.
That conventional agreement, that is what lacking you to give favorable decision in your case. Otherwise, out there clearly.
Your Honor, if I may just clarify, that particular 77 lakhs that was returned was not initially part of the agreement. It is by mutual agreement between the director and the assessee. Once the amount was returned, once the amount of 77 lakh was returned, only an amount of 3 crore was forfeited against the advance. Only an amount of 3 crores was forfeited. Again, as per mutual agreement. It's not a unilateral forfeiture.
See, in this case, I have considered both the parties. And based on the documents that is produced before this court, see, we would be relying on Mahindra and Mahindra. 56-210 is not coming to your case. And the thing is, now you have if this particular document is the crucial document and which is as of now you certify that this is filed before lower authorities.
Yes.
However, the validity is to be checked and subject to consideration of Mahindra and Mahindra. I will be directing the assessing officer to take a note of the particular agreement and clause. In case if that clause specifically states that in case if there is a failure on the part of the vendor, that is the company, so then they can forfeit the money.
So there was
if that
process.
particular, yes, that is to be shown. Nobody, you have not given me the proof. It is filed before the authorities.
Your Honor,
Unless this
we are
is proved,
introducing these facts at this level. So the extract has been perused by the assessing officer.
That's what. That's why I am reminding this particular matter to the file of assessing officer to verify that this particular sale agreement which is entered into between the director of this particular appellant as well as the appellant company, and if there is a forfeiture clause, then in such scenario, this particular case is to be considered, and based on the verdict of the Supreme Court in Mahindra and Mahindra, this particular forfeiture is not to be taxed, but subject to verification of the agreement. If you would have furnished the particular document, you would have seen the validity of the particular document here only. We are tied up with
Your Honor, eventually, our contention is not that
it is done, it is all heard and pronounced.
Just
and the matter is sent back. See, we are not dismissing the case in the
Neither are we saying that it's not taxable. We are saying that it is taxable, but not in this assessment year.
Obviously, see, not in this assessment year, but to check the very crucial document that whether that particular clause is there or not. It is not produced before the court. How will we appreciate? So for that limited purpose, this particular matter is sent back to the file of assessing officer to verify this AR has to, it will be clearly mentioned in the order that they are subject to verification of the sale agreement, and considering the verdict given by the Mahindra and Mahindra, this particular fact is to be re-examined and then suitable action is to be taken by the assessor.
Given the fact that if the forfeiture clause is explicitly present in the
Yes, then you can demonstrate. No, very well
agreement,
demonstrate before the assessing officer stating that there is a failure on the part of the appellant company to hand over the particular property. It is heard and pronounced, so
I mean, it's part of the paperwork.
it's done. Now there is no point arguing. It will be sent back. See, it is ultimately there is no harm or damage. Department side also, it will be just one opportunity is given to the assessee only because they have relayed this case, they have presented this particular document before the lower authorities. If would have been an additional evidence, we would not have been considered, and we would have considered probably in a different manner. But they have submitted before the lower authorities, and considering that the very crucial point in this matter is the validity of the sale agreement. This entire issue revolves around that sale agreement. You would have produced the sale agreement, I would have given you the order.
Ma'am, but the DR is saying
Now
that
it is
in
all-
spite of the sale agreement, they are calling it a colorable device. So the question of the sale agreement.
See, they are doubting the colorable device means let them demonstrate, no, that feature
But they
is
have
there.
no basis for that.
No, let them know before the AO will consider that, and you demonstrate that these are the clauses available and this will support in support of your particular.
But that is not the case anyway, Your Honor. Fine, in your humble submission.
Yes. Sanjita and
Thank you, Your Honor.
is one more clear fact. I first
ITA number 1001, Bangalore 2022, 11 minus.
You got the copy? It is produced before the court and it is signed. Now they will proceed. Please go on. Yes.
So with your permission, my lord, may I start? We are representing the SSC. This is Naman, the AR representative, and this is co-counsel Parikshit Gurusar. Would like
Right?
With your permission, my lord, we would like to summarize the case. The appellant is a partnership firm, deals with the business of mining, which involves boulders, crushing the aggregates, and in the business of running goods vehicle on hire basis. The appellant has filed return of income for the assessment year 15-16, that is for previous year 14-15, with a total income of nil. After filing of re-return, the assessing officer has issued a notice dated 26 July 2016. For your reference, my lord, you can check the paper book, page number 16 and 17, the copy of notice. For limited scrutiny under CASS.
You have given me copy of Form 36. Appeal memo is given to me.
The documents were earlier produced.
Yes, in this.
It has been emphasized
No,
that the
where, which document you are saying?
paper book, page number
Paper
16.
book. Yes.
Notice page number 16.
Yes.
It has been emphasized that the notice has been issued for the limited scrutiny matter for the following issue. One is related to expenses related to related party mismatch and the other expenses in the profit and loss account matter. Instead of taking into consideration the following issue, the assessing officer has taken into consideration the conversion from limited scrutiny to complete scrutiny without following the procedure manual. So, the scrutiny took matter of depreciation matter, and they are claiming that the depreciation should be charged up to 15%, that is amounting to 32,21,924 matter. Aggrieved by the order and also passed the order stating that the Trinity Mines is not in the business of transportation. It is a normal transaction which involves transportation from mines to the vendor matter. Aggrieved by this order, the appellant has preferred to appeal before the Commission of Income Tax, which has been annexed for the Form 35 along with the payment charge. So even the learned commissioner has dismissed our appeal, stating that the assessing officer observed that the appellant has nowhere mentioned it as transportation business and therefore concluded that is a normal transportation activity under section 250 of the Income Tax Act 1961. And therefore the learned Commissioner of Income Tax, instead of quashing the assessment order, has erred in confirming the same, and therefore we would like to, the order has been passed being bad in law, and therefore we would like to appeal before the ITA, that is the Form 36. Now my lord, may I draw your attention to the notice?
Yes.
So for the both issue, that is payments related to related party mismatch and other expenses debited in the profit and loss account, the assessee has represented before the assessing officer in a letter dated 1st December 2017, page number 21 to 25.
Don't you think these other expenses claimed in P&L account should cover depreciation?
No, my lord, because depreciation has a separate note and a separate heading.
Can you demonstrate from your paper book and return of income file that how it is not part of other?
Yeah, sure. We can show to the income tax return of the appellant in form ITR 5 page number, which starts from page 65. May I draw your attention to page 72 of the paper book, my lord?
Yes.
Point 45. It has separate heading called depreciation and amortization.
Yes.
So it is clearly that it is a different expense, not the other expense in the profit and
And
loss.
other expenses where it is shown?
May I draw attention to the previous page, my lord?
Yes.
71 under 39 other expenses.
Yes.
So both the issue has been sent to the assessing officer with the relevant provision whether the expense is being mismatched or not, and even to the other expenses as well. But the assessing officer, regardless of consideration whether this issue has been resolved or not, they have taken consideration of depreciation, that is from limited scrutiny to complete scrutiny. For this, may I draw your attention to CBDT instruction, page number 18 of the paper book, which provide the procedure for conversion of limited scrutiny into the complete scrutiny.
Page number 18.
Yes, ma'am. Under para 3, point B, for the limited scrutiny, there has been a question under section 142, subsection 1 of the Act, which says that the item which has been remained confined only for the specific issues for which the case has been picked up for the scrutiny, my lord. Further, the scope of inquiry shall be restricted only to the limited scrutiny. If the assessing officer want to convert from limited to complete scrutiny, they have to take the approval of the Principal Commissioner of Income Tax or the Commissioner of Income Tax after following the procedure, my lord. But not following the procedure, they have converted the case. And addition to this, the CBDT has issued another instruction, page number 19, instruction number 5 to 2016, which states that there should be a reasonable view whether for converting this limited or to the complete scrutiny before the Commissioner of Income Tax. And based on the reasonable view, the Commissioner of Income Tax will decide whether on the merits of the cases whether to convert it or not. And even the assessing officer has to intimate all the related parties whether they are converting or not. And the assessing officer has failed to intimate to the assessee that the case has been converted from limited to complete scrutiny, my lord. And even the Act, section 119 of the Income Tax Act states that binding, which states that the board has issued, the board may from
Just a minute. Section 119.
Yes, my lord.
Yes.
It says that the board may from time to time issue such order, instruction and direction to other income tax authorities as it may seem deemed for the proper administration of this act, and such authorities and all other persons employed in the execution of this act shall observe and follow such order, instruction and direction of the board. And the other income tax authorities will include the assessing officer as well, my lord. So these all the instruction which is issued by the CBDT shall be binding on the assessing officer, my lord. And the Commissioner of Income Tax has ignored this fact that the case has been converted, has now taken into consideration or appeal, my lord. So next I would like to draw your attention to depreciation rule, new appendix, page number 64 of the paper book, my lord.
Just a minute.
Yes.
Page number?
64, ma'am. the new Appendix 1 effective from assessment year 2006 to 7 onwards. This is the rule which states about the table of rates at which depreciation is admissible for tangible asset manner. For the business of hire, the running of the goods vehicle is considered under the Part A, point 3, I second point, motor bus, motor lorries and motor taxis used in the business of running them on hire, which entitled for 30% depreciation by law. As per section 2, subsection 16 of the Motor Vehicle Act 1988, which states that heavy goods vehicle means any goods carriages the gross weight vehicle exceed 12,000 kg by law. In order to prove this weightage, may I draw your attention to the RC copies of the paper book, page number 29. Which states next to the model that the GVW gross weight of the vehicle is 25,000 kg by law. So this proves that the vehicle comes under the heavy goods vehicle and it is entitled for 30% of depreciation by law. The vehicle having contributed to substantial transport revenue. For this, is clearly a commercial exploitation of the vehicle, hence it is entitled for depreciation of a higher percentage, that is 30% by law, and not the 15%. For the merits of the case, my lord, my co-counsel will address the same.
With your due permission, if I may draw attention to page number 16, my lords.
60?
16. My lords, the scrutiny order clearly states that the scrutiny was invoked with respect to two aspects. One with regard to related party mismatch, the other one with respect to other expenses. My lords, as it is reiterated that depreciation is not covered under other expenses, the AO is not justified by taking up a matter which was not included in the limited scrutiny. For that, he should have converted the limited scrutiny into complete scrutiny by taking the prior consent of.
But anyway, he has addressed.
Right.
Now on merits.
On merits, I would like to read the judgment of Namit Lal C. Javeri versus KK and Sen. Case law compilation, page number.
Before that, you have to show me that these vehicles are used and they are utilized in hiring, running this.
Indeed, my lords, that will come up next. I have the
sample in transportation.
Indeed, my lords, I have that.
That you first demonstrate.
Okay. That's page number 26. Before starting this, I would like to give a brief of the transportation contract.
Yes.
The Sridhiti Mines had a contract for supply of materials with Ultratech Cements. That was only with respect to supply of materials. For the transportation, Ultratech Cement had given transportation contract to AIC Nani bulk carriers, who in turn had subcontracted that service to Sridhiti Mines. So basically, supply of materials and transportation are two independent activities. Although the person providing is the same party, they are two different entities.
Whether you directly, is there any framework wherein you directly transport your goods to the
vendor?
No?
No, my lords.
It is
through
through the
subcontract. Absolutely.
Directly you don't transport any material.
No, my lords, indeed not. Lords, sample invoices are next at page number 26 for your reference. Lords, the name specifically says AIC Nani bulk carriers. And the date is also very well within the previous year. There are 3 sample invoices in this regard.
Yes.
Lords, if I may draw your attention to page number 10 of the paper book. Para 5.5. The learned assessing officer has made the following observations. A. The assessee has failed to prove that it is into the business of transportation. Number 2. The assessee is only into mining business. Number 3. The transportation of goods from quarry site to place of delivery is an ordinary activity and carried on during the process of business. Notice to prove this wrong, I have annexed the RC copies in page number 29. Notice you can see the date of registration, page number 29.
In 2014.
Yes, ma'am. It's very well within the limits of previous year, 1450. And with effect from 1450, the SSC had started that particular business of mining. I'm sorry, not sorry, transportation. For this specific purpose, he had purchased 10 heavy vehicle duties. The RC copies are attached at 29, from 29 to 49. All 10 RC copies along with insurance has been annexed. With regard to the transportation being not an ordinary activity, I would like to state that out of total turnover of 18 crores, around 1.8 crores turnover is from this high transportation business, which is roughly around 10% of the turnover, which is in no way insignificant amount. It is a substantial amount. It cannot be construed as an ordinary activity. It is a distinct and specific activity. To do that, yes, ma'am. Yeah. That's page number 69. Total turnover breakup is given as sale of goods and other direct income. Other direct income here has to be construed as revenue from transportation business. If you may see point number 1.
This is IPR copy.
Yes,
P&L account is given?
No, it's for some reason finance is not.
Yes.
Yes, ma'am. Point number 1.
In your submissions, somewhere you would have given the
Yes, ma'am. That's there. Page number.
this amount as transportation.
Yes, ma'am. Page number 1. Para 1.3.
Yes.
The appellant's last but one line. The appellant's turnover from sale of aggregates was rupees 16 crore 31 lakhs 69,578, and that of the transportation business was 1 crore 79 lakh 56,911. Around 10% of the turnover is from this transportation business. So this cannot be construed as a ordinary business activity. It's a distinct activity. Notes I would like to give one reference of Commissioner of Income Tax versus AM Constructions, dated page number 24 of the case law compilation. 23. But the relevant extract is highlighted on this.
Yes.
Notes I would like to give a brief facts of the case. The facts of the case are very much in line with the current case. The SSC was into business of providing civil contracts. Also, it was into the business of agricultural produce. It had purchased some 5 vehicles for the purpose of agriculture, which was also used for the purpose of transportation. But since the majority of income was coming from the transportation business, the CIT was of the view that the SSC should be given benefit of higher rate of depreciation. Since Section 32 does not specifically mention the usage of the asset should be specifically for the purpose of hiring. There is no word that there is nothing that says in the Act that only if the asset is used specifically for the purpose of mining, then for the purpose of hiring, then only higher rate is applicable. Even if it is partly used for the purpose of hiring and partly for the purpose of mining, the benefit of higher depreciation should be given or not. As per this judgment, I would like to give the extracts, page number 24. Last but one para, the relevant extracts are highlighted. The finding of this tribunal is that substantial income of the SC is from hiring of these papers.
It's not highlighted.
No, it's the other copies. It's submitted to additional. No. Page number 24, last but one para.
Section 32 of the Income Tax Act.
Not exactly.
Yes, submitted. Case completed.
Case law compilation.
They submitted along with the form 35.
Form 35.
Yes.
Case number 24. May I read out?
Yeah, from this only you read out that. Start from the first line of the paragraph so that I will get to from there.
The finding of the tribunal is that the substantial income of the assessee from hiring of these slippers, he would be entitled to depreciation at 40%, notwithstanding the fact that he uses them for the agricultural operations also. Further, sub-item 2, clause 2 of item 3 of appendix 1 does not say that the motor lorry should be exclusively used for the hire or business by assessee.
But this is not your case, right? That in your case, so you are obviously exclusively using it for transportation only.
No, madam.
In your case?
Yes, madam. It is used for mining as well as hiring.
Mining also?
Yes, madam.
When I asked you that you don't transport directly, you said that it is not done.
Correct,
It
madam.
is not
Absolutely.
directly.
It is not a direct contract between me and my customer.
Huh.
It is routed to a subcontractor.
No, that is fine. See, thing is now, here, this particular vehicle is used, plant property, is used for agricultural as well as hiring purposes. So in your case, it is mining and hiring.
Absolutely.
Okay, transportation.
Absolutely.
So when I asked you that this particular motor vehicle is not direct, you are not directly using these vehicles for transporting your mines to the buyer. So you said no, it is only through the contract you use these vehicles. So that means exclusively you are using these vehicles only for the purposes of transportation. Huh. Got it?
Got the point? When the vehicles are filled, but they are also used for the purpose of transporting, value.
Okay.
Both the purposes it is used for.
Thank you, sir. Yes.
Lords, I would like to conclude that the action of the EO is not justifiable, and since it is bad enough.
Yes.
The income order should be quashed or the disable amount shall be deleted, madam.
Yeah, represent for the department. Your Honor, I would request you to look into the page number 19 of the form 36, which
Produced not?
no, produced already. The learned counsel of form
Form 36? Yes.
where they have attached the CAT order also. Page number 9.
Yes.
I would like to read out the findings of the EO, Commissioner of.
See, first you address the technical
Yeah,
reason on the this conversion of limited scrutiny into complete scrutiny.
I'm coming there.
Yes.
My lord, in page para number 5, the CAT appeals says, therefore,
Para number 5. Page? Para number 5 or page number 5?
para number
Yes.
I'm reading only crux of the findings.
From where? From where? Which line?
Uh,
It is not highlighted yet. So
line number 5 from the bottom line.
Therefore, the asking officer
Yeah. Therefore, asking officer after considering the explanation to the show cause notice issued during the course of scrutiny has restricted the depreciation at the rate 15% rather than 30% favored by the appellant. As there is no infirmity found in the issued order, as the asking officer has followed all the norms in pointing out the wrong claim, even it is covered under the limited scrutiny proceedings. Your Lord. Your Lord, I would like request to say that the limited scrutiny was not converted to complete scrutiny, as the depreciation is covered under other expenses.
Now you have to show me. See, now the AR has demonstrated with the return of income that there is a separate rate for depreciation, and this particular depreciation is not covered under other expenses. Now, they have shown the 143(2) notice also, wherein there are only 2 grounds on which they have initiated this particular scrutiny. So now you have to demonstrate that how we are going to review these two.
Your Lord, I request to say that the procedural law is always subservient to substantive law. Here, taking approval from CIT, principal CIT or the CIT is procedural law, where the dissolving the depreciation, higher depreciation which is claimed at 30% is substantive law. Also, Your Honor, the function of procedural law is support to the substantive law, that is provide justice to the substantive law, not to alter or delete the main objective of the substantive law. Also, Your Honor,
making the addition in the substantive law and not following the procedure which is laid down under the law is procedural in nature.
No, Your Lord, there are various case laws where the courts have been liberal in case of the assessees, where they have delayed in filing forms or not filed the forms and they have given the deduction or exemption. When the courts are liberal to the assessee, why so stringent on the department?
It's not about liberally or stringent. It's about the compliance of the procedure which is laid down under the Act. If the law envisages a situation where limited scrutiny is there and there is a complete scrutiny, so that means that the law itself bifurcates 2 types of scrutiny. If there is no bifurcation, we can understand that okay, they have given the powers to initiate the proceedings and they can check anything under the scrutiny. Initially it was like that only. This concept of limited scrutiny and complete scrutiny has been introduced recently. It was not again. So now, having initiated, having brought into the statute the concept of limited scrutiny and complete scrutiny, don't you think the department should follow? And there is a guideline, there is a circular. How do you justify that this particular circular is not binding on the department? Circulars are binding in nature on the department, not to the assistant. And these circulars are issued by the board, stating that there is a procedural formality that you have to seek in case if you see. The law is not prohibiting completely the department not to consider any particular issue, not to convert limited into complete. There is a procedure for that. You have to get the earlier approval, whether that is sought out, whether that particular approval is sought out.
No approval.
No approval, right? So, and moreover, this particular, see, the basic issue is other expenses. Whether this depreciation is part of other expenses or not is the question. So, if depreciation is not part of other expenses, then this particular depreciation is not covered under the limited expenses. So, department is not having any jurisdiction to verify whether the claim of depreciation is right or wrong. So, to that extent, this becomes jurisdictional issue. See, 143(2) notice itself it's a mandatory notice without which department cannot proceed further. So, unless this particular 143(2) notice is not proper, not served, the entire assessment becomes becomes bad in law. This is how the courts have held, and this is almost a settled principle. If you go to the Supreme Court in Hotel Moot also, in case if it is not, service is not wrong. Here, the initiation itself is with respect to limitation, and it is something, it is beyond the scope of limited scrutiny. So, approval is not said that you are accepting. That there is no specific approval to convert the limited scrutiny into complete scrutiny. Now, this particular issue, it's on merits you are. Is there any case law that you are referring to or relying upon to state that this particular limited scrutiny can be, if the issue is selected under limited scrutiny and you can verify any issue without seeking approval from the higher authority? Is there any such case law? No?
Case relates on section 292
What about, see, 292 BB is only with respect to irregularities in the law. This particular concept of this limited scrutiny into complete scrutiny gets into the very jurisdictional defect. And jurisdictional defects cannot be cured under 292. We will consider your argument, but conversion of limited into complete scrutiny is not a procedural lapse. It goes into the root of jurisdiction. So jurisdictional lacuna cannot be cured under 292. On merits.
With your permission?
Yes.
As mentioned earlier, the AO on verification of records as a whole, he considered depreciation into other expenses as a whole. So they got to know that the depreciation has been claimed higher depreciation at the rate 30%, other than, not under 15%, which is wrongly claimed. Actually, the AO observed that the assessee, the dominant activity of the assessee is into mining activities, not under transportation of goods, on hiring or leasing of vehicles. There is no evidence, there is no mention in his objectives that it has transportation business, even in partnership deal, and there are no contrary collaborative evidences that they have submitted to the land assessing officer regarding the transport business of hiring or leasing of vehicles.
The invoices and all is furnished before the authorities.
Yes, ma'am. In letter number 1 dated first of
invoices are furnished, but there is no document regarding contract where they are.
the invoice itself proves that it's a based on contract and raised.
There is no specific contract with respect to contract cement and this schedule mentioned. All the transactions are carried at fair market value at arm's length transaction.
And through the Ali Singhani,
it is subject to the subcontractor Ali Singhani.
Yes, you proceed.
Your Honor, I would like to bring your notice to page number 58 of the paper.
15.
58.
Yes.
Para number 3, which says the objective of the partnership. The partnership business shall be that of quarrying, processing the quarried material, erecting stone, crushing units, processing jelly stones, crushing of stones for buildings, manufacturing of hollow bricks, and such other allied activities as may be mutually agreed and decided by the partners from time to time. But given the substantial amount, Your Honor, there is no agreement. There is no subcontract which the learned counsel or the appellant during the submissions are not provided any agreement, Your Honor, between the subcontractor and the assessee to prove that there was an agreement. There is actually a business of transportation, Your Honor. So we say that there is no transportation business only. It is in the course of ordinance of business where the mining was after quarrying of stone. The materials were transported from the mining site to the customer site directly. There is no transportation activity.
Without transportation.
No, transportation activity presents. There is no separate contract for transportation activity to claim the higher realization. Hiring of.
If that is the case, then in the sale invoice itself, the transportation charges would have been included. Is that so? See, usually what happens when we sell the goods and the transportation is borne or directly provided by the vendor, then why we will be give separate two bills? He will be adding transportation charges in the invoice itself and he will be charging gross sum. So, but this is not the case in their case. There is separate invoice with respect to transportation and there is a substantial revenue. What about that? There is a revenue that is almost 10% of the total revenue is from the transportation.
Yes, Your Honor, but in ITR form also there is a heading called direct income.
Yes.
There is no separate heading called transportation income. Also in the invoices which they have provided, there is no mention of kilometers, Your Honor. Only the quantity is mentioned. There is no mention of kilometers. How many kilometers the vehicle have traveled.
Anything else?
Even in the ITR, my lord, the nature of business is manufacturing industry, not into anything mentioned as transportation or hiring of or leasing of vehicles. So the dominant activity is mining, manufacturing, mining activities. So here the appellant, the SICASA, failed to furnish that they were actually into transportation of hiring or leasing of goods. So the higher depreciation which they are paying at the rate of 30% should be at the rate of 15%, which amounts to 32,21,924 rupees. So the excess depreciation should be discounted.
Also, Your Lord, I would like to request your continuation or something. They are provided in the RC form. Yeah, Your Honor. Yes, Your Lord.
Yes.
Your Lord, page number 29, 30, 31 have the similar kind of asking office where the body type is tipper. But coming to page number 35, Your Honor, the body type is wrong.
Body type is?
Wrong. So all the 10 vehicles are not of similar kind, Your Honor. If the vehicles are used, maybe the tipper vehicles may be used for transportation, but not the other 7 vehicles which body type is wrong.
For the
That's
issue,
it. From your end, this is your argument. Is there anything that you want to say? Then I will tell them to counter argument.
My lord, I would like to draw your attention towards case of complaint. Page number 5.
Case law compilation
Page number
submitted by the applicant.
Your Honor, submitted by the department. That is not here. No, Your Honor. Yes, sir.
Yes.
Page number 5.
Yes.
Here the findings are, to summarize this, when the higher rate of depreciation can be claimed when the assessee is wholly into transportation of business on hire or leasing basis. When they fail to furnish that they were actually into hiring or leasing of vehicles, transportation business, then higher depreciation cannot be claimed. Only 15% depreciation can be claimed. Then the excess depreciation should be designated.
Yeah.
yes, ma'am. For the first issue, they have raised that we are in the nature of mining business and not in the transportation business. For that, my lord, may I draw your attention to paper book filed by the appellant, page number 69.
You can say
Part A,
69.
yes, Part A P&L. The revenue from operation is one from sale of wood, that is from mining business, and the other operating revenue, specify nature and amount. For filing ITR, my lord, will be filed, and in the PDF it has not been reflected, my lord.
No, that is not the issue. You just address this.
It has been specified in the ITR, my lord, that it is in the transportation of higher goods.
Lords, the baseline is to be able to claim depreciation under Income Tax Act. The question is not whether the asset is yielding substantial income or not, and not with respect to partnership deed. The only condition is that the asset should be put to use in the previous year. It is more than when it is full or half. But the question raised by the DR is whether the substantial income is needed from the asset or not. And there is nothing mentioned in the partnership deed about the hiring business. So as per Income Tax Act, my lords, there is no condition to claim depreciation asset. So this intention of EO being not justifiable, the impugned order is liable to be classified.
And regarding to procedural law, my lord, procedural law is a law which provides methods of aiding and protecting the rights of the act. Both procedural and substantial laws should coexist. That is, both cannot exist without the help of each other. Without following procedural, they cannot follow the substantial law, my lord. So for that, we would like that the impugned order be quashed, or at least an amount which is disallowed be deleted, my lord.
I have heard the arguments of both the sides, and see, the issue involved in this particular matter is with respect to technical as well as on merits. So, the very first thing, on technical ground itself, the department has not followed the procedure by getting the prior approval from the higher authority. So the assumption of jurisdiction itself fails. When the assumption itself fails, there is no question of going further on to the merits and then deciding the issue on merits. Whether there is any transportation vehicle, whether they are into hiring, transportation, higher rate of depreciation, 15%, 30%, all this becomes redundant because the very valid jurisdiction itself is not there. Then the department cannot even go further. So the department DR has accepted that there is no prior approval. That it is accepted from the records. It is very much clear that there is no prior approval sought to convert the limited scrutiny into complete scrutiny. And the AR from the paper book has demonstrated that depreciation is a separate column in the return of income which is not forming part of the other expenses. Considering this particular issue, I will decide this particular, in this particular case, the assessment order itself needs to be questioned and no judgment on merit should be given. The moment the assessment order itself is quashed, there is no need of giving any decision on merit. Whether it is 50%, 30%, all those. So that way, in this particular case, the assessment itself is quashed, stating that there is no jurisdiction, there is no proper jurisdiction, and 292 will not come to the rescue of the department because there is a jurisdictional lacking. And jurisdictional defects cannot be cured in that 292.
registered for the business of the
You want to take a break?
No.
So please.
But I have to complete my sheet also.
That is okay. Oh, evaluations.
I'll finish that and probably if given the time I would like to give comments on group wise. Is it possible?
Yes, please.
represent before the higher forum, and you people have done a wonderful job. I'm extremely happy and proud of all of them. All are true winners. I must tell you that the facts of the case, the way you have presented, the confidential level, confidence level, everything is amazing. You all true winners for me. For you, big round of applause. And mentors also, they have done wonderful job. They have provided all the documents. Here, shortcomings are there in the preparation of paper book and all. That is okay. Over a period of time, everyone will learn the thing. Otherwise, the oral arguments were really amazing. Very good. So the thing is now, with respect to each one of you, everyone is having one quality. See, suppose if you take the first case, in that case, DR pointed out some cases, some defects. However, those defects were very much there in the other cases also, but none of the DRs have noticed that. So that will add on to that particular thing that they have noticed that point and brought to the notice of the tribunal. Usually in tribunal what happens, unless the defects are cured, it will not be posted for hearing. But this is a moot court. See, we appreciate that people have taken so much strain and so much effort to present the paper, and up to this level is commendable. So that is one thing. And here and there, in all the cases, none of the papers were signed. In all the cases I have gone through. But it's okay, absolutely, it is all procedural. It is not jurisdictional defect. So it can be cured, no problem, not an issue. So that way, that is fine. And the first case, they got time. They are very smart enough. They are very smart. In first case, they took Passover. So they know how to, they have now probably got that, how to present, and they are actually finished the argument well within the time. So exactly within 30 minutes, right? 20 minutes. So they have completed their argument, and it was through. In case of second thing, that was with respect to this ESI and PF, right? You people have done, especially AR, have done very well. And having this Supreme Court decision against your face, against you, you have secured one partial relief in that. That is very much commendable. That way, because of the Supreme Court decision, I should outright dismiss the case. But you have brought the distinguishable point, and you have observed that minute point stating that one payment, whether it is 1 rupee or 1 lakh, it doesn't matter. When you are arguing the matter before the forum, so you should see to it that at the last breath also you should see that some relief, something you should get. You should not accept the failure. Usually what happens, no, if Supreme Court is against me, what I will do because this is law of the land. See, usually we think like that. So this is not the way. They have done very well. So that is commendable thing. And with the Rakesh and Moot also, they have done very well. Yeah, you have relied on Supreme Court decision and all. But only thing is, you said you have not relied on jurisdictional case law. However, you have relied all these sub-enterprises, sub-enterprises. Alum extrusion was Supreme Court decision which was in our favor. We used to take the shelter of alum extrusion and we used to get this benefit. In fact, in tribunal, I have fought some 50 cases and I got 50 cases through in assessee's favor. Now everything will go and they will reverse the entire thing. Probably they will pass rectification orders and everything will obviously get reversed. So this is how it is. The third case, that is with respect to this capital gains, right? Third case is of Silver Tree and Sai. Or yes. In your case, the only problem is that timing. Otherwise, you have tried. In fact, you have taken more time. Because you have taken more time, DR could not even, one guy, I think he could not even open his note. I am so sorry for you. But I have somehow considered. It's not like that. given the chance, I would like to hear him. Probably after the court, I will meet you personally, and I just want to hear your argument. So it should not be fair if I don't hear you. Otherwise, it is fine. The only thing we see, that's what. See, law itself visualizes that the time frame is 3 years, and you have to stick to that particular time frame. So that is the thing. Otherwise, you people have done very well. Only one thing is, please don't read from the synopsis. Don't read. You are here to argue. There is a line of argument, and it is like something like what happens. No? If you read the thing, there is a one line. There is the way you think is in one proper direction. And usually in court proceedings, what these judges and they just simply say, read this, read that. In fact, you will not be getting time like this. Probably 2 minutes, 3 minutes. In some cases, they grant you 2 minutes, 1 second, probably half a minute, and they just say you're done. They are that particular. They have that temperament, and you should always see that whether the judge, how he is, whether he is calm, composed, whether I should take up my case or not before him. That all that matters. If you know that his mood is not good, then it's always advisable to take adjournment and leave. It is always leave in the court, because I will be always sitting in your place, and this is the first time I am sitting this side. So I can understand, and I am telling you that you should see the temperament and mood of the judges, and ultimately because they are the person who will appreciate the facts. If they are disturbed, then obviously there is no point in how much ever you convey, they may not be appreciating the things. So that is how it is. So this is the thing. And third case is of Silvershri and Sahi Vinay, Isha Thakkar and Rohi. Oh, done. The fourth case is Sanjita and Shravya. And Kreshanu Paul and Sahana Lokesh. Kreshanu, you have done wonderful job. I must admire the way you presented the case. Is commendable. In his only body language, and he has not seen. We usually make points when we argue before the court. Obviously, we will make points. Which case number, what is the which para number, and all that we do. But we don't see. There will be a synopsis that we find, but we don't read out from that. So don't keep that habit of reading. It is something like you are giving one paper and you are reading. That obviously judge can do. Obviously, reading part he can do. Okay? So you have to keep a very concise, to the point argument. And only thing is, in your case, you are very good, but ultimately, once the decision is pronounced, you should not argue before that. Because this is a moot court proceedings, I am just giving me my inputs, giving you all my inputs. That please don't argue before the forum. Once the case is heard, after that you have no right. In fact, once your turn is over, you are not supposed to talk, because then TR's turn comes. So then they should be given proper opportunity of hearing and all. So that way, that is fine. The only thing that in your case was the weak point is not producing that same. You should have provided, probably the matter would have been different. Instead of sending it back, probably you would have got some benefit, but now also nothing happened. And DR, Shilpa Shri and Sahi, very good. The Sahi, so sorry. Sanjita and Shravya, right? So sorry. Sanjita and Shravya really very good. In fact, you also argued very well the way you presented the matter, especially the core points which you have highlighted. The critical issues that you have noticed, that these are the points which will make that particular agreement as tolerable devices absolutely amazing, and I appreciate your efforts in this particular. I am extremely happy, and at the outset I would like to thank SICASA for initiating such a noble and such a great, probably
first time is always special and precious. For SICASA also it is first time. For me also as a judge and as ICI, I have never presented or I have not in fact stepped onto this podium as some guest. This is for me also, this is first time. I think for you people also it is first time. So that way first time is always special and we should cherish and relish this particular thing. And being in this profession, especially into litigation representation, I feel that this is very fascinating and very interesting field. Only thing is don't take things for granted. Please put your efforts. Please try to make it. Don't accept failure. Try in the last moment. If you find something, obviously for that I should appreciate team 2, right? Team 2 for this. So that way I am extremely honored and delighted that I am a part of this wonderful platform so that I can get the opportunity to interact with you all. And thank you very much SICASA and Bangalore branch for inviting me and giving me this honor. I am extremely honored. One more thing, usually in tribunal there will be 2-member bench and there is a limit that we have not checked. The assessed income should be 50 lakhs. So if it is below 50 lakhs, then only you can argue before the single-member bench. If the assessed income is more than 50 lakhs, then divisional bench will say. Then there will be an accountant member and the judicial member. So here we have not seen all that, but the way it is done is really commendable and I am very happy for all of you. Thank you, SICASA. For me, all the winners only this just a formality that it is cast on me that I have to announce. So there are 2 prizes. So first runner-up would be Parikshit and Gaurav and Navani. Because it was passed over, even your comments got passed over. I will tell you why, because see the thing is, you people were very much prepared. If I asked you any question, you were ready with the answer. You were very much into the subject and your facts were very strong. And the way you have presented was very nice. So that way you scored the prize. So in fact, in your case, you got the order passed. That means the entire order itself got passed. So that way, you are the runner-up.
I request all the MC members, Sridham, Pramod, Srinivas, and Madhya. Give it up for
Parikshit and Gaurav. Gururaj.
Give it up for Parikshit and Gururaj.
Come forward.
Yes, please. All the mentors. All the mentors, please.
I request all the mentors to come on.
We have an Indian energetic team there.
Only because of their efforts they could perform
Yes.
so well.
Yes.
A big round of applause to all the executives.
Yes. Winners are, any guesses? Sanjita and Shravya.
Thank you so much, C.S. Sumal Lankar. Thanks for coming and thanks for presentation. I would like to a small token of gratitude from our side.
And the mentors.
A big round of applause for Siddesh sir.
Over to your priority sequence, please. Yeah, upside down. Shared this idea of Moot code and he said, yeah, we'll do. That's all, nothing. He didn't listen to me fully, but he said, we'll do. So thank you. We have some moments for all the participants. Please. Call out the names.
I would request Parikshit,
Parikshit or no,
Charan Kumar M and Bhavana M. A big round of applause.
Both of you have.
I request Bhavna KS and Hasta stay. Rakesh and Sumu. Shilpa Sri and Sain. Shilpa Sri and Sain. Ishtakhar and Roshni. Krishan Kaur and Sahna Lokesh. I would request everyone to applaud.
Saman has a known face, very well known face. A lot of activities. ಜಾಸ್ತಿ ಮಾತಾಡಿದವರು.
I request all the winners and runners to come out together for a grouping. Winners and runners has to run out.
Come, ma'am. Come.
Anyway, morning you were there with us. Yes. One friend. Why do the students not friends? You not That's fine. Kneel down now, maybe.
Only this side and that side.
No.
That's the punishment for winners. Says.
Thank you all. Thank you.
To extend my warm gratitude to the bench members, PAs, non-municipal and all the mentors all the participants, all the audience who are staying from morning to evening and facing the event and making it successful. I request all the students to be seated. There is an announcement. There is an important announcement coming. So I request all the students, mentors, MC members, everyone to be seated. How is the competition? All the students? How is the competition?
Amazing.
How is the mood course? So would you be interested to participate if there is one more mood course?
Absolutely.
We give other participants opportunity. And why same people?
If no other participants there. Okay. Everyone are listening. So as you all know, we are conducting a national conference in December month. It will be held on 16th and 17th of December. That is Friday and Saturday. So I request all the participants who are interested to participate to give their paper presentation, or to be the MC, or to be the volunteer, to register your name with us, any of the SICASA committee members. Here I am the part of committee. Nagaraj, Bhavana, Harshita, and many other people are there. You can register your name with us, and you can get an opportunity. Opportunity of showing your talent.